Honorable Sangon, good morning.
Good morning, Chairperson. Good morning, honorable members. Good morning, colleagues.
Good morning, Honorable Nhlanhla.
Good morning, Chair.
Honorable Sokanyile.
Morning, Chairperson.
Honorable Nombal.
Morning, Chair.
Honorable Skosana.
Ngiyakulochisa mgcinisihlalo ngilochisa lesitshaba namalunga weParliament ephezulu. Ngiyathokoza.
Honorable Mattheys.
Good morning, Chair.
Honorable Sols.
Good morning, Chairperson.
Honorable Chopper.
Good morning, Chair.
Honorable Vessels.
Good morning, Chair.
Advocate RNC, good morning.
Good morning, Honorable Chair, Honorable members, and all those present, Mr. Mashuga and his team. My colleagues are both busy with other witnesses. If they may be excused, Honorable Chair.
Okay. Good morning to our witness, Advocate Mashuga. You are extreme right. Right, extreme right.
Good morning, Chairperson. Thank you.
Is it Mashuga or Mashuga?
Shuha.
Okay. And Advocate Maka, good morning.
Good morning, Chairperson, and good morning to the honorable members of the committee. Thank you.
And pass our regards to your colleague and introduce him.
Good morning, Chair. Good morning, members of the committee. My name is Apla. My surname is Bodlani. Thank you.
What's her name?
Bodlani, Bodlani.
Oh, Botlane. Okay. Mr. Chetty, good morning. Mr. Chetty, good morning.
Morning.
Thank you so much. Good morning to the staff of Parliament. Mr. Tejana. Dr. Tulia.
Good morning, Chair.
Mr. Pilot Kwebu, good morning. Honorable Kola Barnard, good morning.
Good morning to you, Chair.
Thank you so much. The staff of the political caucuses in the National Assembly, good morning to you. Thank you so much. Do we have apologies, honorable members? Can we start with the African National Congress?
Thank you very much, Honorable Chairperson. We've got an apology from the Chief Whip. He will join us during some time in the day. He's engaged at the Chiefs Forum. Thank you.
Okay. MKP.
Thank you, Chair. Honorable Shonge will join us later at lunchtime.
The DA.
Thank you, Chairperson. I think you have received the apology from Honorable Breitenbach. And Honorable Cameron is chairing a meeting now. He may be finished by lunchtime and will then join us. And I have to leave for about half an hour, just before 1 o'clock, but I will come straight back. Thank you, Chair.
What is the apology of Honorable Breitenbach?
She has had to fly to Johannesburg, I believe. I'm not sure which province, but she
will
was
not be able
needed
to-
urgently there. I beg your pardon?
She will not be able to join today's.
She will not be
proceeding.
able to attend at all for the rest of the week. Thank you.
And then when you say you have to leave, where are you going?
I have another parliamentary commitment for half an hour on another committee.
Thank you so much. Any apologies, Honorable Sols?
No apologies, Chair.
Honorable Vessels?
Thank you, Chairperson. I'll just have to step out at 12:30 for a Manco meeting, and then I have a meeting with the House Chairperson Frolic at 1:30. And then this evening, I'll see, but I might have to attend the joint committee on financial management of Parliament. Thank you, Chair.
Okay. The committee which I'm the co-chairperson. Okay. Yeah, we have a meeting tonight. Do we have the apology from Honorable James Wanani? Okay. Honorable Mwango is also here just by the door. He's concluding another commitment. Before we start, this morning we woke up to the sad news of the passing away of the former member of this Parliament, both the National Assembly and the National Council of Provinces, Musiwa Teralokota, a former leader of the United Democratic Front, a former leader of the African National Congress in the Free State and former premier, the inaugural premier of the Free State Province, and former chairperson of the National Council of Provinces, the former national chairperson of the ANC, and the former member of this National Assembly, and the leader of the Congress of the People. Can we rotate political parties to express short messages of condolences to the family?
Thank you. Thank you very much, Honorable Chairperson. On behalf of the African National Congress, we'd like to express our sincere condolences to the family of Comrade Teralokota. We also extend condolences to his party, the Congress of the People. I think as the ANC, we will always hold Mr. Lekota in very high regard for the role he played, not only in the African National Congress, but also in the struggle for the liberation of Blacks in general, Africans in particular of this country. So we mourn with them and wish them strength during this difficult time of bereavement. Thank you, Chair.
The MKP.
No, thank you very much, Chair. We wish to convey our deepest condolences to the Lekota family and to his political family, Congress of the People. Those who speak well usually say there's only one day we do not know, and usuku lokuhamba emhlabeni. So we are saying God has taken what belongs to him. Abalale ngenxeba, alihlanga lungehlanga. Thank you very much.
Honorable Kola Barnett.
Thank you, Chairperson. Yes, I served along at the same period as Monsieur Lekota. I've been here since 2004, and I have had the deepest respect for him, having heard, sorry, Chair, having heard his speeches on the podium. He was at times positively presidential. And I think a man who will be greatly missed. He's missed in Parliament. He's greatly missed, I am sure, by his family. And I proffer our deepest condolences. I literally have marched alongside him for the protection of farmers and the like. I've got to know him extremely well. And I think he will be greatly missed, and my deepest condolences to his family. Thank you.
Honorable Matthys.
Thank you, Chair. And on behalf of the Economic Freedom Fighters, we do send our revolutionary condolences to a freedom fighter and someone that has also spent a large part of his life in prison and on Robben Island. And we appreciate his contribution that has brought us all here to be able to sit here in Parliament. And may his spirit live on and in us, his fighting spirit. Thank you, Chair.
Honorable Swals.
Thank you, Chairperson. On behalf of our President, His Excellency Gayton McKenzie, our Deputy President, the Honorable Kenny Kunene, the entire Patriotic Alliance South Africa, we want to extend our deepest and sincerest condolences to the Lekota family, and want to share a scripture that says, "Blessed are those who mourn, for they shall be comforted." So may God comfort the family. And like we say in our communities, Resach Rodman. Salute.
Honorable Vessels.
Thank you, Chairperson. Also on behalf of the Freedom Front Plus, I wish to convey our deepest and sincerest condolences with the family of Mr. Lekota, also with his friends and with his political colleagues in the Congress of the People, COPE, which he started. I think that Chair, one could have differed from him, but there's one thing that nobody can deny, and that is that Mr. Lekota always treated everybody with respect, and that he made a huge contribution to South Africa, to democracy, and also to opposition politics in South Africa. He started an initiative called, which was called at that stage, the Collective for Democracy, where myself and him worked closely together in 2012, 2013, around that time. And I got to know him quite well, and yeah, our deepest condolences. He made a huge contribution and he will be missed. Thank you, Chair.
Honorable members, thank you so much for your commiserations with the family on their loss. I hope that they are following these proceedings, or a relative or a neighbor is hearing your commiserations, and they will be able to pass them on to the family. Indeed, it's true, Honorable Nomvalo, what you said in Sesotho, Atlala ipya madiba, ago madiba a sa phiego, leshoka le setlefala re lebeletse. Honorable Skosana will help to give you to give you the context. Yeah, he will give you the transcript. Mr. Ramano, you said when you gave the apology of Honorable James, your microphone was not on, and that might not have gone into the record. Can we please make sure that it goes onto the record?
Thank you, Chair. The apology is that she is currently in another meeting and she will join us as soon as she's done in that other committee. Thank you, Chair.
Thank you so much. Your hand is up, Honorable Skosana.
Thank you, Chair. I'm sorry, it's just I have to raise this, and I think it's the right platform, or perhaps others will say it's the wrong platform. Chair, our co-committee, for me, I'm not happy for, but all these excuses which are made here, all these apologies. Because if we all apologize, Chair, because we've got co-committee meetings as well, but we are here. It is unacceptable. I mean, people knows that we have an ad hoc committee here. Now, if they don't want to participate, let's close this thing and go back to our committees. Because for me, it's shocking. It's shocking, really. Every day, people are having meetings. I have to leave. I have to do that. It's unacceptable, Chair. It's not fair for you to chair a committee which is dysfunctional.
Yeah.
You know, but really, because you can imagine all these members, if we all have to send you apologies, what's going to happen to this committee? And we have the last extension now. We know that there's other issues. People should delegate on other issues. Hence, we have alternative members. Even if you are a chair, you said you are a co-chair in another committee, but we are here. Now, if one has to say, what am I going to prioritize? I'll say I'm going to SCOPA. or I'm going to international relation. It's not fair. It's not fair for South Africans. It's not fair for us as members as well. That we have to be here to form a quorum. Now we have to count ourselves. How many are we? Because we can do the same thing. We can lobby Honorable Nhlanhla and Sangoni and say, and Mateis, and say, let's not come. Let's make an excuse and go to our committees. It's not fair, Chair. My last point was, I thought yesterday, Chair, we said we're going to start with the public participation because I think we're going to need a lot of time with the advocate. Masha, but I'm not sure whether that has changed because we said maybe, if I remember well, I might be wrong, maybe we'll have a public participation until lunchtime because there's no leading evidence. I think he's going to present himself. You heard, I'm not sure whether Mr. Chetty or is the, yeah, or whoever, you know, but I don't know. It's your discretion, but I thought that's going to be like that because the last time we had somebody here waiting for hours and hours. You know, maybe it's not going to take time. I don't know, but we are under your leadership. Thank you, Chair.
It's not my discretion. The chair executes the committee's decisions. My understanding is your understanding, Honorable Skosana. I think the legal team will lead us. We said that Advocate Mashucha, we are going to start with Mr. Chetty. There is nothing wrong with you sitting together there. He will just come and sit there and make a presentation for about 45 minutes to 1 hour. And the committee will determine how it moves forward with his presentation. Is how we agreed yesterday. Immediately after his presentation is going to be you. But it does not mean you must move. You just sit there. That is the code of good neighborliness. Honorable Sols, do you have a point you want to raise? Yes, the floor is yours, Honorable Member.
Thank you very much, Chairperson. Chair, I'm a bit concerned. Already, you know that I have an issue with the restricted time allocated to us when we have to question witnesses. Now, of course, we have now decided that, you know, we're going to stick to the time that you give us, which I understand, and we go through that. But when we are restricted in that way, and we are allowed another opportunity to ask a question or get clarity, we should be allowed to finish that. And I'll tell you why, Chairperson. Yesterday, with a general that was here as our witness, on the opportunity you gave me for clarity, you then cut me off, and there was something material I wanted to state for the record. It is not about the exchange, because this exercise is for evidence. So it's important what we state for the record. So I missed that opportunity, but out of respect to you, I stepped back. Upon reflection, I thought it is important that I bring it to you because it's not about the time, it's about what is important to be stated for the record. So I would like to state that for the record so that we have it. And then there's one more issue around the witnesses for public participation that you said yesterday towards the end of the meeting, the 2 witnesses for public participation that we have agreed as a committee already, that they are going to appear before us, that their statements will be referred to legal to decide, whereas the committee has already decided. And I think it's the responsibility of the legal team to assist the public if the presentations is not clear. But when I read the affidavits yesterday, I saw, although it was done in their way, in their informal way, material issues that we should allow them to ventilate here as it relates to interference. It was a murder case, and they are claiming, or there's allegations that they have not been, there's been interference and defeating the ends of justice by the South African Police Service. I think we should hear that, even if we hear it in a way that they give it.
Yeah.
So that's an issue. I'd leave that there. May I state for the record what I wanted to state yesterday when I was cut off, Chairperson? Is it okay? So yesterday, the two statements, the material difference in the two statements made under oath by General Musikili of the macro incident. The material difference is the crime scene. On the one statement, she says that her belongings was stolen inside of macro. In the other statement, she says that her belongings was stolen.
Point of order, Chair, please.
In the car.
Point of order, Chair.
In the car. So that is the material difference.
Point of order, Chair.
In the two statements.
Just hold for a moment, Honorable Souls. Let's hear the point of order from Honorable Nkosana.
Chair, I don't think it's fair that we are discussing what happened yesterday here, because the witness is no longer here. We'll discuss that internally. We can't be discussing the statement today when we had an opportunity, even if some of us might not be happy with other issues. But we can't be discussing a General Musikili issue now. To say, I can raise something as well, that I was not happy with this. So I'm saying, please, Chair, let's focus on the witnesses which are before us now. Thank you, Chair.
No, I hear the point of order that you are saying. And all of us are well aware that General Musikili is not here today. I don't think the honorable member is raising the point to say we must discuss it. The honorable member is bringing the matter to our attention, and let's allow him to conclude his point. And if it's a point that we must refer to the legal team, we will do so, but let's allow him to raise that point. I think it's only fair that we hear him. Honorable Souls, may you please conclude?
Thank you, Chairperson, and thanks for understanding. It's for the purpose of the record, so that when we consider the testimony, this part is part of that record for consideration. So the material difference in the two statements, the General testified that it was the same statement and the content of the statements are the same. And I put it to her that it was not the same, and the difference is the scene of crime. On one statement, she says her belongings were stolen in macro. On the second statement, she says her belongings were stolen at the gate outside of macro. And that is the material difference.
Okay.
Thank you, Chair.
Yeah, what we will do for the purposes of fairness and to justify our actions, we are going to request you that you put that in writing. And through the legal team, we pass the statement to the witness, so that if there is anything that you may want her to explain, let her explain that, so that we don't become one-sided. Honorable Nhlanhla.
Yeah, no, thanks, Chair. But I thought those are the issues that are relevant for our deliberations, because during the deliberations, when we're done with the interviews, we are going to expose the discrepancies that we have detected during the oral and in the written statements. So I don't think it's relevant for this meeting. And Honorable Nkosana was correct, Chair, to say those are the issues that Honorable Souls is supposed to keep and raise them when we deliberate, to say this witness was not credible on this basis because his statement was contradictory and so on and so forth. So that is my understanding, Chairperson.
Yeah,
Yeah.
No, you are not wrong in your understanding. Let me tell you, both you and Honorable Sols are not wrong. Honorable Sols is raising a matter here, which the chair says, let's put it in writing, so that the witness can also be given an opportunity to respond to it. It will come to deliberations. At the time we deliberate, we would have heard the question that Honorable Sols has sent to the witness, and we will also be having the response that the witness would have given us. It's unlike when we reach a point of deliberations and then he raises the matter at that time, and somebody stands up and say, no, but the witness is not here, has not been given an opportunity to respond. I think let's take it in that spirit, honorable members, that it will be passed on to the witness, and the witness will also be given sufficient time to respond to the question that Honorable Sol is stating here. And with regard to your request, Honorable Sols, about where time expires, and you were asking a clarity-seeking question or a follow-up. Can we agree that the chair will allocate each speaker no more than 2 minutes in case we find ourselves in a situation like that? Is it agreeable? Thank you so much. I'm just saying that we must mind those time lapses so that when your time expires, and then maybe the speaker or the witness has not finished responding to the question, we say the chair's benevolence must be stretched to no more than 2 minutes. Is that what we are saying? Agreed? Okay. Honorable Sangon, is your hand up?
No, you've covered me in the summary and the earlier discussion. Thank you, Chair.
Okay, thank you so much. Advocate Mkhize, I want to hear you speak regarding the matter of Mr. Chetty and Advocate Mashocha. Which witness do we take first?
Chair, we had prepared with the witnesses that we would deal with Mr. Mashocha's evidence first and thereafter Mr. Chetty. That is the team.
We said we were going to give Mr. Chetty 45 minutes to present.
Indeed, Chair. Chair, we are in your hands in terms of guidance, but
I want to check with yourselves and Mr. Chetty if you are ready that we can start with him.
Mr. Chetty and I have not had an opportunity yet to just go through some of his evidence, and that's the reason why we were asking for Mr. Mashocha to go first.
Okay.
Yeah.
Okay. We can't go against your advice. If that is so, are you comfortable with that, Mr. Chetty?
Honorable Chair, yes, I am.
Okay.
Thank you.
Can I check, are there any statements you want to make before we swear the witness?
No, Chair, there's no statement we'd like to make. As soon as you've sworn in the witness, if you may please just excuse me so I have an opportunity with Mr. Chetty before we start. Once you've sworn Mr. Mashocha in.
Once we say Mr. Advocate Mashocha, is Advocate Mashocha, is it Advocate or Mr.?
Indeed, so.
Advocate, yeah. Once we say Advocate Mashocha in, your request to be released to finalize with Mr. Chetty.
Indeed.
Thank you so much. No, that is granted.
Thank you.
Advocate Mashocha, we are going through the swearing in process. Let me just make this remarks before we say you in that you have been invited before this ad hoc committee, which is investigating the allegations that have been made, or before.
Chairperson, I stand to be corrected. I have had, I've consulted with my leader, and he's also of the view that perhaps the public participant should go first because his time is limited and it's 45 minutes, and then thereafter we will take the main witness. Okay.
What do you want us to do?
Sorry, Chair, honorable members. I had requested at the last committee meeting to start with Advocate Masha at his request and that of his legal team. I had then asked to be excused from the meeting. So I didn't hear subsequently that request wasn't granted or refused, or what the position was and the order of witnesses. And that is why, after consulting with Advocate Masha and his team since yesterday, we were under the impression that we are starting first. And I think we still have Mr. Adams on our witness list for today. But in the event that, Chair, the public participation witness, Mr. Chetty, are you going to restrict him to time? It may be best in the circumstances. Otherwise, he may well be waiting here, as Honorable Skosana said, for a long time. And if you can deal with him first, then we wouldn't have any objection.
What is your proposal?
So we propose that he start first, and that Advocate Masha follows.
Honorable Chair, I have not consulted with anyone. There's a lot of evidence that I have that I think council has to see, just instead of reading my affidavit in.
Mr. Chetty, the legal team tells me that they are fine, they can handle your matter. Remember, with public participation, it's not like the witnesses that we have identified. With public participation, they read your statement. They say that they have gone through your statement and they have structured questions, which they will ask you and help you to provide. When they go through your statement, they look at what is relevant to the terms of reference of the committee. You have given us your statement, isn't it?
Honorable Chair, yes, I have. And there's a lot of annexures as well, which I don't know if council has been through it. Because there's a lot of information that has everything to do.
No, it's fine. Let's do this. Advocate Arendse, let's take Advocate Mashura for now, so that we do not do with the witness what does not give him or her comfort. If he thinks that on his part, I mean, on the part of the legal team, you may be satisfied that you are ready. So have that moment with him and satisfy him that both parties are ready for presentation. Yeah. Honorable Matthews.
Chair, we've discussed this quite regularly in our working meetings, that our public participants should not be treated any differently than the witnesses that are on our list. And while we made a decision as a committee based on the report that we received from our technical team, there was a process where our legal office is supposed to go through that and treat our witnesses and our public participants with dignity. We can't have our evidence leaders only getting these copies and then just going through it now, Chair. And this thing was even raised yesterday. Why are we doing that? And we've had so many of these issues. That's how we ended up having a witness here, because we brought them here without us just doing basic due diligence on it. Because remember, we made it a decision, Chair, as the ad hoc committee, based on just a report from the technical staff that they went through. None of that was tested. They were not sat down with the evidence leaders. From what I understand yesterday, Advocate Mkhwanazi said they don't have capacity to be able to go through our public participants' sworn statements. So I would have thought that maybe we should see if the Parliament legal team is able to do that, but they're also the ones that don't lead evidence. So I don't think we're doing justice to this process of public participants, and we should not be treating the general public in the manner that we are, Chair. Thank you.
Honorable Nombalo.
Chair, mine is a clarity-seeking question. I just need to be clarified on this aspect, Chair. Is Mr. Chetty a witness or a public participant? I'm asking this because I've read his statement, and to a certain extent, he's making a testimony which is within the context of the terms of reference, and a testimony which also involves some institutions that we are probing or we are investigating. So he talks about IDEC and so on. Now the question is, Chair, what is the difference between his testimony and the testimony of Advocate Mashuka? And I think we did discuss about this at some point as this committee, that what is a difference between a public participant and a witness? So I just need to be clarified, Chair, because I'm really confused. This clarity is important so that we have a better insight when we are dealing with witnesses, because the public participants that we have dealt with previously have been afforded an opportunity to make presentation, and if my memory serves me well, some were just reading presentations, which was not made under oath, which was not reliant on affidavits, on sworn statements. Now, Mr. Chetty is a witness, is coming with a sworn statement and is making a testimony, which also relates to some of the terms of reference and also relates to some of the institutions that we are probing. So I just need to get a distinction, Chair. I'm asking this from a genuine perspective because I'm really confused now. What is happening?
Chairperson, the evidence team goes through all the affidavits that we receive from the Secretariat. We received Mr. Chetty's 75-page affidavit yesterday. He had initially filed a one-pager as his evidence as a public participant. He subsequently also attached a number of annexures, which are quite lengthy. I have gone through all of that overnight, and I am prepared to lead his evidence. He is a public participant in my understanding, and how we have dealt with all public participants is that we don't have numerous consultations with them as we do with witnesses as given to us by the committee members, because the list is received from the committee regarding witnesses. However, it does not mean that we compromise all witnesses that come before us. We treat them the same. We consult with them. We go through their evidence. We prepare, regardless of the time when we receive their affidavits. Indeed, I can confirm I have gone through his affidavit and I've prepared to lead him this morning.
Okay, let's do this. Because he has said that he wants to meet with you. we are going to afford you that time so that he gets satisfied that when you come back here to start the presentation of evidence, we don't have question marks. So we are going to start with Advocate Masha now and allow you, as it was earlier requested, that you will go and consult with Mr. Chetty, just for the legitimacy of the process, but also to have each one of you satisfied that whatever matter they would have want to raise, the matter is raised. Yeah. Honorable Nhlanhla.
Chair, I'm quite concerned. Was looking also at the evidence of Advocate Masha. It's quite, it has got serious volumes. So I'm worried about the approach that we're taking now. If when they are done, the Advocate Mkhwanazi and Mr. Chetty, are we going to interrupt the evidence of Mr. Masha, or we're going to take him immediately after?
We're taking Advocate Masha and from start to finish. Yes. Yeah. Advocate Masha, let's restart the process that I was explaining to you, that you have been invited here to come and help the committee in its oversight and investigative work. We are investigating allegations that were made by the KwaZulu-Natal Police Provincial Commissioner, General Nhlanhla Mkhwanazi. Amongst the allegations that he made is the unlawful, number one is the alleged unlawful disbandment of what is called the the political killings task team, otherwise known as the PKTT or NPKTT. Number two, alleged moratorium on the filling of vacancies. And within the South African Police Services, the SAPS. Number three, alleged corrupt relationship between senior leadership within the SAPS and members of the public. And lastly, political interference within the work of the SAPS. In extending this invitation, the chairperson of that ad hoc committee has indicated that you may provide such information to the committee if you so wish, under oath in terms of the powers, privileges, and immunities of Parliament and Provincial Legislatures Act of 2004. Advocate Masha, please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to do so in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or even civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or a Committee of Parliament may not be used against you in any court or place outside Parliament except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offense and is liable to a fine or to an imprisonment for a period not exceeding 2 years. You are required to take an oath or affirm that the evidence you are about to give is truthful. Which one do you elect, oath or affirmation?
I will take an oath.
Okay, thank you so much. You have elected to take oath. You shall, may you please follow me as I dictate. Please say aye and state your names in full.
I, Molatwa Michael Mashuha,
Swear that the evidence I shall give
swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
And so help me God.
So help me God.
Thank you so much, Advocate Mashura. I'm handing over the reins to yourselves, Advocate Mkhize and you. Good luck in the presentation of your evidence.
Honorable Chair, I'm going to lead Advocate Mashucha. Just a few preliminaries before we start, Honorable Chair, honorable members. You would have seen from the affidavit before you that Advocate Mashucha has not disclosed his current position, where he's employed, and also his address. The reason for that, Honorable Chair, honorable members, is that you would also have seen from his affidavit that as a senior state advocate, he had prosecuted a number of high-profile matters, some of which have been concluded and successfully, and where the accused were found guilty and serving prison time. Other matters are still pending, which have now been obviously taken over by his former colleagues now that he's left. In one matter, the well-known or notorious rhino horn matter, where he prosecuted, threats were made to him and the investigating officer in that matter, and the investigating officer was murdered. So he is very concerned about his security and his safety. And in fact, just this morning, his legal team had also raised somewhat disappointment about his security arrangements that they thought would be made with Mr. Romano. So that is the reason, Honorable Chair, that is not disclosed in his affidavit and to this honorable committee.
But have those security arrangements been sorted now? Or are you still in the situation you were at the time he raised those concerns with you?
Mr. Masha of the MPA indicates no. So perhaps while Advocate Mashucha is in the relative safety of this chamber, maybe my colleague and Mr. Masha can try and sort it out with Mr. Romano.
But was there a commitment on the part of Parliament to make those arrangements?
I'm not sure, Honorable Chair, Mr. Masha is present. If with your leave, he can address that issue.
Thank you very much, Chairperson. He had made a request when he was requested to come and testify or prepare to testify before this committee. And all that he was provided was a driver, nothing relating to his security was addressed. He brought this to my attention yesterday, and I raised it with Mr. Romano and counsel this morning. And up to now, no indication if the matter is being addressed or not. And to us, that is a concern. Thank you.
It's fine. Let's proceed. We will get Mr. Mpilo as the proceedings go ahead too. and solicit an explanation as to what is happening.
Thank you, Honorable Chair. And again, just before we start, just to contextualize Advocate Mashugha's presence here, he is giving evidence in relation to the again well-known / notorious case of Camildriff, case 1201/2017, which has been referenced in the evidence respectively of Mr. McBride, Mr. O'Sullivan, General Paslani, and that is why this honourable committee, through you, Chair, had requested that the prosecutor in the case, as we know, the matter was struck off the roll in terms of 342A of the Criminal Procedure Act some 7-9 years ago, and has not been re-enrolled, and the honourable committee was rightly concerned why that has not been the case, and Advocate Mashugha is here to assist us in that regard. He was the prosecutor in that matter. Now, this honourable committee wrote to both the previous NDPP, Advocate Patoy, and the current NDPP, Advocate Motibe. There was a letter that was sent to the committee in November last year, by Advocate Patoy, and there's also a letter that was written by Advocate Motibe, and I've asked that it be placed on the desk, will be in front of the honourable members, and it's also before Advocate Mashugha. If I may just refer to the first one, dated the 20th of February 2026. Advocate Mashugha, you got that one? There's two, the one of the 18th. I'm going to deal with that one second. The first one is the 2-pager 2002-2026.
The one that I'm having,
you should have two.
18 February.
Yeah, and then there's another one of the 20th of February.
Yes, I have one.
Is that what that one page?
Oh,
yeah.
yes.
Yeah, and you have it. Thank you. Now, Honourable Chair, Advocate Mashugha, that's the one where, because of course you are no longer in the employ of the NPA, and you're a former prosecutor in the matter, you had to seek permission from the NDPP to testify.
Indeed, so, Chairperson.
And this is the letter from Advocate Motibe, where he says in the 3rd paragraph, I have seriously considered your request and henceforth authorized Advocate Mulotwa Michael Mashugha to disclose the information relating to the criminal case that involved Mr. Paul O'Sullivan, particularly case 1201/2017. Kindly note that the authorization is limited exclusively to disclosure for the purpose of the ad hoc committee. You are reminded that this permission does not constitute a general waiver of confidentiality obligations under the Act, and disclosure remains subject to the restrictions and protections provided therein. Any disclosure made under this authorization must be handled responsibly with due regard to the integrity of the information, the rights of affected parties, and the statutory obligations of the NPA. This authorization is granted solely for the facilitation of the ad hoc committee and shall lapse upon its conclusion. No further disclosure for any other purpose is permitted without the prior written consent of the NDPP. You confirm that, Advocate Mashugha?
I do confirm receipt of this letter, and I confirm that the contents were so received. And in my affidavit, I try as much as possible to ensure that the conditions that were set out in this letter are complied with.
Since your resignation from the NPA in 2024, which you referred to in your affidavit, have you had access to the docket in this matter?
No, I never had access to it.
Good. And then if I may just round this off, there's a letter of the 18th of February 2026, which responds, Honorable Chair, to a number of questions posed by this Honorable Committee. Have you got that one there, Advocate
Yes,
Mashocha?
I do have it, Chairperson.
And where Advocate Mutibi refers to the Honorable Committee's letter of 10 February 2026 and the letter written by Advocate Batoy of 17 December 2025. Advocate Mutibi, our current NDPP, says that he has requested the Acting Director of Public Prosecutions within whose jurisdiction this matter resides to provide with a report to address further information. The ADPP has provided a report and the following response. First question: why was a decision taken by the NPA to hold over the decision to prosecute O'Sullivan until the matter against General Pashlani is finalized? The answer: the ADPP was informed that the senior state advocate assigned the matter prepared an indictment that included charges relating to the contravention of Section 2 of the Prevention of Organized Crime Act, POCA, commonly referred to as racketeering. The POCA requires that racketeering charges require authorization of the NDPP. After due consideration of the said charges, the supervisor held the view that there was insufficient evidence to prosecute on racketeering. The prosecutor was directed to reconsider the appropriate charges. The decision by the prosecutor was thereafter delayed. Mr. O'Sullivan allegedly defamed the prosecutor, and the prosecutor also had to justify allegations made by Mr. Robert McBride at the Zondo Commission. The prosecutor has resigned from the NPA. So, Mashocha, that's a reference to you.
Indeed, Honorable Chairperson.
The ADPP has established that the docket is with the counsel appointed in the civil case and will be assigned to a suitably experienced prosecutor to consider whether to institute a prosecution and whether the case can proceed against O'Sullivan. The second question, whether the report was supposed to be compiled by the prosecutor within 7 days of the judgment did serve before the Director of Public Prosecutions. And Mr. Mashocha, that you're going to deal with in your evidence.
Indeed, Honorable Chair.
Yeah, this comes from a portion of the magistrate's judgment that the matter is removed from the roll and that the report must be compiled within 7 days.
Indeed, Chair.
Okay. The answer: it is assumed that the report referred to is the order made by the magistrate during the striking of the matter from the roll in terms of 342A of the Criminal Procedure Act. Section 342A3C of the CPA provides that the prosecution shall not be reinstated without the written instruction of the Attorney General. That was then the Attorney General, but it's the DPP these days. A report will only become relevant when the delay causing the striking of the matter has been addressed, e.g. further investigation that had to be finalized. In this instance, the DPP was appraised of the court reasons for the striking of the matter. There was no formal report, as it will only become relevant when it is considered to re-enroll the matter. So the concerns, Advocate Mashocha, that's been raised by this Honourable Committee about why the matter has not been concluded or hasn't been re-enrolled, you're going to assist with that in today's evidence.
Indeed, Honorable Chair, I made an attempt to
place evidence before this committee explaining the delay as well as the 342 capital A C reasons.
So just now, just to focus on your affidavit, we know now that you served as a senior state prosecutor for a long time in the NPA. You served in the organized crime unit, but since 1 September you resigned, and we discussed the reasons why you do not disclose your current employment. Do you just want to give us some overview of your own professional background, which you reference at paragraphs 5 to 8 of your affidavit?
Indeed, so, Honorable Chair, I commenced my employment with the NPA as a prosecutor on the 3rd day of April 2000 at the Magistrate Court, Taung. In 2002, I was promoted to become the Regional Court Prosecutor for the Regional Court in Taung, that is in Northwest. In March 2007, I was appointed as a State Advocate at the Office of the Director of Public Prosecutions in Kimberley, Northern Cape. There my duties are listed there in paragraph 5, in which inter alia included dealing with high-profile matters like murder, robbery with aggravating circumstances, rape where victims were murdered. I also dealt with appeals and reviews. And then in 2009, I was appointed as Senior State Advocate at the Office of the DPP Kimberley. And in March 2010, I was transferred to the Office of the DPP Gauteng, Pretoria as a Senior State Advocate at General Prosecutions and subsequently at the Organized Crime Unit. And as a Senior State Advocate, my responsibility included dealing with high-profile matters and complex criminal cases. I also supervised junior advocates. During my employment in the Office of the DPP Gauteng, Pretoria, I was allocated serious cases of police corruption, racketeering, money laundering, cash in transit robberies, murders, taxi violence cases, and targeted assassinations and other cases of a similar nature.
Thank you. Then you describe at paragraph 9 the purpose of your submission to this honorable committee.
Indeed so, Honorable Chair. And I described there that the purpose of this affidavit is to make submissions to the ad hoc committee demonstrating that at a particular point in time, the Independent Police Investigative Directorate, which is IPID, was infiltrated by Mr. Paul O'Sullivan, who was a complainant in a matter that was allocated, that I was allocated to prosecute, as well as her assistant, Sarah Jane Trent.
Then at paragraph 10, you say this, what this matter really, or what's at the heart of this matter is the investigation by the IPID, and then the subsequent threats and intimidation and interference against you and the investigation team, and by some of the witnesses, including O'Sullivan, McBride, and some other people. In your submission, you demonstrate interference against you, persons involving, including Mr. McBride. You make submissions about the steps, which is of concern to this honorable committee, that you undertook to re-enroll the case. You make submissions to this committee about the witnesses or some of the witnesses who testified. already before this honorable committee, including O'Sullivan, McBride, General Pashlani, and other witnesses. You respond to allegations made by McBride and one Brigadier Tayani Shlungwani before this committee, and you address some of the related matters.
Indeed, so Chairperson. So in summary, my submissions regarding paragraph 10 will show or demonstrate evidence which will ultimately show that there was a considerable interference with the investigating officers, with me as a prosecutor, which would have contributed to the delay of the Camille Drift case 12/01/2070.
Okay. Then the aspects of your affidavit which follow the mandate of the NPA from paragraphs 11 through to paragraph 22, which is from pages 5 to 8, are more formal matters, the fundamental principles of that guide the prosecution of a matter under the NPA, and also your role as a prosecutor. Do you want to summarize some of that?
Yes, in summary, I would highlight paragraph 16, in terms of which Section 32, subsection 1A of the NPA Act states that a member of the NPA shall serve impartially and exercise, carry out, or perform his or her powers, duties, and functions in good faith, without fear, favor, or prejudice, and subject only to the Constitution and the law. And paragraph 17, section 32(1)(b) of the NPA Act, which provides that subject to the Constitution and this Act, no organ of state and no member of or employee of an organ of state, nor any other person shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof in the exercise, carrying out, or performance of its or her or his powers, duties, and functions. Paragraph 18, section 41 of the NPA Act provides that offenses and under offenses and penalties, any person who contravenes the provisions of section 32(1)(b) shall be guilty of an offense and liable on conviction to a fine or to imprisonment for a period not exceeding 10 years, or both such fine and imprisonment. And I state these paragraphs and provisions in light of what happened during the investigations of the case that I was guiding, and the threats and the interference and the hindering that was occasioned by some of the people involved or accused or suspected in that case.
And you have a comment at paragraph 21 about people like O'Sullivan, McBride, and others who label themselves or call themselves as corruption fighters. What's your opinion?
Yes, I do say that because I have been subjected to sustained interference, insults, and the allegations were that I was captured. In fact, during that time, there was a sustained attack which included interviews, O'Sullivan going to for interviews at different radio stations, Radio 702, Power FM, and different articles were written about me. And ultimately, my name even made it into a book by a certain Jack Paul, where allegations of state capture and corruption were made against me, just because I had made a decision to prosecute Mr. Paul O'Sullivan and some other suspects. As the committee will see later, there was more than sufficient evidence that I relied on to prosecute those people.
Okay. Then from paragraph 23 onwards, you deal with the nature of the matters dealt with in the organized crime unit to which you were assigned. And those clearly, I mean, it's apparent from paragraph 23.1 through to 23.3 that it deals with the most serious of matters. Because it is important to establish your credentials as a senior prosecutor and your views in this matter. Is there anything from under this section, paragraphs 23 to 28, that you want to underline before we move on?
From this, the only important paragraph that I would like to bring to the attention of the committee is the duty of the prosecutor in giving instructions after a matter has been opened, or a case docket has been opened by the police. They do some preliminary investigations, compile the docket, then they bring it to a prosecutor. From there, a prosecutor now starts giving out instructions as to which investigations he would like to be carried out. So
that's the prosecution guided approach.
Yes,
in matters of serious nature like this, also adopted by the PKTT and their team.
Yes, that is the prosecution guided approach, but not the prosecution led.
Is the prosecution led the IDAC approach?
Yes.
And you say there's a difference.
Yes. Indeed, so, Chairperson.
Okay. So in other words, your involvement in the Camille Drift case, this particular case, was quite involved and quite intimate in terms of guiding the investigators and the prosecution of this matter.
Indeed, so after the investigators investigated the matter, collected a few statements, then the docket was taken to the DPP office for a decision. So at the DPP office, it is brought to the attention of a deputy in the DPP office, and then the deputy allocates it to a prosecutor, either a junior state advocate or a senior state advocate. And then by then, because organized crime unit dealt with very serious offenses of which are organized in nature, there were only senior state advocates there. There were no junior state advocates. So before me, there was a prosecutor or a senior state advocate who was allocated.
Masha, if you can just move closer to the microphone.
Thank you. Yes. Before me, there was a senior state advocate who was allocated the matter to deal with. So he, at some stage, resigned, and then I was selected to deal with this matter.
So we move on in your affidavit under the heading the mandate of IPID, and you reference IPID because this will, for you in your affidavit, illustrate or highlight the kind of interference by O'Sullivan, amongst others, in the affairs of IPID. So you set out the mandate of IPID with reference to the Constitution and the IPID Act. Do you want to highlight any particular paragraphs, perhaps 31, 33, and 35,
Yes.
36 and 37 of your affidavit?
Thank you. In fact, I would like to deal extensively with those paragraphs because it is actually the crux of the matter in terms of whether there's always been this question whether Mr. Paul O'Sullivan and Trent were entitled to involve themselves in this investigation, and whether IPID had abdicated its statutory power and duties and functions to a private person. So I would deal extensively. I would start with a paragraph 30, which says that 29, which says section 206, subsection 6 of the Constitution lays the foundation for the establishment of an independent police complaints body, which is to be established by national legislation. Paragraph 30, the Independent Police Investigative Directorate, 2011, Act 1 of 2011, which is referred to as IPID Act, establishes the IPID. Paragraph 31, Section 2, subsection D of the IPID Act provides for the object of this act, which inter alia are being to provide for independent, and I would like the committee to underline independent and impartial investigation of identified criminal offenses allegedly committed by members of the SAPS and municipal police services, because in this paragraph, I place evidence before this honorable committee that the IPID investigation at that stage was not independent because it was infiltrated by and led by Mr. O'Sullivan and Ms. Sarah Jane Trent, who were not only not independent and biased, but who had a motive to falsely implicate General Patlani, as we will see in the subsequent evidence that I deal with. And then also you will see that where the section says IPID had to deal with identified criminal offenses allegedly committed by members of the SAPS. Now they extended their own mandate now to include dealing with private citizens who were not members of law enforcement, and even a minister who they had no mandate to investigate him. And then in this affidavit, and I'm at paragraph 32, I demonstrate that the IPID, by permitting O'Sullivan and Trent to lead their investigation into the Patlani matter, runs contrary to the very independence and impartiality the IPID Act seeks to protect and guarantee. And then importantly, at paragraph section 25(1), importantly because it relates to the core of the charges that I preferred against the suspect. Section 25(1) of the IPID Act further provides that no member of the directorate may conduct an investigation in respect of a matter in which he or she has a financial or any other interest which might preclude him or her from exercising or performing his or her powers, duties, functions in an objective manner. So this section deals or refers to a situation where an investigator is related to a person and then involves that person in an IPID investigation, whether that person is related to that person as a friend or as a person who has at some stage helped him financially, or maybe where the person is related to him, where he's a wife to him. He cannot involve those people in an IPID investigation. And then section 25(2) provides that if during an investigation it appears to a member of the directorate that a matter concerns a financial or other interest of that member as referred to in subsection 1, that member must, 1, immediately and fully disclose the fact and nature of that interest to the executive director and withdraw from any further involvement in that investigation. We know that the IPID members, the Patlani task team, had these kind of relations with Sarah Jane Trent and O'Sullivan, where there were favors exchanged amongst and between themselves, the interest being to see General Patlani being removed as a national director or suspended. So the evidence is there. I will set it out during my affidavit and refer to real evidence. Section 33(2) provides that any member of the directorate who willfully discloses information in circumstances in which he or she knows or could reasonably be expected to know that such a disclosure will or may prejudicially affect the exercise or the performance by the directorate of the powers and functions is guilty of an offense. Section 33(4) provides that any member who fails to make a disclosure in accordance with section 25(2) or fails to withdraw in terms of section 25(2)(b), as the case may be, is guilty of an offense. Even the regulations, regulation 10.1 of the regulations for the operation of the Independent Police Investigative Directorate provides that all information, whether verbal or in writing, and all documentation acquired during the course of an investigation conducted in terms of the Act, and all records pertaining to any such investigations are to be treated as confidential and may not be divulged to any person outside of the directorate unless authorized to be divulged in the interest of justice by the executive director or relevant provincial head, as the case may be, in writing or an act of parliament. Now, several of the charges against the IPID members related to this contravention of section 33.
And yes, you conclude at paragraph 38 that your submission is that the accused and the suspects in that case have all contravened these provisions that you've referred to.
Indeed so, Chairperson. Now, I also highlight at paragraph 31 the prevention, the definition of the Prevention and Combating of Corrupt Activities Act.
31 or 39?
39, oh, sorry, Chair, 39. And then section 1 of the Prevention and Combating of Corrupt Activities Act, number 12 of 2004, provides the definition of gratification to include money, whether in cash or otherwise, any donation, gift, or loan, any forbearance to demand any money or money's worth or valuable thing, any other service or favor or advantage of any description, including protection from any action or proceedings of a disciplinary, civil, or criminal nature. We have heard before this honorable committee that Mr. O'Sullivan admittedly made a contribution of 200,000. I think he said 200,000 for the legal expenses of Mr. McBride, and that was during the period that Mr. McBride was suspended. So immediately thereafter, in November, Mr. McBride was reinstated. Same time, O'Sullivan now approaches Mr. McBride and then involves himself in the investigations against the General Patlani. Now, that definition, which says including protection from any action or proceedings and forbearance to demand. So it demonstrates to us that he paid that money for the legal expenses of Mr. McBride as a forbearance for him now being involved in the investigation and exercising the functions and powers of IPID.
So that amounts to gratification.
That amounts to gratification in terms of the act. And then I deal with the other contentious issue of the National Credit Act. Mr. McBride and Mr. O'Sullivan said there's nothing wrong with a person accessing the credit information of private citizens. In fact, that is a very, very dangerous contention by them. So I deal with the National Credit Act 34 and under section 68(1, provision is made there that any person who in terms of this act receives, compiles, retains, or reports any confidential information pertaining to a consumer or prospective consumer must protect the confidentiality of that information and in particular must use that information only for a purpose permitted or required in terms of this Act, other national legislation, or applicable provincial legislation, and report or release that information only to the consumer or prospective consumer or to another person to the extent permitted or required by this Act, other national legislation, or applicable provincial legislation, or as directed by the instruction of the consumer or prospective consumer or an order of a court or tribunal. Now, the regulation 18.4 of the National Credit Act regulations as amended by the 2015 regulations provides that the prescribed purposes other than for purposes contemplated in the Act for which a report may be issued in terms of Section 70, subsection 2G, are inter alia. One, an investigation into fraud, corruption, or theft, provided that the South African Police Service or any other statutory enforcement agency conducts such an investigation. Two, fraud detection or fraud prevention services. Now, I'm stating this fact because we know from the information, and when we were even able to obtain a statement from TransUnion as to the reason why O'Sullivan and Trent accessed the credit reports of private people. Now, we know that they used this 42.2 reason, fraud detection or fraud prevention, but they cannot, they are liable in terms of the contravention of the Act because there was no complaint of fraud made to them in the first place. Secondly, other than that, there was no fraud and detection. We know that the witnesses whose credit reports were accessed were not suspects. In fact, the witnesses were state witnesses in their in IPID's own investigation. So why did they have to investigate their own state witnesses? And then finally, I referred in paragraph 43 to section 86(1) of the Electronic Communications and Transactions Act, and it relates to also the accessing of the credit information, which says, subject to the Interception and Monitoring Prohibition Act 1992, a person who intentionally accesses or intercepts any data without authority or permission to do so is guilty of an offense. This section, Honorable Chairperson, has now been amended, actually deleted, because of the promulgation of the Cybercrimes Act 19 of 2020. So there's provision for this offense now in the Cybercrimes Act.
Then in conclusion on this section, you underscore the points that you make with reference to that SCA case at paragraphs 44 and 45.
Indeed, so Chairperson, in that case, I refer to it where it says, and I quote, "The second issue concerns the undesirable fusion of private and police investigations. It appears from the evidence referred to earlier that AIN commanded the resources of the SAPS when it saw fit. The police officials involved readily complied. The SAPS is not up for privatization nor for direction by parties such as AIN. This too is a matter that should be dealt with by the relevant authorities. And on my paragraph 45, lastly, it is not only that the lines between the AIN and police investigations became blurred, but as set out above, police officials acted in two capacities, even going to the extent of doing AIN work whilst on police sick leave. This is untenable and should be investigated by the relevant ministry. So at paragraph 46, I state that I implore this honorable committee to keep all these legal bases, the contravention or rather the provisions of the IPID Act, this case, the National Credit Act. I implore this honorable committee to keep this in mind when we go through the contraventions or the offenses that were preferred against the accused.
Okay, thank you. So now we get to your involvement in the Camildrift matter from paragraph 47 onwards. Describe how you came to be allocated the matter in February 2017.
Indeed, so Chairperson, the Camildrift matter was initially allocated to a certain state advocate who later resigned. And then in February 2017, the matter was allocated to me by the Deputy Director of Public Prosecutions in the Organized Crime Unit, after a request was made to the DPP himself to assist in securing an advocate due to the commitment of advocates from the Organized Crimes Unit. So in the Organized Crime Unit, they normally deal with matters which are more serious, and they take time to study and take through the trial process. So most of the time, you will find that they are all committed, and then they would request that an advocate from outside organized crime be provided. So that is how I was then requested to deal with this docket.
And then at paragraph, once you received the docket, what was your first task?
Yeah, my task was to establish from the contents of the docket whether there is any evidence of the commission of a crime, which is the normal task which prosecutors do when they receive a docket. And secondly, if there is a need for further investigations, in which case then to guide such investigations. As I explained before, as soon as the prosecutor receives a docket, he studies it, he identifies whether there's a need for further investigations, and yes, and then guide such further investigations.
And then at paragraph 50, you highlight the offenses which you had identified that the suspects would have contravened at paragraph 50 after you studied the docket.
Indeed, so Chairperson, I identified that there was intimidation, and the intimidation was the one regarding General Patlane, where he was told that he will be imprisoned, his house will be sold at an auction by O'Sullivan, and he would sell it at, he would buy it at an auction and sell it just like he did with the house of Krecher. That is what he said. and then also extortion against General Patlani. Then there was this contravention of Section 33(5) of the IPID Act, where they presented themselves and acted like IPID investigators, and a conspiracy to commit this offense, and that relates to the 2 IPID officers who, despite O'Sullivan and Trent acting and pretending like IPID officers, obtaining statements of witnesses like IPID officers, and all what they did. The 2 IPID investigators did not stop them, or so they allowed them to continue contravening the IPID Act. So they were, I preferred the charges of conspiracy against all of them. And then there's also fraud, where they pretended to Chris Joste, the estate manager, that they are IPID investigators, and they are entitled, using the power of IPID, to access the confidential house plans of General Patlani. So that misrepresentation, I preferred the charges of fraud. And then the extortion of Chris Joste, where they intimidated Chris Joste when he did not want to give them access to the house plans. They intimidated him and said he will be sentenced to 2 years imprisonment, but we know that the 2 years imprisonment was if a person does not cooperate with IPID investigators, not private persons like Paul O'Sullivan and Sarah Jane Trent. And we know that after those house plans were provided by Chris Joste, it is O'Sullivan who took pictures with his phone of the house plans. So in fact, it was O'Sullivan's own private investigation, not an IPID investigation, and they were just using IPID officers as cover. We know that the intention was to show General Patlani that I told you that I'm going to take you to prison. Now here I'm taking you to prison. Because one other factor in this case is that when these investigations were going on, when O'Sullivan and Trent were obtaining this information of the investigations by IPID, they continued taunting General Patlani, sending emails to him that I told you I'm gonna do this and this, and now here you are. And then, yeah, the attempted extortion is against General Patlani, where all these threats were made to him, but obviously he did not succumb to be part of the cabal of O'Sullivan and Trent. So the threats did not result in anything. So there was no advantage in terms of the definitions of extortion that was gained.
So after you considered the totality of the evidence, you identified O'Sullivan, Trent, Tamani, Binang, Nhlanhla Kayisi, Mashlangu, who's late. You identified them as suspects in relation to these charges, and that you describe at paragraph 52.
Yes, in summary, that is the position, Chairperson.
Okay. From paragraph 55 on which you discuss the background to your submissions, and in relation to this honorable committee's terms of reference at 56(2), paragraph 56(2), to establish whether any wrongdoing, corruption, or breaches of conduct have occurred within SAPS or any other relevant institution as outlined in the regulations. So that's in summary the context in which you are giving this evidence.
Indeed, so, Chairperson.
Then I think we've discussed this. I don't think you need to spend much time. The honorable committee members have also read your statement. The process of prosecutorial decision-making from paragraph 59, the whole of 59 through to 61. You conclude at paragraph 60, I can confidently state that I applied myself to the obligations set out above, consistently, but more particularly in my handling of the docket in a cumulative matter.
Indeed so, Chairperson.
Okay. Then you have summarized the charges preferred and the relevant evidence, summary of the facts, which you deal with from after paragraph 61, 62 onwards. Is there anything you want to highlight there?
In fact, Honorable Chairperson, I have already summarized this, so I don't need.
Okay.
I don't think there's a need to repeat it.
Okay. Just again for ease of reference, the charges of intimidation from paragraph 67, the charge of contravention of 33(5) the IPID Act, and conspiracy to commit such an offence. That's at paragraph 68. Fraud at 69, extortion at paragraph 70, attempted extortion from paragraph 71, contravention of section 18B, small Roman 5 of the of PRECA.
That one I would like to
yes, please
give light on, because indeed this offense, as I say at paragraph 78, this offense is based on evidence of Jooste when on 17 November 2016, O'Sullivan induced Jooste to sign a statement containing false information, and this offense is based on evidence of also of Antoinette Wilhelmina Venter, when on 17 November 2016, O'Sullivan induced Venter to sign a statement containing false information. So what happened in this in the offenses referred to in these two paragraphs was that O'Sullivan, whom we knew that he was a private person and not an IPID member, he drafted statements for the two witnesses, that is Chris Jooste and Antoinette Venter, and then he emailed them saying that this is their statements. And Jooste says in his statement, witness statement, that Mr. O'Sullivan did not even interview him relating to that statement. And Antoinette Venter also says that she was not interviewed. That is why when they received that statement, which said that it was couched in a language that seemed that it is just an innocent draft that demanded that the witness can just look at the statement and amend where possible. But we knew that it was in contravention of the law because, firstly, they were not IPID officers. They had no business with drafting witnesses for witnesses who are IPID witnesses. Secondly, we knew that they acted with intention because there is that issue where they had threatened General Patlane that we are going to imprison you, we are going to take you to prison. And we knew that that was part of them taking Patlane to prison. We knew that before these statements were sent to witnesses, there was intimidation according to Chris Joste. He was intimidated. So O'Sullivan, the inferences that can be made is that Mr. O'Sullivan, after intimidating Joste, knew that he would cooperate to anything that he wanted. And then on paragraph 81 or 80, this offense is based on evidence of Joste when on 18 November 2016, O'Sullivan induced Joste to sign paragraph 81. This offense is based on Annexure MM4 commission, which is attached as MM4, when on 23 November 2016, Trent induced Joste to withhold information from a police docket. So Trent sent a WhatsApp, and I will read it from MM4. And
give us the page. It is paginated.
Yeah, it's MM4, Annexure MM4.
Yeah, but the page reference. I think it's 66. Yeah.
Yes, it reads, hi Chris, please send me your name and ID number as appears on your ID for the subpoena. Thanks a million. Already we know that these are private persons, not IPID officers. They do not have any business to subpoena witnesses. Secondly, hi Chris, we are on our way to your offices. Officer Nhlanhla says the CCTV photos are not important and can be removed from the statement. Now, section 18, subsection B(v) of the Prevention of Corrupt Activities Act (PRECA) makes it an offense for a witness or any person to persuade, and persuade is defined there as including cause a witness to remove any part of his statement. This is exactly what Trent was doing. She was instructing, or we can even say requesting a witness to remove a paragraph which dealt with CCTV photos. She had no right to do that. She had no right to interfere there. And in my view, this contravened section 18(b)(v) of Breka.
Okay, please pause a little, SC. Honorable Sangwell.
Thank you very much. SC, I'm sorry for interrupting. Please do guide us because this paragraph keeps, these paragraphs keep referring to false information. Are you going to delve into what this false information is? Because it's making it difficult for us to follow. Thanks.
Yes.
Sorry, Honorable Acting Chair. Perhaps if we could direct that question at the witness. The affidavit is quite detailed in that regard. Advocate Masha, do you want the question to be repeated?
Yes, please.
Okay, thank you. Thank you for that guidance through you, Chair. On paragraph 78, I think 78, 79, and 80, you indicate that I think it's Ms. Trent, Mr. O'Sullivan were inducing the witnesses, Mr. Euster and Ms. Venter, to produce false information. What is the false information?
This false information that was contained in that statement was, maybe I should just give a brief background. After the visit to General Patlani's estate, one of the witnesses called General Patlani and told him that there were some people who said they are from IPID. They were looking for my bank statements and they were asking questions about your house. Then General Patlani called the estate, I think it's Chris Joste, and the manager, and asked him whether there were people who had come there looking for his confidential private information. And Joste agreed. And then he said, but you must not give people like O'Sullivan my confidential information. And then General Patlani sent, because Chris Joste forwarded a picture of O'Sullivan's motor vehicle when they were at the estate to General Patlani. General Patlani forwarded that photo to McBride and said to Mr. McBride, I was informed that a private person was accompanying IPID investigators to the estate. Here is the photo of the car. Ethical investigations are encouraged. After receiving that, it would appear that Mr. McBride then sent the information to Paul O'Sullivan. That is the reason why Paul O'Sullivan made these statements. That is the reason why a case of defeating the ends of justice was opened against the General Patlani. So the false allegations there were those who, that were contained in that statement, which said that General Patlani encouraged the witnesses not to cooperate with IPID investigators.
You deal with it at paragraph 85, defeating the course of justice.
Indeed so, Chairperson.
No, I think you can also add, the question is mostly based on the further preferred charges against Trent, O'Sullivan, and Nhlanhla, where they are alleged to have forced Juste and other witnesses to make false information about the operation of O'Sullivan and the company. So I think the specific question that comes from Honorable Sangon is that what kind of information were they forced to make? What is it that they were told to say about Pahlane or the operation at the estate?
No, this specific charge relates to the statement, the draft statement that was made by Mr. O'Sullivan after McBride informed him, and there we are relying on inference that he would have been informed by Mr. McBride that Pahlane knows what we did, what we were doing at the estate. So O'Sullivan then drafted these two statements for Antoinette Velemina and Chris Joste. And what is important here is that he never even talked to Antoinette Velemina about those allegations. He just drafted a statement and sent it because he knew that he had already intimidated them, especially Chris Joste, on the previous occasion. So he knew that they would comply with his request that they admit that those allegations are true.
Also, yes.
May I continue, Chair? Thank you. Thank you, Advocate Mashuga. Perhaps just if highlight or reference some of the paragraphs in your affidavit in relation to crime and injuria at paragraph 87, the charge of perjury at paragraph 89, the personal information illegally accessed and used to what you describe or is quoted as dig up dirt about adversaries at paragraph 93.
Chair, I refer there to exhibit MM6. It contains of 3 pages. In fact, 4. So at some stage during the investigations, General Pahlane made an application for the interdict against the IPID, Paul O'Sullivan, Sarah Jane Trent, and they had to file responding, rather answering affidavits. Now, in those answering affidavits, they made certain false allegations. In fact, there was an answering affidavit and confirmatory affidavits by the others. So the person who answered was Nhlanhla, and the others like O'Sullivan, McBride, and the others just confirmed. So
the annexure you referred to is MM6?
Yes, it's
and that's from pages 68 to 71, and the selected paragraphs in the answering affidavits.
Yes.
One finds from paragraphs from page 69 through to 71.
Yes. Now MM6 stays there in paragraphs in page 73, paragraph 217. There is no blanket restriction against O'Sullivan. However, if he was not involved in the investigation of, however, he was not involved in the investigation of Patlane. He merely assisted in the preliminary stages by locating certain witnesses who could corroborate the allegations against him. But we knew that this is wrong and this is false allegations that they are, or false information that they are including in a sworn statement. That is one of the reasons that we charged them with a perjury. And also in paragraph 234 of the same affidavit, I also reference it there. It says, I note and confirm that O'Sullivan has indicated that he is not involved in the investigation process undertaken by IPID. I mean, by now, we all know that O'Sullivan was deeply involved in the investigation process undertaken by IPID. Also at page 57, paragraph 148, I confirm that from around 25 November 2016, O'Sullivan had no involvement in the investigation. We know, even from the downloads, that O'Sullivan and Sarah Jane Trent were involved in the investigation up until the 7th of February 2017, 3 days before Sarah Jane Trent was arrested.
Now, this application brought by General Patlane, that was not concluded. That didn't go through its conclusion, didn't go through the court.
I do not know where it ended up, Chairperson.
Okay. In fact, after this application was launched, they were arrested, brought to court. Or rather, Trent, I think, was arrested, and O'Sullivan was summoned. The other two were summoned to come to court. I'm not sure whether.
Yes, I'm not sure. I will find out. But Trent was arrested on the 10th of February 2017.
Yes. I'm not sure if it's apparent from this. I'm looking at M6, the notice, the filing notice, that the date of the issuing of these papers doesn't appear.
It does not appear, but during break, I will give you all that information.
Then paragraph 93. Personal information illegally accessed and used to dig up dirt about adversities. You want to, that paragraph 93, you want to mention or refer to those paragraphs?
Yes, paragraph 93, where I refer to when Trent was arrested, a cell phone was seized in terms of section 23(1)(a) of the Criminal Procedure Act, which provides that, I quote, on the arrest of any person, the person making the arrest may, if he is a peace officer, search the person arrested and seize any article referred to in section 20, which is found in possession of or in the custody or under the control of the person arrested. So this is commonly referred to as a warrantless arrest, because normally a search and seizure is done in terms of section 21 of the Criminal Procedure Act, where a normal search warrant is applied for to search and seize and download the information. But now there are two provisions, the one that those that are referred to as warrantless Section 23(1)(a) is one of the warrantless search and seizure of a cell phone. And at 94, the cell phone was booked into the SAPS 13 and handed to the cybercrime unit for downloading. I was later informed by the investigating team that the cell phone was successfully downloaded, and I was provided with the downloads. In 95, what was found in the download is quite shocking when one considers the fact that McBride and O'Sullivan labeled themselves as corruption fighters. And I indicate there that I do not list the contents of the download of Trent's phone in order to preserve the integrity of the evidence, taking into account the undertaking made by the NDPP to the chairperson that the decision to delay the enrollment of the case is to be reconsidered. I only refer to the content of the download, which serves as evidence of criminal conduct, and those which I referred to, or the facts which I referred to under the charges that I preferred against Trent and others in the draft indictment. And I may add that also the prosecution, draft prosecution memorandum. In 97, I say the following are examples of the types of activities identified in the cell phone. 97.1, there were discussions about Patlani's arrest. 97.2, the inquiry by Trent, who directed to Matlangu regarding the success of the operation at Patlani's place. Now, in this regard, there was a search warrant. I think I followed Nkabinde's evidence before this committee, where he said they obtained, applied and obtained a search warrant to go and search General Patlani's house, but the intention was not to actually confirm the sound system, but it was to confirm what was inside the house. So after the search, Trent and Matlangu did discuss about the success of the operation at Patlani's place. Before the search commenced, McBride leaked the search to the press. In a communication with Trent, Trent asked McBride, who leaked the information to the press, to which McBride replied that it was him. Similarly, after the search was concluded, communication between Trent and Mandla Matlangu showed that they in fact misrepresented to the magistrate that they are going to search for the sound system. They were actually searching the whole house. That's what they said, that they searched the whole house. And that was with the intention of identifying inter alia, the air cons inside the house, the finishes inside the house, to provide to O'Sullivan. And then Mandla even asked Trent, how is Paul taking it? Then Trent said, she's taking it brilliantly. He's even on his way to get a Guinness. So a Guinness is some kind of a beer. So that is the disregard of a person's privacy that they were prepared to go to lengths to violate. Then at paragraph 97.4, I set out that Patrick Johnson causing problems for Mr. McBride on the Marcosin matter. So McBride sent an ID number to Sarah Jane Trent and requested Sarah Jane Trent to get the credit record of Patrick Johnson because Patrick Johnson was the one who was causing problems for McBride on the Mkhwanazi matter. So there was apparently a case against the McBride where the witness was Patrick Johnson. So they wanted to deal with him. And then they continued that his false matric certificate must be exposed and suggest that rather Sarah Jane Trent and Paul tip off on the guy than McBride because it's going to be seen as revenge if McBride tips off. And then I note there that Marco Singh was a witness against McBride in a certain case. And I note there that this is exactly gratification in terms of the preca, because there was what we call a quid pro quo, value for value. So there was this issue of IPID helping or assisting Trent and Paul O'Sullivan to get back at General Patlani in order to have him not or suspended or dismissed. On the other hand, McBride now was getting all these favors. His problems with people like Patrick Johnson were resolved. So this is corruption within the meaning of PRECA. 97.5, Nhlanhla trying to get rid of me again. There was a discussion of a counter-attack when Minister Nhlanhla tried to reinstate the case against Mr. McBride. So this also constitutes a gratification because there was plans of a counter-attack. Minister Nhlanhla's information was accessed by Sarah Jane Trent, and then there was a report on the media that they leaked, which said 30 million rand Nhlanhla house, alleging that Minister Nhlanhla had built a house to the value of 30 million rand. And I note there that this is also a gratification as there is quid pro quo, value for value. And then the other gratification was of McBride regarding a polygraph test which was arranged and paid for by O'Sullivan. Now, in this regard, there was a meeting which Nkabinde referred to on the 3rd day of December 2016. This meeting, Nkabinde attended.
Is that the one at Kretsch's house?
Yes, the one at Kretsch's house. After the meeting, I think about a week thereafter, the meeting was leaked to General Mkhwanazi. Now, General Mkhwanazi opened a treason amongst others, a docket. So when they heard about this from the media, they started to panic. I'm saying this in light of the fact that it was said here before this honorable committee that no, the meeting was about a bride, then later a meeting was about the launch of a book. I mean, if it is an innocent meeting, why do you have to panic and said you are going to counter the allegations by Mkhwanazi, and then they devised a plan in which to say that McBride and Mkhwanazi must go for a polygraph test. But before going to the polygraph test, they invited, rather they arranged that Paul O'Sullivan is the one who is going to provide questions to be asked at the said polygraph test. Fortunately, General Mkhwanazi withdrew from that polygraph test. But here I'm saying that this also constitutes gratification, because other than McBride being gratified by this arrangement, arrangement of a fake polygraph test, other than that, Trent and O'Sullivan are the ones who paid for this polygraph test. And we have invoices in the docket. We have a bank statement that showed that they are the ones who paid on behalf of McBride. And then 97.7, I deal with several instances where Trent was compiling Section 205 requests and receiving the information from IPID members when it was provided by banks and cell phone network providers, despite her not being a member of IPID, which is a contravention of the provisions of the IPID Act. I also refer in 97.8 of several instances where Trent and O'Sullivan accessed credit bureau records of several people, including witnesses against General Patlani. In some of these witnesses, she is requested by Mr. McBride to do that. On one instance, McBride leaks an ID number of Alvin Dupree. Alvin Dupree was Patlani's driver and a witness in their matter. So he leaks an ID of Alvin Dupree to Trent and instructs her to find anything strange on his credit record, which may suggest that he doesn't require. The reason for that, they wanted Alvin Dupree to confirm a draft statement which implicated General Patlani. So Alvin was refusing to confirm that. He said that, no, that is false. It must first be amended. So that is why now they wanted to get his credit report, probably in order to have leverage against him. And I note there that IPID had no mandate to investigate private citizens, even a minister. And paragraphs 97.9, I refer to the legislation dealing with the accessing of credit bureau information. And Chairperson, I have already dealt with this before, the national provisions of the National Credit Act.
So just while we pause there, you also deposed to substantially the same matter before the Zondo Commission of Inquiry. You also deposed to a lengthy affidavit, which contains substantially the same allegations, submissions. And we also know that Mr. O'Sullivan had also deposed to an affidavit to the Zondo Commission, essentially contesting your submissions, your allegations.
Yes, what happened is that at the commission, there was a provision that the affidavits by the witnesses must not be supplied to any other person. So we had to send them to the commission. Now, O'Sullivan, when he made his affidavit, he does not only send it to the commission, he sent it also to me, because it contained insults and threats and all those things. So he wanted me to know what he's saying to the commission.
In fact, your affidavit was only released to this committee upon application to the NPA to release your Zondo affidavit and the annexes to us.
Yes, it was released because the Honorable Chairperson wrote a letter to the Department of Justice requesting that they release that to me. They could only release it to me because of the confidentiality consideration.
Okay. Then perhaps if we could just perhaps fast forward to at paragraph 106, you start dealing with the plethora, what you call the plethora of threatening and insulting emails from O'Sullivan, which you regard as interference. You want to highlight some of them?
Indeed, so, Honorable Chairperson, in an email dated 4 November 2017, a copy of which is marked as Annexure MM7, where O'Sullivan stated, amongst others, not Flock, Mlochwa, Mabula, Korani, Ngube, Mashuha, or any of the scum out there can survive what is coming. Good will triumph over evil. It always does. Then in an email addressed to me dated 4 November 2017, copied to several people, O'Sullivan inter alia accused me of having meeting with criminals and that I and the Northwest crooks are all guilty of theft of Sarah Jane's phone, unlawfully sending it to Israel. Andries brought it back last Friday and was seen at the airport by one of my people and unlawfully downloading the contents, not only a breach of a constitutional right since there was no search warrant in the first place. Yes, this is also a breach of Act 70, which carries a 10-year sentence. A copy thereof is marked, is attached as MM8.
Yeah, that's at page 74 of the paginated papers, MM8. MM9 you have now provided because it was missing from the statement and the annexes printed yesterday.
Yes, in fact, it was provided today after we were informed that it was missing, but I will provide it.
Yeah, you did.
I will ask copies to be made there.
Okay.
And in an email addressed to Mkhwanazi is the DPP, dated 15 November 2017, he states, the latest criminal suspect I need to bring to your attention is Advocate Mashuha. A copy thereof, marked as Annexure MM9, is attached. And then in 2 emails addressed to me on 30 November 2017, one of which was addressed in the early hours of the morning at 1 a.m. He inter alia refers to me as a criminal that broadcast for the Patlani family, being dishonest, protecting criminals and being rubbish. In particular, he indicates that he himself will deal with me. And in the second email, he states as follows, people that protect criminals like this are the lowest form of criminals. In fact, he was not referring to me where he said criminal that bought cars for Patlani. I think he was referring to one of the suppliers. And then emails from O'Sullivan to me on 6 December 2017. In the email at 2 p.m. he states, hey, you dishonest prosecutor, why don't you lock these 2 crooks up and the photograph of Nhlanhla and Phatlhane was inserted. I'm closing in on all of you. You will rot in jail. So the list goes on and on. But what I want to draw to this committee, what I want to draw to this to the attention of the
No, I'm just saying that you will rot in jail.
Indeed, so Chairperson.
Is a phrase familiar with this? Yeah, Nkabinde, when he was here appearing before us, he also showed us a message with that phrase, you will rot in jail.
Yes, indeed. So, but now the issue here is that conduct of his, first of all, constituted contravention of Section 32, 1B of the NPA Act, which prohibited anyone from hindering or interfering or threatening a prosecutor. And also it constituted extortion because remember I was prosecuting him. So his email were to the effect that because you are prosecuting me, then I'm going, there's one which said that he has gone to Northwest to dig information about me in Northwest, and what he's getting is concerning or something like that. So this is extortion. You are saying just because the prosecutor is prosecuting me, I'm doing a revenge by investigating him. That is exactly extortion.
So, Mr. Mashuga, the whole trail of emails and insults that you describe continues throughout the whole of paragraph 106. And you also conclude at paragraph 107. Similarly, Phatlhane was subjected to a plethora of threatening, insulting, demeaning, and intimidating emails from O'Sullivan. Such is dealt with in this affidavit to demonstrate the kind of character O'Sullivan is, and yet officials of an institution that is supposed to be independent and impartial. That's a reference to IPID.
Yes, indeed.
Allowed such a person to actively participate in the investigation against Phatlhane.
Indeed, that is the submission I make.
Can we move on to the next topic?
Indeed, so.
Chairperson, can I ask for a short comfort break? 2 minutes. A short comfort break.
Time is it now?
It's 12:37.
5. 1. As I'm checking, it's just 20 minutes before 1. Are we unable to push before 1 and break at 1? We can allow you to go out and come back without, if you really want to go out. If you want to go out with the witness, you can call him.
No, I don't want to go out with the witness. I just wanted to move on to the. I'll be 2 minutes. Thank you.
Yeah, let's check something.
Chair, we respect the elderly.
That's exactly what I'm saying. That we can't be asking him many questions. Yeah. Skosana.
Yeah. I just saw something here.
You will rot in jail.
Yeah, I just saw something because the The evidence leader is not around. I'm taking the page 79, which he was talking about here. The more I deal with low lives, dishonest people like you, the more I love my dogs. Hey.
But did you pay your debts?
I'm sorry?
Did you pay your debts?
Che, wait for tomorrow. Wait for tomorrow. You'll see spark will fly. When somebody's lying before this committee, you will suffer the consequences.
So, but you're not a witness before this committee.
No, but he must answer. Remember, Che, tomorrow I'll give you the proof of payment.
Honorable
Thank you.
No, Chair, I'm just taking advantage of the break. I didn't want to interrupt. If maybe Africa Mashucha, that polygraph test, what was it about? I keep hearing this thing that they paid for a polygraph. Why was Mr. McBride taking a polygraph test?
In fact, it's connected to the meeting of the third. So where invitees like Mandla Matlangu, McBride, Nkabinde, Cedric Nkabinde, all those people that were invited there. There was a certain Angelique Serrao or something like that. She was a journalist. Also, Mr. General Sibia was invited. So the invite said, Bry, 3:00 p.m., Bedford View, then they gave the address, then top secret. It was listed as top secret. I'm saying this to say that if it was just a launch of a book, I mean, there's no reason for it to be top secret. Or if it was a braai, there's no reason for it to be top secret. And then secondly, I'm saying that if it was an innocent braai or launch of a book, why would they be so concerned about it when there was a leak about that meeting? So it corroborates the version of Cedric Nkabinde that actually that was a planning meeting where they planned to take over the criminal justice system by having, for instance, the removal of General Patlan. So after that, the discovery or the leaking of that meeting, they came with a plan. O'Sullivan and McBride and Trent came with a plan that they must refer the matter for a polygraph test to show who is telling the truth between Mkhwanazi and McBride. So that is when they arranged, they made pre-arrangement that O'Sullivan will provide questions so that McBride can go there knowing the questions already, and then Mkhwanazi would be disadvantaged. And then media must be invited to that so that everything should seem to be above board. So the invoice to the polygrapher was paid by Trent and Paul O'Sullivan. We have a statement of the polygrapher in the docket. We have proof of an invoice and a bank statement which showed this. And we submit rather, I must say, we preferred those charges in the draft indictment of corruption in contravention of section 3 and 4 of PREC.
Yeah, thanks, Chair. I suppose then it was just their own polygraph. Thank you, Chair. Through you, Advocate, we were respecting your break. I was just curious about who demanded a polygraph. How did we get to polygraph? Thank you.
May I proceed, Honorable Chair? Thank you. Thank you for the...
You are allowed.
I'll be right for the next derby. Advocate Mashucha, you then, in the next section that we're dealing with, although you've dealt with it quite extensively already, you allege the capturing of IPID by O'Sullivan and Trent. If you want to, you reference that by the evidence at paragraph 111 or 111. The evidence clearly demonstrates that Trent and O'Sullivan even went to the extent of preparing Section 205 subpoenas and statements which were presented as if they were compiled by IPID officials. Such conduct was embraced by the late Nhlanhla and Binang, which is clearly wrongful, unlawful, and unprofessional conduct. And you describe that conduct as highly irregular and unlawful. Do you want to make any further comments on that section?
Indeed, so, Honorable Chairperson, here we are referring to, again, to the contravention of the IPID Act, where Trent and O'Sullivan were allowed by IPID to use powers which belonged to members of IPID, not to the private citizens. The main concern that we had whilst we were going through this investigation was, how does IPID disclose or allow a private citizen to access information that is supposed to be confidential, whilst that private citizen is, unlike IPID members, not subjected to a vetting exercise? What if that person is a threat to the security of the state, and then they are allowing that person to exercise the policing powers and exercise people's bank statements, people's cell phone records? That was the main concern, and that is why I make this submission at paragraph 111.
So if we come to the matter itself, we know now that the matter was removed from the roll.
Indeed, so.
Yes, and you obviously protested that it shouldn't, and the magistrate nevertheless ordered the removal of the matter.
Yes, I did indicate, I think that the matter had only started in February, and 8 November, it was struck off the roll. We were initially prepared to proceed with the matter, but then came the downloads, and the downloads now forced us to do some investigations and identify and obtain warning statements from more or additional suspects. Now, one of the things that was raised previously by Mr. Paul O'Sullivan and Mr. McBride was, why did we effect an arrest before we finalize investigations? But the question, we answered it very simply. The nature of the charges and the conduct, criminal conduct that was being perpetuated by Trent and O'Sullivan required us to act immediately. Because if a person is going on intimidating witnesses, then there's a need to urgently deal with that situation. That is why upon information that he is intimidating witnesses, we had to deal with the agency that was required even before the investigations were completed.
So on at paragraph 116, which is on page 51, on the 8th of June 2017, you were approached by one Masha, is it how do you pronounce it, Rapesu?
Yes.
An IPID investigator who was part of the Paslani task team. He was instructed to obtain a statement from you regarding inter alia why you signed the warrant of arrest of the accused. So that statement that you made is at triple M 14. You want to comment on that at all?
Yes, Chairperson.
Triple M 14
yes.
Is at, I think it's page 80. It's at 86. It's at page 86.
Yes. This statement, Rapesu, who was one of the Patlani task team, was instructed by the DPP office to go and obtain an investigation a statement, from me as a result or pursuant to a case docket that was opened by Sarah Jane Trent and O'Sullivan, where it was alleged that where she was alleging that her cell phone was stolen and she was kidnapped. And we knew that the cell phone was obtained in terms of section 23, subsection 1A of the Criminal Procedure Act. And we knew that she was detained in the cells. So, however, the persons dealing with the advocates who dealt with the matter instructed that Rapesu must obtain a statement from me, and the questions which they asked and they wanted to be addressed were, number one, who is the prosecutor who signed the warrant of arrest? But it was already known in my office that I'm the one who was dealing with that case. I'm the one who signed the warrant of arrest. An affidavit must be obtained from him wherein he states why he signed the warrant. And I'm saying here that this is internally, this could have been resolved internally because we are in the same office. They could have just come to me and asked me, did you sign the warrant? Why did you sign the warrant? I would have given them the docket to say, go and read the docket. Was a docket presented to him? If not, was any information relayed to him? If so, what information? I mean, this is all information that they could have easily obtained from me rather than creating a situation where a DPP office, because at the DPP, we issue correspondence to external parties in the name of the DPP. So even if something is signed by a deputy director, we issue it in the name of the DPP. So now a situation was created where a DPP was telling a third party to come to the DPP and obtain a statement from the DPP or information from the DPP, which could have been easily resolved. But I made that statement. It's there in MM14. I didn't want to cause some consternation or
Yeah,
whatever.
you were requested to make another statement at MM15.
Indeed so.
Which is at page 92. But wasn't that pursuant to, you also attached, it's at the back of MM15 on page 94. This is now in relation to those two charges that were brought, or these cases that were instituted by Trent.
Yes.
The Sandton case and the Littleton case.
Yes.
The abduction, assault, removal of the kidnapping. So on the 20th of June 2017, is this why Masha from, it's addressed to the IPID, R. Masha, decision on the two dockets, Sandton case number, that Littleton case number, your memorandum dated 24 April 2017. The Director of Public Prosecutions remarks as follows. The following must be done, obtained. Advocate Mashuga states in his affidavit that there was an interdict against Mr. O'Sullivan. A copy of this interdict must be obtained and filed in the docket. 1.2, a supplementary affidavit must be obtained from Advocate Mashuga, wherein he states if he was aware when he signed the warrant of the court order, Littleton case number. Kindly return the case dockets together with the requested information.
Yes. So in this one, in this regard, Chairperson, I did reply to them that the interdict that I'm referring to is an interdict where the applicant was Mr. Neil Diamond, and Mr. Neil Diamond had instituted this application against Mr. O'Sullivan for similar matters, which are intimidation and attempted extortion. So we were using that case to oppose the release of Mr. O'Sullivan on bail. So that is why I was requested to provide the copy of that interdict. In terms of clarifying if I was aware of the court order when I signed the warrant, is that court order which said that Mr. Paul O'Sullivan must be given 48-hour notice before he's arrested.
Is that the judgment of Judge Duckton?
No.
Or Prinsloo?
No, it's the judgment of, I think, Deputy Judge President Ledwaba.
Yeah.
Yes. So he gave that order, but
thank you.
it was a settlement order, and NPA was not part of the parties that were ordered. It was only the SAPS and some other people. NPA was not part of that settlement. So I could not have been aware.
So you weren't bound by that order because you weren't.
We weren't bound. And remember that order did not interdict the NPA or the magistrate from being involved in the issuing of a warrant of arrest. It was the police who could be held responsible if they knew that this order existed, because each and every day the courts make orders. So you cannot just say, just because there's a certain order that was made against the police, then the prosecutor should know about that order.
Okay. You were also subsequently, there seemed to have been a gap because then at paragraph 119, you referred to October 2019 when you again approached by IPID to obtain another statement, which is at M17 on page 99. To obtain a statement where you were questioned on why you gave questions to your investigating officers to seek clarity from section 204 witnesses.
Indeed, so, Chairperson, there was this occasion on the 31st of October where I provided a statement where the inquiry was for what was the exact purpose for me providing a list of questions to Brigadier Ngube and General Mabula. So, as we have, I have already clarified, this prosecution was a prosecutor-guided investigation. So, we already had information from the downloads by then as to what was the role played by different suspects. And now, when the 204 witnesses approached the investigating team, showing their willingness to cooperate and to become state witnesses, I wrote several questions that were supposed to be addressed to the 204 witnesses, one of which was whether they are giving their cooperation independently without any undue influence.
Now, it appears from the documents that you attach, Advocate Mashucha, that there was some tension, put it mildly, between IPID and the DPP office. Look at page 101, I think it's M7, page 101. It looks like M17, dated 21 July 2017. This is from the Director of Public Prosecutions, and it's addressed to the Brigadier Ngube, Northwest Provincial Head, complaint against the office of the DPP and IPID members interfering with exhibits handed in on Camille Drift 12/01/2017. So that's about the cell phone.
Yes, indeed, so, Chairperson. It's about the cell phone.
It says the cell phone that the DPP letter seeks to obtain from the investigators form parts of court exhibits, and the NPA has no right to order that such exhibits be disposed of. You are not authorized to dispose such court exhibits to anyone except through an order of court. That would amount to defeating the ends of justice. You must give this letter to Colonel Mike Sales, who must take note that he is not allowed to dispose of such court exhibits unless he gets a court order. And this is issued by Mr. Nemarani, Deputy Director of Public Prosecutions. And that is then followed by a letter at page 102, referring to the case, and it is a lengthy letter that's written by at the time Brigadier Ngube, dated 21 July 2017 also. And I'll just summarize, and obviously you can comment at page 104, paragraph 10. You got it there? Just summarizing the gist of the letter. It is my view that the DPP instruction concerning the handset of Ms. Sarah Jane Trent was not correct, and it thus compounded the problem. I wish to state that any attempt by any member of IPID or the office of the DPP to remove the exhibit will be seen as an attempt to defeat or obstruct the course of justice, and the necessary criminal case will be opened and investigated.
Indeed, so, Chairperson, in this regard, there was a discontentment that I could detect from the advocates who were dealing with the charge, with the docket that was opened by Sarah Jane Trent and O'Sullivan. So you can see from the instructions that they were given by the same DPP office, who most of the information that they wanted here, it was very easy for them to come to my office and ask me about all these things. Were you the prosecutor who signed the warrant? Yes. Why? What information did you have? I could have given it to them. There was no need. What happened to the cell phone? Was it? Is it at the SAP 13? I would have said yes. We are still waiting to download it. But they went around, gave their own instructions. So this now created a situation where it seems that there was a tension.
Yeah, there appeared to be the tension between the Camildrift case, which you were prosecuting, and the Littleton and Santon case, which was the complaint of Sarah Trent.
Yes,
especially relating to alleged kidnapping, assault, and taking of a cell phone.
Yes, and I must state that other than this instance, generally the DPP office functioned normally without any tensions. But I was also surprised at this. Actually, I even approached Advocate Eric van der Merwe after this and asked him what was the problem with him, and what he said was that, or rather, must I say, he was apologetic about all this.
Now, you do reference the memorandum, which is authored by Van der Merwe and Van Jaarsveld, dated the 31st of May 2017, which presumably informed this request by IPID to secure some, or to obtain some affidavits from you, and that you reference at page 1 of triple M19 on page 105. You got that?
Yes, I've got it.
So you can see on page 105, memorandum dealing with the prospects of a successful prosecution of certain members of SAPS. Both the case dockets, Littleton and Santon, relate to the unlawful arrest of Mr. O'Sullivan and his assistant Trent. And then there's a heading with the Littleton case. O'Sullivan was at his office in Johannesburg when a traffic officer came to his office and rang the doorbell and asked him to let him in. She told O'Sullivan that his car was involved in an accident and she's there to investigate. Sullivan refused. She left. This is confirmed by Trent. And then it goes on. Then you are then referred to Advocate Mashukha. There is a transcript of the conversation I'm reading from the bottom of page 105. There's a transcript of a conversation between Spies and Ngube, as well as printed photos that corroborate the complainant's version. Brigadier Ngube apparently applied for the warrant of arrest, the A13. It is not clear, based on evidence that this application was made, it is not clear at this stage whether the person who signed the warrant on behalf of the DPP had any information, evidence available to him, and if so, what. It is not clear who signed the warrant. According to the tape recording, it is Advocate Mashukha. In the directions to the investigating officer, the following was requested: a statement from Willie Spies, the docket in respect of the charges against O'Sullivan supplied by Advocate Mashukha must be obtained. A statement should be obtained from Advocate Mashukha. Although it does not matter why the warrant was issued in the first place, as the main charge should be contempt of court, it is advisable that this information be obtained. So that's in relation to the Littleton matter. Then there's the heading prima facie cases, contempt of court, in that O'Sullivan was arrested despite the court order being shown and explained to them. It will also be able that they were, even before the issuing thereof, aware of the court order, as it was in the public domain and issued in one of the matters where the same investigating team is involved. In this regard, the following is apposite. Prosecutors and police officers are in the employ of the state and have a public duty not to violate a person's right to freedom. It is a fundamental right to an accused not to be detained arbitrarily and without just cause and interference with physical liberty without justification. Then there's a reference to the kidnapping. If no valid warrant of arrest existed, that appears to be the case, it will be easy to prove that the facts of this matter warrant a conviction on a charge of kidnapping. The show of unnecessary force will also be a deciding factor in this regard, and a charge of intimidation will most probably succeed. The fact that the warrant of arrest was requested by an advocate purportedly from the DPP's office will also be of no avail, as there is no evidence to infer that the prosecutor and the arresting officer acted within the authority conferred by a power in question, which in turn requires him or her to take all reasonable precautions to avoid or minimize injury to others. A failure to do so would render his or her conduct unlawful. Fraud and defeating the ends of justice. Then there's a reference to the suspects on page 107, Brigadier Ngube and Colonel Dawood. This involves the arrest of Trent, complainant at the office of O'Sullivan after he left. This is the same day that the traffic officer came to the office. Someone came to the office and arrested her, whereafter she was taken to a Shell petrol station where she met Colonel Dawood, who cuffed her with cable ties. According to her, the arresting officer was Brigadier Khorani. Ms. Trent was kidnapped and kept in isolation at various places without her rights being properly explained. Her cell phone was also stolen from her and illegally tapped. A warrant for arrest was never shown to her, and she was not afforded the opportunity to contact her relatives or lawyer immediately. The show of force with which she was arrested also paints a clear picture and was totally unnecessary if a valid warrant of arrest on a valid charge was available. It is, however, questionable why an arrest was necessitated on the alleged petty charges. A summons would have sufficed. The possibility that there was no warrant of arrest should be investigated. It appears she was arrested on a whim after O'Sullivan could not be arrested. Then there's a reference to prima facie cases. According to the authors of this document, kidnapping, theft of the cell phone, intimidation, suspects, Colonel Dawood and Brigadier Khorani. The OB books and the register from Camildrif SAP station should be obtained in order to establish who booked her in. This is then the recommendation. Colonel Dawood appears to be a suspect in both dockets. Brigadier Khorani and Ngube appear not to be involved in both dockets. It is possible to investigate further links to connect the various accused and maybe even others in one case. However, the matters can also proceed separately, and action can be immediately instituted despite the further outstanding investigation. The dockets already constitute prima facie cases. Advocate van der Merwe and I are therefore of the view that prosecution must be instituted in the regional court. I am aware and have been informed that the decision cannot be made by me and will be taken at another level of authority. I make it clear that in my view, a failure to prosecute will be an injustice to the complainants and the public at large. If it is decided not to proceed with prosecution for whatever reason, care should be taken that the decision will withstand the requirements of noli prosequi certificate. The possible delictual liability of both NPA and SAPS should also be taken into account. So that was signed on the 31st of May by Senior Advocate van der Merwe, DPP Gauteng, and van Jaarsveld, DPP Pretoria.
Indeed, so.
So it's this letter that really gave rise to you being requested to make these further affidavits which you've referred to.
Yes. I would just like to draw this honorable committee to 3.1 and 3.1
of the annexure.
Yes, of the annexure.
Yes, on page 107. 3.1, under the subheading suspects.
Suspects.
Brigadier Ngube and Dawood.
Number 4 from the book, line number 4 from the bottom, which start with, it is however questionable why an arrest was necessitated on the alleged petty charges. So are these petty charges intimidation of witnesses, intimidations of persons like just the intimidation of any person, including the acting national commissioner of police? Can you really say those are petty charges? So that is why I'm saying there was some animosity against me in relation to that matter. That is why my docket was referred to as petty charges. And secondly, paragraph 2.2 on the previous page.
Yeah.
The fact that the warrant of arrest was requested by an advocate purportedly from the DPP's office will also be of no avail, as there is no evidence to infer that the prosecutor and the arresting officer acted within the authority conferred by the power in question, which in turn requires him or her to have taken all reasonable precautions to avoid or minimize injury to others. A failure to do so would render his or her conduct unlawful. They are speaking about me. They are supposed to be colleagues. So they are attacking me, even saying that my conduct was unlawful. Remember, they do not have the docket. They do not know what is in my docket. And we now know of the charges of the misconduct of what they had committed. That is why I'm saying that there was an animosity from their side. That is why they could even instruct that our suspects who were part of the Patlane investigation task team should go and obtain a cell phone, which is evidence, which is in the SAP 13, evidence exhibit that was supposed to be downloaded. So once they got hold of the docket, then there would have been a break in the chain of custody. So
there was a
Oh,
clear-
sorry, Chair, I've just had my hand up. If the advocate can speak closer into the mic, and I don't know if I didn't miss the first part of your response, advocate. It was very strong, but you were on a roll, so I didn't want to interrupt. So if you could just, that first part and that first part section that you read, because I missed it, please, Chair. And please speak louder because you're allowed to scream in Parliament.
Thank you, I will do it.
Well, not scream, but talk loud.
So what I was referring to is that my docket was referred to as containing petty charges. And I reference here the paragraph that says, it is, however, questionable why an arrest was necessitated on the alleged petty charges. So these serious offenses that I consider as serious were referred to as petty charges. And secondly, there was an attack on me because of this quotation here. The fact that the warrant of arrest was requested by an advocate purportedly from the DPP's office will also be of no avail, as there is no evidence to infer that the prosecutor and the arresting officer acted within the authority conferred by the power in question, which in turn requires him or her to have taken all reasonable precautions to avoid or minimize injury to others. A failure to do so would render his or her conduct unlawful. That is referring to me. So I was being attacked here for doing my job, studying the docket, deciding that people should be charged. In fact, this case that was opened by Sergeant Trent and O'Sullivan was not prosecuted. The DPP declined to prosecute simply because the cell phone was seized in terms of Section 23(1)(a) of the CPA. So the police were allowed, upon arrest of the accused, to seize the cell phone, number one. Number two, Sarah Jane Trent was arrested and taken to the cells. You cannot say a person is kidnapped when he is taken or he or she is incarcerated in the cells. So that is one of the reasons why the DPP declined. And then there was a representation from IPID after the Nole prosecute to the NDPP. And the NDPP also confirmed the decline to prosecute. Thank you.
Okay. You referenced the fact that at paragraph 122 on page 53 of your affidavit that Mr. O'Sullivan also wrote an affidavit to the Zondo Commission of Inquiry, and that's at triple M 20.
Indeed, so Chairperson.
Yeah, you want to highlight or emphasize anything there?
Yes. The reason why I annexed the previous annexure, MMM 19, was this M19 was in the hands of Mr. O'Sullivan. So this is an internal memo. This is an internal memo of the DPP office, but it was leaked to Mr. O'Sullivan. And that is why I also reference MMM20, which is the affidavit of Paul O'Sullivan to the Zondo Commission. And I reference paragraph 31 thereof, which is the second page of the exhibit. And it says that, I say that Baloi's decision was unlawful because I was able to get a copy of a letter jointly signed by 2 senior deputy directors at Pretoria Regional Court who had made a decision that the Mabula squad should be prosecuted on a whole raft of charges, including kidnapping of Trent and theft of Trent's mobile phone. I attach a copy of that letter as Annexure POS 3. Now, importantly, he says here, the memorandum was leaked to me by a whistleblower in Baloi's office who knew that Baloi was up to, but was afraid to speak out. Since the copy I have is hard to read, I have taken the liberty of typing it out verbatim for the benefit of the Commission. The typed version is attached as Annexure POS 4. I request that the annexes be read as if specifically incorporated herein. I now wish to draw the Commission's attention to the following extracts of the memorandum, as the extracts show that the Mabula squad and Mashuga acted with common purpose. And he references the same extracts of the same memorandum that we spoke about. Sure. And just to be clear, Baloi's office, he was referring to the DPP because Advocate Baloi was the acting DPP of DPP by then.
Okay,
So-
let's take Honorable Sangon.
Sorry. Chair, I feel so stupid asking this question, but I think I must ask it. When we talk about the kidnapping and the arrest, is it one incident?
Yes.
Like, is the kidnapping and the arrest the same thing? So others call it a kidnapping, others call it an arrest.
Yes.
That's where the cell phone was seized.
Yes.
Oh.
We are taking a break at 1:30.
Thank you, Chair.
And then we will come back at 2:00.
Not going to go into extra time. Advocate Mashuga, so the affidavit of Sullivan triple M20 that you reference is to illustrate your point that there too appears to be an infiltration because he gets hold of this internal memorandum, which is triple M19, which we've dealt with.
Indeed, so Chairperson, there appeared to be an infiltration because this memo was made and then he got hold of this memo and then he says in triple M20 that someone in the DPP's office leaked the memo to him. So that shows that he had infiltrated somehow the DPP office because now he was being provided internal memorandum of the DPP office.
Okay, just then before the break.
What is happening is somebody coughing? You must not choke because South Africa is playing this afternoon and we are known as chokers on an international stage.
May I continue?
Was choking, Chair, not joking, choking, like literally.
That's what I'm saying, choking.
Oh, okay.
Not joking, choking. Yeah.
It's Action SA and PA that's choking me.
Angasita, do you want to say something?
Yes, thank you, Honorable Chairperson. If I'm ahead of the evidence leader, I will apologize. I was actually asking for the explanation with regard to the content of paragraph 118. The 48-hour order. What does that mean? I mean, that Mr. Paul O'Sullivan should be informed, should be given 48 hours notice if he was going to be arrested. Is this a norm?
He obtained a court order to that effect.
Yes, thank you, Chairperson. Yes, he had that order. I do not have a copy, but I know of the contents because I saw it during an agent application that was launched on the date of his arrest. I had to attend to that agent application in the evening. So the order is very clear that before an arrest is made on Mr. Paul O'Sullivan, he must be given 48-hour notice. We were also concerned about that because it means that if maybe, for instance, Paul is committing a very serious offense, the police must first come and give him a notice. So we were very concerned about the effect of that 48-hour notice order.
Thank you, Chair. I don't think the advocate has responded on this Honorable Mkhwanazi's question. He was asking if that's normal in a simple term.
Well, I would say it is an extraordinary order, but as far as I remember, it was a settlement order. The persons who were, the parties who were cited there were the police and people related to the police, and then the NPA. The NPA did not become part of that settlement order. But on the police side, they are the ones who are settled. So it is a settlement order, meaning that it was agreed between the lawyers of Mr. O'Sullivan and the lawyers of the SAPS.
In other words, we are saying it's only on that occasion. But now, if he has to be arrested now, you don't need 48 hours.
No, it is not only on that occasion. It is perpetual until it is rescinded. It applies.
Even now?
Yes, it applies in any matter. The words I remember that I used there are that in any matter where the police have taken a decision to arrest the applicant, they must give him 48-hour notice.
Then we don't have a judiciary chain in this country. Thank you.
Can we break?
It's on the same matter about the arrest, Chair. It's just clarity.
Okay.
Advocate,
just wait a moment. Honorable Matthews, Honorable Klopa, Honorable Sangon, and who else? The list is closed. Yes.
Thank you. Advocate, please tell us who in SAPS was part of this settlement order. Do you know? And then if not, Chair, I'm going to suggest that we urgently write to SAPS to send us a copy of that settlement order so we can see whose signatures were involved in that. And was it through SAPS National or Gauteng SAPS? Do you know how it?
The settlement order would only contain the legal representatives who were representing them. So they will be the ones that you can get the names of. But obviously you can obtain the information from the SAPS, from their records as to who ordered or who gave the instruction that the matter be settled in that manner. Sorry, Honorable Mathis.
The other part of the question was, I'm not sure, but you clarify, would it have been something that was done from a provincial level or from a national level? How would it have worked?
It would have been done from the national level because the parties that were cited was the national commissioner and I think General Patlani was also cited. Yeah, there were some parties that were cited. Yeah.
Honorable Taupa.
Thank you, Chair. I'm partly covered by Honorable Matthys. I just didn't hear correctly. You said the NPA excluded themselves from this agreement, and it was only SAPS that entered into the agreement with O'Sullivan so that he cannot be arrested within 48 hours without permission or with notification.
Indeed, so Honorable, the NPA was cited, as far as I can remember, the papers or the order. The NPA was cited, but they did not agree or to the settlement, so they were not part of the settlement.
Thank you.
Honorable Sangwen.
Thanks, Chair. I think I'm also partly covered by the two speakers. I just wanted to find out, Advocate Mashuha, would you know what legal authority would have been relied on to be able to grant such an order? Sorry, before you answer, Chair, and then I was just going to request that, can we, I don't know if the advocate can assure us that he's got a signed copy of Advocate Mashuha's affidavit, because neither the electronic or the printed ones have been signed. Thank you, Advocate.
Application. So I do not know the facts relating to that, but that it was an application for an interdict. What I could infer from the two orders, because there was not only the one of arrest, there was also the one of a summons, which says that in the matters, and I'm subject to correction, in the matters before or dealt with by the police, the accused or the applicant must be brought to court by way of a summons. So paragraph 2 is the one that says, if it is decided that the accused, the applicant must be arrested, then he must be given the 48-hour notice. So there were those two. So it was an application for an interdict that was settled. So I do not know the facts supporting the same.
Honorable Chair, if I may assist, it is referenced by O'Sullivan, and it's at page 943 of his statement. It's an annexure. Page 943, and it's in a case number in the Gauteng High Court. Case number 75378 of 2016 in the matter between Paul O'Sullivan against the NDPP, Minister of Justice, Minister of Police, Lieutenant General Nhlanhla, Lieutenant General Shlameza, Major General Mkhwanazi, Advocate Mayema, Advocate Mlochwa, Warrant Officer Flock. This is the copy of the order. Having read the papers filed of record and by agreement between the parties, but without any admission of liability, and in particular without admission that the applicant is entitled to any relief in relation to Part A, an order in the following terms: any matter, including the charges being investigated under Pretoria Central Case number 380/4/2016, where the first respondent has taken a decision to prosecute the applicant and where a warrant of arrest has been obtained for the arrest of the applicant, the third, fourth, fifth, and sixth respondents. That is just third, fourth, and sixth. That's the Minister of Police, Lieutenant General Nhlanhla, Lieutenant Shlameza, Major General Mkhwanazi, undertake to afford the applicant 48 hours notice to present himself at a designated police station. In any other matter where the first respondent has made the decision to prosecute the applicant, the third, fourth, and fifth respondents undertake that the applicant will be brought to court by way of summons. In any other matter where the determination is made that the arrest of the applicant is necessary, third, fourth, fifth, and sixth respondents undertake to afford the applicant 48 hours notice to present himself at the designated police station. We'll make this order available again during the lunchtime. Is that what you were referring to, Advocate Mashucha?
Indeed so, Chairperson. That was what I was referring to.
If I may just round off just one matter which shouldn't take more than 2 minutes. At paragraphs before lunch, 123, 124, 125, you referred to Brigadier Shlungwani. Just summarize that quickly. I think that is because Shlungwani, you say that McBride testified in a case that involved him as an accused.
Yes, the reason I am including this paragraph about Brigadier Shlungwani was because it seems that there was some conspiracy against me in all matters, even those in which I wouldn't expect to be linked to Mr. McBride or Paul O'Sullivan. So I say here that I was allocated a case, State versus Mkushani, and I see I wrote 4, but it's 3 others by Advocate Andrea Johnson, when she was still a Deputy Director of Public Prosecutions in DPP Pretoria, where I charged 4 accused persons from crime intelligence, including a general who was a divisional commissioner, a brigadier, and then Brigadier Shlungwani, who was accused 3 in the case, and a colonel and a colonel. Shlungwani appeared before this committee as a witness, where he mentioned my name and made all those allegations that I treated him unfairly. In fact, paragraph 124, at some stage, Shlungwani was acquitted in terms of section 174 of the Criminal Procedure Act 51 of 1977, the decision which I launched an appeal against. So I drew up some papers and served the papers on him, but I resigned before the appeal was set down for argument. On 1 August 2024, Nhlanhla wrote an email to me demanding service of appeal papers which were delayed at the appeal clerk's office. He insulted me in that email, even stating that I did the same with the IPID members. And the only case that I was dealing with that was against IPID members was this Camille Drift case 12/01/2017. And I state that there that this is a clear interference with a prosecutor in terms of section 32(1)(b). And I also penned a letter of complaint to the DPP through my supervisor. And just to make it clear, the reason why I could not myself initiate complaints or open case dockets at that stage, I had information even from Paul O'Sullivan himself that they wanted me to be removed from the matter. I don't know where they got that information that if I'm removed from the matter will not be prosecuted. So they were hailing all these insults in order for me to open a case, and then they would run and say, I'm conflicted, I cannot be a complainant and a prosecutor at the same time. So I knew of that information. That is why I was not keen to rush to open dockets against them. But the evidence is there, the emails are there, so the evidence is there. I can always open a case at any time.
And that in summary was the reason why you didn't open a case or lodge a complaint, because you didn't want, that was a stratagem as far as you're concerned, to have you removed from the case.
Yes.
Because of a conflict of interest.
Yes, and I would like Chairperson to refer to the relevant annexure. So it's MMM 22, which says that the first email was on 1 August 2024 at 10:08. So Mr. Tiani Nhlanhla is here says, Dear Mashura, more than 8 months later, I still await the documents for your appeal. I have always avoided a confrontation with you during the trial, even when you blatantly lied and did your best to delay the trial, even when the late magistrate was still alive. Your aim and that of the people who give you instructions is to leave this thing hanging over my head. If I do not receive documents over the next 2 months, I will report you and your conduct supported by recordings to the leadership of the NPA. You did the same with the IPID members. Your aim is to harass people on behalf of those who give your instructions. You even mention things which have nothing to do with me in that notice of appeal of yours. You are disgusting for a prosecutor, man. You disgust me, man. You are despicable and disgusting. And then on the 2nd of August 2024, he write another email. Illegitimate son of a Northwest police officer. Bring it on. Stop playing politics. And
okay.
It's a Brigadier Nhlanhla who testified before you, before this committee.
Yeah, it's Nhlanhla at that page 120.
So this is a clear interference and hindering of the prosecutor, and it's a contravention of section 32(1)(b) of the NPA Act. These are the matters that I'm saying that I was avoiding to be conflicted. So now I'm going to follow them up with laying cases. And also on Mr. O'Sullivan, in some of his emails, he also made these suggestions, discriminatory suggestions that I am from Northwest, and the Mabula team is from Northwest. Those allegations in the emails.
Chair. What do you want to say, Advocate Aransa?
No, it's Honorable Chair, I was just looking at you to see whether you want to take the lunch adjournment or whether we should.
Honorable members will come back at 2:30.
Thank you. Between 30 and 45 minutes. Shouldn't be, we can,
Because we still have two more witnesses today.
yeah, I appreciate that.
So it's going to be a long night.
In fact, if I may proceed, Honorable Chair.
Uh-huh.
Thank you, Advocate Mashuga. Perhaps we could just move on to what the honorable committee members and all of us are quite curious about. What steps, if any, were taken to re-enroll the case? That you deal with from page 56.
Let's have the microphone on Advocate Masha.
Oh, sorry.
Page 56 from paragraph 129 onwards.
Yes, in fact, I deal with the reasons there. Under the paragraph, the steps taken to re-enroll the case. And I submit there that the case against Trent O'Sullivan and the two IPID officers was struck off the roll on 8 November 2017 in terms of section 342, capital A, 3C of the Criminal Procedure Act 51 of 1977. The section provides that, in brackets, if the court finds that the completion of the proceedings is being delayed unreasonably, the court may issue any such order as it deems fit in order to eliminate the delay and any prejudice arising from it, or to prevent further delay or prejudice, including an order. Subsection C, where the accused has not yet pleaded to the charge, that the case be struck off the roll and the prosecution not be resumed or instituted de novo without the written instruction of the Attorney General, in brackets DPP. The reason why there was a delay in the case was twofold. After downloading of Trent's cell phone, overwhelming evidence came to light which required the addition of suspects. I instructed the investigating team to obtain warning statements from the implicated individuals. By the next court appearance, I did not have the warning statements of all the individuals. In my opinion, there was evidence of a sustained, continuous, unlawful campaign to target Patlani and other victims. Trent O'Sullivan and IPID officers were an enterprise. They even had a WhatsApp group formed during the investigations against Patlani. I was of the view that their unlawful conduct constituted racketeering as envisaged in section 2(1)(e) and F of the Prevention of Organized Crime Act 120 of 1998. Only the NDPP could authorize the racketeering charges. So I applied for a postponement inter alia to engage in a process to request the racketeering certificate. After the matter was struck off the roll, I drafted a prosecution memorandum which, upon approval by the responsible Deputy Director of Public Prosecutions, would have been referred to the DPP for his authorization of the memorandum, and finally to the NDPP, who would grant a certificate if he agreed.
Have we got, sorry to interrupt you, Advocate Mashuga, that memorandum that you drafted, we don't have a copy of that memorandum.
No, it's...
Maybe we should also Sullivan.
It's still in internal office memorandum. As soon as it is approved, then we can have access to it.
And in that memorandum, you made it a case. You made it a case as described above, that the charges against him can be proved, and that the racketeering certificate is justified in this case.
Yes, in fact, because racketeering refers to a situation where the state has evidence of an enterprise. So an enterprise can be, maybe in this instance, IPID, where the activities were managed and the participation took place in. Or an enterprise can be an association of certain suspects by fact. So I was alleging in that memorandum that the enterprise was the association between Sarah Jane Trent and O'Sullivan and those relevant IPID members. They formed an enterprise which was which purpose was to target Patlane continuously in a continuing manner, because we have to also prove that there were 2 or more offenses that fall under Schedule 1. So we had that evidence that there was a pattern of racketeering in terms of the offenses being committed in a continuous manner. So we knew that other than continuously targeting Patlane, they also targeted the Minister of Police by then, their witnesses in the case. So there were about 9 individuals that they had targeted. So the charges, I think the indictment amounted to more than 80 individual charges against them. So I had evidence of racketeering.
At paragraph 133, you mentioned that due to the matter being a high-profile one, we had to brief the NDPP who was tracking all high-profile matters. Is that a reference to Advocate Sean Abrams, who was then the NDPP?
Yes, Advocate Sean Abrams wanted to be briefed on all high-profile matters. So we would have days where we were supposed to go and meet with him and brief him on the investigation.
But the decision to issue the racketeering certificate was the decision of the DDPP.
No. It was the NDPP who had to authorize it.
So when you briefed Advocate Abrams then, was he not persuaded that a racketeering certificate be issued?
No, it was, as far as I can remember, during the meetings, we were briefing him about their investigations, but he knew that he had to expect that at the end we might refer an application to him.
Because in paragraph 134, I don't know, is this a reference to Annexure M19 that we discussed earlier? That the responsible DDPP registered his uncertainty whether we could prove racketeering.
Yes, at a later stage now, the responsible DPP who was responsible for facilitating racketeering applications in the DPP office then said we must. Yes.
Yeah.
Yes.
Yeah.
Then said we must relook at the matter. He thinks that we might not be able to prove racketeering, and then the matter was back in my hands now, where I addressed his concerns in respect of the proving of racketeering, and I addressed that by amending the indictment and setting out the facts that that addresses his concern about the racketeering, and he had to.
And subsequently, say, okay, so also bolstered by Nkabinde, who was one of the IPID investigators, but then who had turned, as it was, state witness, 204 witness, and he issued a statement which would support your case of racketeering.
Indeed, so Nkabinde became a Section 204 witness. He gave a Section 204 statement, which was very important because it shined a whole light now on some of the issues that we were investigating. It gave clarity on the meeting of the 3rd of December, the Krecher House meeting, as to why there was a meeting there, why the meeting, the invite to the meeting said top secret, and why the persons who attended the meeting were so concerned about the leaking of that meeting. So he gave light around that, and he also gave light on the issue of the sound system, that the search warrant was fraudulently applied for from the magistrate in terms of the searching of the sound system, whilst they knew Patlani had shown them proof from his net bank account that he had paid for that sound system on the morning when they went to his office before they proceeded to his house. They knew about that, but they proceeded. And the thing about the 80,000 rand system, they later also confirmed, and they were panicking that Patlani has won this round. He definitely paid for the sound system, and they used to go to the media and tell the media about that Patlani bought, or rather the suppliers bought Patlani an 80,000 rand system. But after they discovered that he paid it, they don't go back to the media and said, no, we were wrong. They just left it as it is.
Okay. So you then go on to say that while you were waiting for the DDPP to make a decision, you were then implicated by McBride in the Zondo Commission, which put the case on hold, and affidavits had to be filed there, and you, amongst others, were accused of targeting IPID and the corruption busters.
Indeed, so, Honorable Chair. So after the downloads, we required, or I instructed the investigators to obtain a warning statement from Mr. McBride. The Brigadier Ngube then made a call to Mr. McBride, and then when he answered, he told him that he was instructed by the prosecutor to obtain his warning statement. Then Mr. McBride said, no, you have to talk to my lawyers. Then Brigadier Ngube asked him, who are your lawyers? Then he just dropped the call, and he never picked up since then. The next time we heard, he had now implicated us at the Zondo Commission, and we were supposed to file affidavits refuting his allegations that we were captured. But it was not only me from the NPA, there was some deputy directors of public prosecutions who were also implicated in the matter, the Kaito Mena matter, the rendition matter. All those prosecutors, surprisingly, all those were deputy directors of public prosecutions there. It was only me, the senior state advocate, who was implicated with my seniors.
Okay. So at the end of the day, the certificate was never issued, and the matter was stalled on the basis that the outcome to the Patlani case was still awaited.
Indeed so.
Then from page 59, you just want to deal with some, what you describe as miscellaneous matters. Do you want to highlight anything there about some, it's a few short paragraphs about allegations that were made, brought to your attention? You want to address some of them?
Indeed, so Chairperson, I say there on 139 that I now deal with clearing some of the untruthful allegations that came to my attention during some witnesses' testimonies. There was testimony that Nkabinde was not invited to the meeting or braai or launch of a book, whatever it is, at Radovan Kretscher's former house, but he came uninvited. In fact, Nkabinde was supposed to be at home in Durban that weekend, but cancelled at the last hour. Mahlangu, in his communication with Trent, informed the letter that Nkabinde is no longer going home. Trent sent an invitation to Mandla requesting him to forward it to Nkabinde. 141, the invites to the invites to the attendees were notified that it is top secret. And I questioned there that why would a braai or book or launch be top secret? After Mokotedi learned of the meeting and opened the treason charge, they went into overdrive and panicked, even accusing a certain Jacob Nare of leaking the meeting and later accusing the journalist Angelique. The committee will make its inference in this regard. 142, O'Sullivan and McBride stated that there were no meetings at IPID offices.
Do you, just a matter of interest, this name Jacob Nare, where does that name crop up?
He was one of the persons that were at the top secret meeting at Kretscher's house.
Yeah.
So after Mokotedi opened treason charges that what was discussed there was a plot to overthrow the government and take over the criminal justice system. Now McBride and Paul O'Sullivan and Sarah Jane Trent panicked because they thought that their cover was blown. So they panicked. Now this Jacob Nare was there at that meeting. So they initially suspected that it is him who leaked the information about the meeting. So they planned to deal with him. Later, then they changed and said they suspected Angelique. There was a journalist by Angelique who had attended that top secret meeting. So they now changed and said it is her. So at paragraph 142, there is proof of meetings being held at the IPID offices. And then 143, O'Sullivan and McBride said Trent and O'Sullivan were never involved in investigations after they appointed witnesses at the initial stage of the investigations. And I say there that there's proof from the downloads that they were involved until at least the 7th of January 2017, 3 days before Trent was arrested, according to the information in the downloads. 144, O'Sullivan said he did not receive any information from IPID. O'Sullivan and Trent received information like cell phone records, bank statements of private individuals, vehicle information, ID numbers of private citizens, internal memorandum, and other information according to the downloads. 145, it was said that General Mokotedi opted out from the polygraph test which McBride passed. Trent, in fact, had arranged that polygraphy test, and the arrangement was that O'Sullivan would provide questions to be asked to McBride and Mokotedi. 146, the statement of the polygrapher was obtained. It proves corruption where McBride's polygraph test was paid for by O'Sullivan and Trent. In fact, McBride traveled to the police station in Centurion where the investigators were obtaining the statement of the polygrapher with Binang to try to interfere with the witness. 147, McBride said he had nothing to do with the YouTube video undermining Phahlane regarding the attempted robbery. In fact, McBride is the one who instructed Trent to post the YouTube video undermining Phahlane. Trent mistakenly used her name when she uploaded the video. Then she realized her mistake and she had to delete the video and use another name. I think she used the name of Amanda, if I'm not wrong.
Advocate Mashugha, I think we've come to the end of your statement. Is there anything that I omitted to ask you or that you want to perhaps mention to the Honorable Committee before I ask you questions?
Nothing. I think we have covered everything.
Thank you very much also for your cooperation.
Thank you very much.
Thank you, Chair.
Thank you so much. And I check Honorable Skosana and Honorable James, your hands are up.
Thank you, Chair. On 144, you said that also even said he did not receive any information from IPID. That's what he said, yes. And we are saying here that they have access to get records, bank statement, vehicle information, ID numbers on private citizen. Is that what you said? Am I right?
Yes. The IPID official, let me say, Trent and Paul were providing 205, drafting 205 that would be provided to IPID officers. Then the IP officers would just be a conduit, taking those to the service provider. If it is a bank, they would take that to the bank so that the bank provides the information. When they get back that information, emails it straight to Trent or Paul O'Sullivan, depending on who was dealing with it. So it's cell phone records in terms of Section 205, it's bank statements, it's information of ownership of cars by people, all those things.
Thank you, Chair. At least now we know he's coming back tomorrow. Thank you.
Honorable James.
Thank you so much, Chair. Mr. Mashugha, I just want to go back on a name that
Mashugha.
Mashugha.
Yeah.
Thank you, Chair.
Not Mashiro.
Mashugha.
Yeah.
Thank you. You mentioned Jacob Nari, and I heard that name somewhere. Jacob Nari was an associate of Krishna. And Jacob Nari plotted against Paul O'Sullivan. And you say that he too was present at the braai. The braai that was arranged by Paul O'Sullivan. So I'm trying to connect the dots here. Why would he be part of the braai when he was plotting against Mr. O'Sullivan? I don't know. Trying to make sense of all of this.
It appears from the communications that he was staying with Paul O'Sullivan at that house.
So Paul O'Sullivan was responsible for the Krishna case, the matter, the alleged drug dealer, getting him arrested. Am I right?
Yeah, Paul
So I don't know. I'm just trying to connect the dots here, trying to link people from the drug cartel with Mr. Paul O'Sullivan. So I failed to understand why this gentleman would be at a braai, where I also know that they were plotting against them, because it would now appear that maybe Paul O'Sullivan was playing both cards. I don't know, both sides. I don't know.
I think so, because it is intricate, because O'Sullivan referred to this individual as a 204 witness. So,
Okay, so this person could have been the one who gave him the information on the drug cartels, maybe, I don't know.
yeah, I couldn't make out what was the relationship actually, but I know that
They stayed together at that
they,
house.
They were staying together at that house.
Okay, Saloma Mora vra, thank you.
14:56. I'm going to suggest that we take the next witness because we still have 2 more witnesses. Is there something you want to say, Advocate Mkhize?
Yeah, we were wondering which witness you want to call next.
Yeah.
We were just trying to figure out which witness you were going to call next.
Yeah, you are the ones who must advise if we agree to take a witness. And if we don't agree to take a witness now, we must make a decision whether we're still going to allow 2 more witnesses to present here, because it means it'll be until 5 o'clock in the morning. Yes, that is what it means. We have to anticipate that we will leave here at 5 in the morning if we don't take the presentation now. Can I get guidance from the members? Or maybe let's hear the legal team first. Can we hear you? Can we first hear from you whether you agree with the suggestion of the chair? There are 2 ways here. One way is to go at the rate we are going and finish at 5 o'clock in the morning and come back here tomorrow at 9 o'clock. And then, yeah, there is no way tomorrow will not happen. Tomorrow must happen. But before tomorrow happens, tonight is happening. So that's what I want to hear from you. Now, I'm going to rotate you to speak. You are going to take the next 5 hours to conclude the presentation of Advocate Masha. And then after 5 hours, we take the second, 5 hours from now will be 7:30. And so we need 10 more hours to conclude the 2 witnesses who will be coming after Advocate Masha. So what I'm suggesting is that we take the second witness and hear their presentation. And maybe the legal team can advise us if we were to take Honorable Adams or we were to take Mr. Chetty, how long will it take them to lead the presentation of evidence so that we can be in a better position to decide what should happen than to run here the whole day and later we tell one of the witnesses to say, go home. We will not be able to listen to you today.
Honorable Chair, honorable members, can we, because Honorable Adams is also going to be quite long, that we try and reschedule him for another day, another time slot. And that in relation to Mr. Chetty, there is a slot for public participants on Friday. If we start slightly earlier, then we can accommodate him on Friday. And that we suggest alternatively that we call him only today, and try and curtail his evidence, but we need to finish Advocate Mashugha today.
Okay, there is a proposal that the two witnesses that are coming should be rescheduled. If we agree on rescheduling, let's agree on rescheduling, and then we will decide when we slot them in. Can I hear the parties, the African National Congress?
Thank you very much, Chair. As ANC, we don't agree with both proposals. We don't agree with the Chair's proposal that we take another witness because we think it may be detrimental to the evidence just led by Advocate Mashugha. We would like to fully interrogate his evidence, and if we pack them one after the other, we may not have an opportunity to do so. We do, Chair, think that Advocate Mashugha's presentation was relatively straightforward, and we want to propose that maybe we reduce the amount of time that is allocated to members for the engagement. That's to shorten the 5 hours that you're talking about. Chair, we feel very strongly that we must take Honorable Adams today, even if we were not to get to question him because it is 5 a.m. like you're saying. But his presentation is very important before this committee. I think it was Honorable Diane Kolobarnard yesterday who motivated very strongly why we should not be postponing the testimony of Honorable Adams. So our proposal, Chair, is that let us go into the questions with Advocate Mashugha now. When we finish, we hear the testimony of Mr. Adams, and we will then decide at that point whether he's rescheduled for questions. The one proposal we support is perhaps a consideration of rescheduling Mr. Chetty's testimony. Thank you, Chair.
What time do you propose as an allocation for members? I normally allocate to 30 minutes.
15 minutes, Chairperson.
You propose 15 minutes.
Yes, we think Advocate Mashugha was very clear.
If you propose 15 minutes, it's for full members and 10 minutes for alternates. Agreed? That is the proposal.
Agreed.
Wait. This is the proposal that the ANC is tabling. I want you to listen carefully. Honorable Sangweni says, let's take Advocate Mashugha and then followed by Honorable Adams. And then when we engage with the presentation made by Advocate Mashugha, members will be allocated 15 minutes and 10 minutes respectively. 15 minutes for full members and 10 minutes for alternates. This is the proposal that is being circulated. Can I hear what members are saying? Is there anybody who still wants to speak on this proposal from the ANC? Honorable Nhlanhla.
Fully covered.
The ANC speaks in one voice. MKP?
Chair, we totally reject that. Completely rejecting that. One, the first proposal which we are rejecting is that with what was presented to us here from Advocate, we need our full 30 minutes. I just want to start with that one. Secondly, in the morning, I said it, we can't treat, and that's what you said yourself, Chair, public participation with a contempt. And I think Honorable Sangon, that's what he said as well, and Honorable Matthews, that we are doing the same thing. We call witnesses to come here. They fly them from all over the country. Then at the end of the day, they must go back. For me, if I may to choose, I will choose a public participant after Advocate Mashugha, if it's possible. And then our honorable member, because he's here with us here in Cape Town, there's no cost involved. We'll save taxpayers money. But if you have to keep Chetty, it means you must send him to a hotel If he's prepared, I don't know, but I'm just saying that it will be unfair for us to not even entertain it now and say, no, in fact, the Honorable Sange never even spoke about the public participation at all. He said after this, the proposal is that we must have Honorable Adams. What happens to the witness who's here, who's been flown in here?
Chair, protect me.
No, Chair.
From somebody who is lying about what I put before this house. Please
Chair,
protect me.
Let's do like this.
Let's not behave like that.
Let's
Honorable Sange. You'll get an opportunity.
Let's allow the honorable member to conclude.
Yeah, because now, you know, this thing happens all the time, Chair, and I'm concerned it's the same member. When I'm speaking, respect me. I'll respect you. I won't even interfere. Now, I'm saying to you, Chair, the proposal which you proposed, I mean, it was proposed by Honorable Sangon, is that the public participation must go to the next leg. Because he's not going to testify today here. We are going to have Honorable Adams. Then what happens to the witness here? Chetty. What must happen? He was supposed to be told in the morning that you are not welcome, come today here. Maybe we'll have gone back home.
Okay.
Thank you, Chair.
Honorable Number.
Yeah, no, thanks, Chair. Chair, I think it's practically impossible for us to have 3 witnesses today. And 2, we don't agree with a proposal of reducing time on the basis that the statement before us is quite voluminous. It's a sizable statement. So we are going to impede the work of members if we want to engage this statement within 15 minutes. It's a very long statement. And we've been allocating previously time on the basis of the size of statements. So we can't vary from an established practice and want to apply another principle today. We don't think that we are going to do our work qualitatively if we are saying we allocate 15 minutes to a statement of 60-something, whereas we've been allocating 30 minutes to a statement of 30 or less pages. So, Chair, we don't agree. Well, if the majority agrees, then we subject ourselves to the behest of the majority, but we strongly feel that we are going to jeopardize the quality of our work if we reduce time. Secondly, I agree fully with Honorable Skosana that let's take the public participant after we have engaged, we have questioned this witness, Advocate Mashura, because Honorable Adams is frequenting this vicinity. He's always with us here, and we're not incurring any cost for him to be here. So even if he can come on Friday, there's no problem with that. So I'm suggesting I'm supporting the proposition that has been made by Honorable Skosana. Thank you.
DA.
Thank you, Chair. Chair, honestly speaking, I think it's a bit late to be having this discussion now. We know that we can't have 3 witnesses in one day. It's physically impossible to meet that requirement. So I didn't think I'd ever say this out loud, but I agree with MK. I think that especially with Honorable Adams, we need to have enough time for that. I think that it's going to be a lengthy session, and we need to make sure we don't limit it to the point where we won't be able to engage properly. So that's on the one side. I think in terms of Mr. Chetty, I agree with. I don't think it's fair to public participants to, apart from wasting money, but that we mess them around because we didn't schedule as accurately as we could potentially have. And I agree that we finish the process with the advocate before we then move on to the next witness.
Okay.
Thank you, Chair.
EFF.
Chair, not 2 witnesses back to back. We were trying to have 3 witnesses today, so in agreement. We don't, the public participant should go today. As we said, I mean, we need to engage Honorable Adams. He's a full-time parliamentarian, so he should make himself available. So I think we can just engage him. I can't imagine him not availing himself at a convenient time to the committee. We're in agreement that you can allocate full members 15 minutes and alternates 10 minutes. We do understand that the sworn statement of the advocate is quite lengthy, but the information is very clear. Don't think there's much for us to interrogate. In terms of our public participant, Mr. Chetty, I don't know if we're going to be able to do, if he gives his testimony, will we also be able to do questions to him after, within a decent time? So that would only be the only concern, unless we do the same thing with allocation. But I don't know whether 15 minutes is going to be enough time for full members with Mr. Chetty. So that's our submission. Thank you.
Bangazita.
Thank you, Honorable Chairperson. Well, I firstly support the proposal made by Honorable Sangon. And secondly, support that perhaps after the witness before us now, we deal with Mr. Chetty, because he comes from all the way from KZN. And if we were to schedule him on Friday, then it means Parliament must actually incur the cost of his accommodation until Friday. And that it would also not be fair to him. So Honorable Adams is with us here. He was with us even over lunch, and he's happy and looking forward to be with us at any time we need him. So I see no train smash in rearranging that. Thank you.
Okay. Honorable Salz.
Honorable Chair, my understanding is that Mr. Chetty still needs thorough consultation with the legal team. That's the understanding that I got. Because today it had to be done today. But I think if we shift Mr. Chetty to Friday, it allows for a more thorough consultation through his attachments, etc. Then we do Advocate Masha today, 30 minutes, and Honorable Adams today as well. Thank you, Chair.
Honorable Vessels.
Thank you, Chairperson. I'm not sure if there should still be a consultation with Mr. Chetty, then it changes the dynamics. But I think the proposal that was made to have the current witness complete his testimony, I think the time allocation of 15 minutes and 10 minutes is sufficient, as other members have said. And then that we take Mr. Chetty, because he is here, if the consultation has been done and it has taken place. And then, as I said and other members said last night, we need sufficient time with the Honorable Adams, and I don't think we're going to do justice to his testimony if we squeeze him in tonight or today. Let's reschedule Honorable Adams. Thank you.
Honorable James. Honorable James.
We are in agreement with the time allocation of 10 and 15 minutes, Chair. And we also think that the next witness should be called is Mr. Chetty. Thanks.
Okay. Let's do like this. From the African National Congress, how much time do you need per speaker? Is that 15 minutes okay with you?
Chair, we're very opportunistic. If you give us 30, we'll take 30, but we can work on 15 per speaker. And sorry, Chair, while I'm on the floor, please can we confirm the readiness of Mr. Chetty.
Yeah, I
Because
want-
I
I
got the
want to-
impression that he was not ready.
I
Thank you,
want to
Chair.
I want to come to that point. Can I check how much time do you need? How many speakers do you have today?
We have 2 speakers, Chair.
And each one of you speak how much time they need?
15 minutes, Chair.
15 minutes?
Yes.
It's 30 minutes?
Yes.
Okay, MKP, how much time do you need?
Chair, we stick to the 30 minutes and
No,
yeah,
no,
but
no.
listen to me, Chair.
No. Just say to the chair, this is the time that we require.
Exactly what this is what I'm saying, Chair. And what I didn't want just to say that alone. By what is happening here, because look, it's not about ourselves. I'll make now, because I heard everyone here. If the evidence leader speak to Mr. Chetty as well and Mr. Adams to postpone them, and let's have a full time with all of us. But those who want 15 is fine.
Honorable member, I circulated for discussions.
Okay, thank you. 30, which is an hour for us.
Thank you.
Thank you.
Honorable Kola Barnard, I see Honorable Cameron is out. How much time does each of your speakers need?
We're quite satisfied with 15 and 10, Chair. Thank you.
EFF?
2 hours, Chair. No, 15 minutes, Chair. Thank you.
Okay. Pangazita?
15, Honorable Chairperson.
Sols?
30 minutes, Chair.
Honorable Vessels?
Maximum of 10.
Okay. Honorable James?
10, thank you, Chair.
Okay. This is what we will do, honorable members. The majority of you are satisfied that the presentation that has been made by Advocate Masha reinforces some of the presentations that would have already been made before this committee. It's just for you to clarify 1, 2, 3 matters with him. We sitting here as a chairperson exercising benevolence for those members who may wish to ask questions to satisfy themselves. We may not have to suppress them. I am going to allocate you the time that you have requested individually. That is exactly what I wanted to confirm with you. And you have individually indicated the amount of time that you need. We are going to stick to that. I'm trying to come to a point of agreement in the meeting where there must never be any member who feels that this process has just become ceremonial. If the MKP and the Patriotic Alliance feel that they have questions, they must not leave this meeting with qualms that they were not given the opportunity to ask the questions that they would have wanted to ask. So I'm going to allocate them the time that they have requested. And then we will start with the 30 minutes of the African National Congress. And then before we do this, can I check with the legal team if we are ready to proceed with Mr. Chetty? Yeah, I know your hand, Honorable. So you must not leave, Honorable Adams, until you hear what our decision is.
Chairperson, I think that perhaps we could conclude Mr. Mashukha's evidence and then see where we are time-wise. And then we'll know at that point whether we should continue with Chetty, start with Chetty rather. We were suggesting Friday morning.
Yeah,
However,
we can't do that. If he is not happening today, he must know now. And if he happens, he must know that he's happening.
Chair, he can, yeah, we'll take him after Mr. Mashukha.
Thank you so much. Honorable Souls.
Chair, to be fair, earlier the legal team was prepared to do Mr. Chetty, but Mr. Chetty himself requested consultation, and then you made your ruling. It's only fair that you ask him now as well. Does he feel there's consultation needed, and is he prepared to come on Friday? That's my input there, Chair.
Yeah. Mr. Chetty, are we ready to go?
Honorable Chair, I was consulting with the evidence leader and realized a lot of my annexures was not received. So the bundle that is received here is not complete at all. So the evidence leader and I has been going through it, but it's not 100%. It's not even 50% complete as yet. And my evidence is quite lengthy. So I don't know now. We can consult, but it's about me consulting with the evidence leader and for the evidence leader to understand exactly what I'm complaining about, because there's a lot of annexures attached to it.
Okay. So the point is very clear. The witness feels that they are not ready for the legal team. The witness feels that they are not ready for presentation today. So when we finish with Advocate Mashura, Honorable Adams sits here. Can we start? It's now 23 minutes past 3. At 15:53, your time expires, 15 minutes each. Honorable Sangodi and Honorable Nhlanhla.
Thank you very much, Chair. Chair, it is our conviction that the evidence of this witness is straightforward. It actually corroborates with some of the evidence that would have been tabled before the committee, and we think that it is quite also convenient that Advocate Mashukha appears today before the appearance of both Mr. Paul O'Sullivan and Miss Trent. So we'll have some few issues to raise with Advocate Mashukha. I think the first thing is it not a criminal offense for an accused person to harass and insult the prosecutor who's handling his case?
Thank you very much, Chairperson. Indeed, it is a criminal offense, and the offense is, amongst others, contained in the section 32, subsection 1B of the National Prosecuting Authority Act, and it has a sentence of up to 10 years imprisonment.
Did you charge Mr. O'Sullivan for that offense?
I couldn't charge him.
Did you open a case against him?
Not yet.
Why?
Because it was their plan. They
No, no.
They weighed
No, no,
down.
Advocate Masha. Leave whose plan was it? Whether it was a president's plan or it was a worldwide plan, it does not change the legal prescript of what it offers you as an option when you face such kind of a situation. So why did you not open a case against Mr. Paul O'Sullivan?
Because they were going to cry conflict. They intended to remove that I be removed from the case by either conflict or somehow, because they were of the belief that no other prosecutor would. I don't know where they got that information, but the communication of the emails that he was using to threaten me and do all these things showed that that was their plan. And then.
So you did not want to fall into their trap?
Yes, I did not want to fall there. But in terms of prescription, a criminal offense other than murder and treason prescribes in 20 years. So I know I could deal with the case, the trial, and then after that, I can go and open the case. But as I am no longer in that space, I'm prepared.
Yeah,
to go
that's the problem with the prescription. Even if a matter does not prescribe, but the problem is that the longer it takes, the more chances of evidence getting eroded. That's the problem. That's the challenge of it.
Yes.
Yeah. Okay. Let's go to the estate. You took the statements of the security guards, the estate manager, and the building. What?
The investigating of team
Yes.
took those statements.
So,
yes.
Okay. Do those statements tell what exactly Mr. Paul O'Sullivan did in the estate?
Yes.
Did it go to an extent that Mr. O'Sullivan went to an extent of asking the security guards of the number of protectors of General Patlane, the number of vehicles he's using, the kind of ammunitions and guns the protectors are using, and all that? So did that information get contained in the statements?
Yes. What I remember is the witness was Van der Walt, the one who took O'Sullivan, Trent, and the two IPID officers from the gate to the estate manager's office. Is Van der Walt. So after the communication or the meeting inside the estate officer's office, they then left to go out. On the way, they went via the General Patlane's house. That is where they stopped and then asked Van der Walt those questions as to how many bodyguards, how do they patrol, do they patrol on feet, and yes, those kind of questions were asked.
What did Paul mean when he says you must fix Munu and Crash? What did that mean? Because fix may mean contextually, the context may differ in every situation. Fixing them, what did he really mean?
No, if you take the context of the totality of the emails and the content of the emails, he meant that General Patlane must either dismiss Monu because he's corrupt, but he had the option of opening a case against him. That's the proper way or proper process to follow. So he did not want that. He wanted to have his own way.
So are you aware of how is the appeal process in terms of that matter being struck off for? You said you have you appealed, then you left NPA.
Or the one against the Brigadier Nhlanhla?
No, remember the matter against Paul O'Sullivan. got struck off roll, and
Yes.
NPA appealed.
No, we did not appeal.
Okay.
We, in terms of section 342, capital A1C, you did not appeal. You just address the reasons
issues.
why the matter was struck off, which is the delay in terms of obtaining statements from the suspects, and then the delay in terms of applying for a racketeering certificate. But as you have seen the letter from the NDPP, it says that a prosecutor is being allocated to look at the matter and decide whether to re-enroll or they re-enroll on which charges. So they are.
No, don't worry. We're going to call our advocate.
Sorry, just the mic.
Sorry.
The nation
Just-
can't
just-
hear you,
just
and
take
they want
the
to
chair
hear you. Thank
closer.
you.
No, we're going to call our advocate Marga from NPA to update us as the Justice Committee on that matter of Paul O'Sullivan. And how far have they gone in terms of filing an appeal? So there is a download. We got threatened here with a letter by a person called Sarah Jane Trent. When there was information that was tabled here, which includes, amongst other things, the information downloaded from the phone. Was that phone processed and the information extracted from Israel?
That phone was seized in terms of section 23, subsection 1A, which is a warrantless search and seizure, which is allowed by the law when a person is.
Don't forget
arrested.
your mic.
When the person is arrested. So it was then booked into an SAP 13, which is where they book in exhibits. And then later I was informed by the police that it is with the cyber crimes unit. So cybercrime, as I am informed, it would be hearsay, but I have to give you the answer. Cybercrime unit has a contract with Celebrite. Celebrite is a company. So the cybercrime has a contract in terms of unlocking of phones or where it is needed. When they cannot do it, they go to the parent company, which is apparently in Israel. That is why the phone was taken to Israel to unlock the phone, and then they came back to South Africa to download it. That is the.
But the conclusion is that the information was retrieved through lawful means.
Yes, through lawful means.
So anyone who suggests otherwise is in his or her dreamland.
Yes, there's the section is in the Criminal Procedure Act, and there are cases. There's a Western Cape case which deal with the downloading of a case in terms of section 23 of a phone in terms of section 23(1)(a). We also have the international law case from.
Okay, we can leave it there. Because what we wanted to establish was the manner in which that the evidence was obtained through lawful means in accordance to the law of evidence.
Yes, but
So-
but then only the trial court in a trial within a trial can later decide on the admissibility or otherwise.
So this evidence was part of the evidence you submitted in court.
No, it will be submitted when the criminal trial is proceeded with, yes.
So, did you charge the people you have found to be conniving against certain individuals and illegally sharing information about some citizens,
Yes.
including Mr. McBride? Was he charged?
I cannot, in the beginning, on the charge sheet, in the magistrate court, he was not charged as an accused. I can only say that I instructed the investigating officer to obtain his warning statement. But as to whether he will be charged or not, I cannot disclose that information.
So, as things stand now, he was not charged.
He was not charged, yes.
Did Nhlanhla Mahlangu get charged?
Yes.
Who was the journalist who was part of the entire operation?
They were,
which involves the meeting at the Mr. Rodovan Creature's house.
is Angelique. I know that his first name is Angelique Serrao or something like that.
Was Angelique charged?
No.
Okay, so there are people who still survive being charged, even when you have amassed this kind of evidence.
Yes. Now, I was not dealing with that matter which would make Angelique a suspect as such. I was dealing with the matters against General Patlani and the incidental matters of accessing people's cell phones. So apparently, Mr. General Mokotedi had laid treason charges against those people who plotted.
Okay, so my time is coming to an end.
Sorry.
What material did Paul O'Sullivan and Trend use to intercept communication from other people?
I'm not sure of that.
Did he have a grabber?
I'm not sure. I don't have evidence of that.
Okay. Thank you, Chair. I'm done.
Thank you very much. Advocate, maybe let me start where Honorable Nhlanhla ended. So I've gone through the charges that you had preferred. Why did you not charge them for the illegal interception of information in line with what you said was offenses relating to the Electronic Communications and Transaction Act and the National Credit Regulatory Act? National Credit Act, sorry.
Yes, I did charge them with contravention of Section 86, subsection 1 of the Electronic Communications Transactions Act.
And then what happened, excuse me for this, I was 2 days old when I found out that the arrest and the kidnapping were one thing. I always thought they were separate things, right? So what happened to the kidnapping case then, the counter case that had been opened?
The DPP, acting DPP by then declined to prosecute the case, and then IPID made representations to the National Director of Public Prosecutions, and the National Director of Public Prosecutions confirmed the decline to prosecute. So it ended there.
And the treason case?
Treason.
The treason case that General Mukode, and it's important that we ask you this, Advocate, because had it not been for this committee, this entire case against Mr. Paul O'Sullivan and Sarah Jane Trent was swept under the carpet. So what happened to the treason charges?
The treason charges is related to what General Mokotedi would have, the docket that General Mokotedi would have opened. So it was not part of our investigations. Our investigations related only to the intimidation against General Patlani and all those instances where information was leaked to and
So
O'Sullivan.
you don't know if it was ever investigated and how far it went?
Only General Mkhwanazi can shine some light on that.
Okay. Now tell me, you said when you were talking about Mr. Jacob Nare, you said they panicked and they planned to deal with Jacob Nare. What did you mean by that?
Yes, they said they suspect that it is Jacob Nare who leaked the meeting. So McBride suggested that he's going to deal. I just cannot remember what exact words he used, but he said, he told Sarah Jane Trent to inform Paul. Paul was overseas at that stage, to inform him that he's going to deal with Jacob
You
Nare.
don't know what they meant by dealing with him?
I do not know what they meant by dealing with him.
Okay, help us clarify this issue, Advocate Masha. You said, I think you said Mr. Jacob Nare and Mr. O'Sullivan were living together. I mean, I use that in the loosest possible term. This house in Bedford View, also in your testimony, you said Mr. O'Sullivan was going to go after, put General Patlane in jail, go after his wife, go after his house, get it sold on auction, buy it, and then get it at a profit. Then you said the same thing he did with Krecher.
Yes.
Now, Mr. Krecher's house, did Paul O'Sullivan buy it? Because he came here and told us it was a friend's house. He wanted to go back to where things went down, the crime scene, and he asked his friend or this person that he knows who bought the house, did Mr. Paul O'Sullivan buy Krecher's house?
I'm just trying to look, to take a look. Yes, there's an exhibit where he says, yeah, it's exhibit MM3. The third line from the bottom. Then your house and assets will go under the hammer whilst you and your wife are in prison. I'll do what I did to Krecher. I'll buy it on auction and sell at a profit.
So Mr. O'Sullivan lied to us when he said he did not buy that house. All right. Now, there's an explanation you give somewhere that you decided not to, the NPA decided not to re-enroll that case because you were waiting for the Patlane corruption case to be concluded. I think you said this was a decision that you and the DPP had taken, and you would also not introduce the charge of racketing. I'm keen to find out what legal provisions did you rely on when you took this decision that you are going to wait? Like, what legal foundation do you say, no, let's wait until this other case is concluded?
Yeah, it was not a matter of a legal based principle, but it was after all these things that I've testified before this committee of the interference, people attacking me for having taken the decision. Then I tried to have the matter re-enrolled. I compiled an indictment and a prosecution memorandum. Later, the DDPP who was responsible said at some stage that he doesn't think we'll be able to prove racketeering, but we had a meeting. It was me, Advocate Hyde, Advocate Venon Nemaorani. We had a meeting where we discussed this, and then it was agreed that I would draft a new prosecution memorandum where I show address the issues that the DDPP was complaining
But
about.
those were relating to the charge of racketeering. I mean, I'm keen to find out why he thought you couldn't prove racketeering. But even more than that, I want to know why, if you thought you had a case, you didn't continue pursuing your case. You wanted to wait and see the outcome of another case. Surely that can't be correct.
Yes, that's why I'm saying I addressed his concern in respect of the racketeering. Racketeering also involved the predicate offenses that would have been preferred. So I drafted the second prosecution and submitted it to him. But in the meantime, there were other interventions, like now we were taken to the Zondo Commission. After we were taken to the Zondo Commission did not want to make findings or even call us to go and testify. And that was a disadvantage to us, because when we returned from there, now
Advocate, okay, were you ultimately frustrated? Advocate, okay, were you ultimately frustrated, intimidated, that you decided that you are not going to proceed?
Well, at the end, ultimate end, my colleagues who we were referred to as state captured were charged with disciplinary proceedings, and they had to resign. That concerned me, but I was not ultimately charged myself, because I had the backing of my DPP and my supervisor.
Okay, but there could be a dereliction by the NPA to not have re-enrolled that case, am I right?
I think all these things of O'Sullivan threatening people going in to radio stations.
Niamsab, you are afraid of O'Sullivan, like he...
Me?
I'm just saying, the way that you are talking about it, this is one man who goes around threatening national commissioners, threatening prosecutors, and you can't even take a decision that we're re-enrolling this case, we're going after him. Surely there is dereliction by the prosecuting authority.
Yes, but what I'm saying is that I was subjected to this stress and so on, but I still was prepared to re-enroll the matter. But remember, I couldn't take that decision alone. I had to rely on the deputy.
Okay, I'm sorry to push you, Advocate. I'm just trying to manage time. So you mentioned a security WhatsApp group that had Mr. McBride, Mr. Sisoko, Mr. Mahlangu, Binang Rapetsu Ngabinde, Subramani, and Anthony Sehas, I think. Now, is this the same Mr. Sisoko who's the head of investigations at IDEC?
Yes.
What was his role in this conspiracy or in the Patlane task team?
Other than being involved in a WhatsApp group that was sharing internal information of WhatsApp IPID investigations, he was just the one.
That's contravention of law itself, isn't it? So
Yes.
was Mr. Sisoko charged?
Yes, it's contravention of Section 33. No, he was not charged.
But he was part of this enterprise.
Yes.
Okay, I think Honorable Nhlanhla has asked you about the legality of the phone. What I didn't get is, so you're talking about a warrantless seizure. Does a warrantless seizure authorize you to download the data?
Yes. In terms of relating to the period when this was seized. Remember, after 2017, there was a Cyber Crimes Act 19 of 2020, which was passed. So it regulated or changed the law in respect of seizure of and search of electronic devices. So that Cyber Crimes Act now requires that even if you seize a cell phone or an electronic device during an arrest of a person, but you would still need a warrant now if you want to download it. This is the law now. But by then in 2017, the police acted in terms of either a search or 23(1)A.
Okay, my last question, if I run out of time, it relates to paragraph 63.7 of your affidavit, and there you say in some instances through threats to provide information, documents, either incorrect information implicating Phahlane or to remove evidence contained in statements already under oath. What information were the witnesses giving that was incorrect, that implicated Phahlane, General Phahlane? Because what I'm understanding you to be saying here is that witnesses were intimidated to give incorrect information implicating General Phahlane. This is different from when I asked you what false information. This is, were you aware of any witnesses that were forced to give false testimony against General Phahlane?
Yes, it relates to those instances where statements would be made to witnesses and presented to witnesses to confirm whilst it contained false evidence. Like they tried to force Alvin Dupré to sign a statement that contained falsehoods. When Alvin Dupré refused, then they decided.
Can you give us an example of a falsehood? I'm trying to advocate, get a distinction between whether the allegations that they were making against General Phahlane themselves were false, or they were fabricating evidence. What exactly were they doing? So when they said Mr. Dupré lie, what did they say he must lie about?
As far as I can remember, the falsehoods in relation to Dupré, and I'm saying this under correction, was about Phahlane having loads of cash in bags and paying people sums of money.
Thank you very much. Thank you, Advocate. Thank you very much, Chairperson.
Honorable Nomba. I'm taking the two of you at a go.
Honorable Skosana will come first.
Thank you, Chair.
When his 30 minutes expire at 23 minutes past, you must follow.
No, 24, Chair. Thank you. We are strict like my old principal, Mr. Nhlanhla. Thank you, sir. Good afternoon, Advocate Masha.
Good afternoon, Honorable Speaker.
Advocate, because of time, we asked for 30 minutes. I hope that we will be able to get as much information as possible. Advocate Masha, you allege that Paul O'Sullivan and Sarah Traingen effectively infiltrated and led the aspect of IPID investigation, despite being individuals. Can you explain to the committee how it became possible for a private person to exercise such influence within a statutory investigative body like IPID without internal resistance or disciplinary intervention?
I can explain it in terms of the contravention of section or of Act 12 of 2004, the PRECA Act. PRECA Act, one of the definitions of gratification is forbearance of either an amount of money or a favor. So at some stage around 2016, when McBride was under suspension, O'Sullivan helped him with his case in the Constitutional Court. And then fast forward to November, O'Sullivan, or rather McBride was back at the helm of IPID. That exactly is when now O'Sullivan became involved in this investigation, exercising powers of IPID, drafting statements, drafting Section 205 witnesses, interviewing witnesses, and we are talking about a person who is not vetted. So that was the problem. That is how it came. That is pure corruption. That is gratification. That is a value, exchange of value for value.
For value. Now, you said earlier that the Zondo, the State Capture Commission, which was chaired by Justice Zondo, let you down. Am I right?
Yes, I believe so, because remember, we as the prosecutors, I was the only senior state advocate. All of them were deputy directors of public prosecutions. We had cases. Others were dealing with catomania. Others were dealing with rendition. We were all accused that we were a core group of advocates who were corrupt and captured. So when we were invited to testify in the Zondo Commission, we were looking forward. We even brought all the evidence and 100 pages and pages of evidence to show our innocence. Now, when we get there, we are told that no, actually, law enforcement, we cannot deal with law enforcement due to time constraint. Our question was, if you are saying state capture, you have to deal with the prosecutors because they are the gatekeeper of the criminal justice system. So why don't you make yes?
So we were correct, some of us, to say the State Capture Commission was a farce. Now,
I cannot say.
No, we are saying so. You might not say so. We are saying that. It's not only you. There's a lot of people who send information. Some of them would deny access because it had some eyes, that these people are belonging to a certain group. In fact, your submission, your attachments here, I'm going to come to them. So I'm going to ask you, to be brief for us to be able to get into these emails which were sent by a so-called expert in terms of the law, because he was given an opportunity to infiltrate that institution called IPID. General Mkhwanazi alleged that the criminal syndicate has penetrated law enforcement institution based on your experience in camel drift investigation. What would you say? The conduct you describe amount to institutionalized capture of or infiltration of IPID? And if so, who within IPID enabled it?
It is quite clear from the evidence that I have in the docket that IPID was indeed infiltrated and captured by both O'Sullivan and Sarah Jane Trent and McBride, and IPID members enabled it.
Now, you stated that in your statement that Robert McBride and IPID officials participated in the communications and activities with O'Sullivan and Trent. Am I right?
Indeed so, Chairperson.
Did the evidence in the download cell phones, data demonstrated that senior IPID leadership knowingly authorized or tolerated the involvement of these private actors.
Indeed, so there was an IPID group where they discussed investigations which were not supposed to be disclosed to members who are not members of IPID. We know of meetings that were discussed. So it is indeed.
Now, why did you, at that point in time, not open a case against them, knowingly that this is what they are doing with IPID?
My investigation also included this, so I cannot say who is a suspect who before a person appears in court.
Okay. Now, you testify as well that the security WhatsApp group existed involving IPID investigators and trend, and who were not the IPID members. Can you clarify shortly for the committee what operational decision or investigative steps were coordinated throughout this group, and whether this constituted unlawful sharing of classified investigative information?
Yes, remember in terms of the IPID Act, all information of investigations has to be treated confidentially and only be disclosed to members of IPID, not to private persons. So the fact that they were discussing information of cases in the WhatsApp group means that they contravene the law and the sections of the IPID Act.
You indicated that O'Sullivan and Trent held themselves as IPID investigators when interacting with witnesses. Did evidence show whether IPID officials present corrected this misrepresentation, or did they actively allow it to continue?
They actively allowed it to continue. For example, when O'Sullivan sent statements to witnesses, he was not supposed to send those statements or email those statements to witnesses. He copied Nhlanhla Mahlangu in that email. So they were aware, but they did not correct the misconduct.
Now, in your affidavit as well, you suggest that Trent, a private individual, assisted in drafting Section 205 of the SAPS and receiving confidential data from the banks and telecom companies. Do you regard this as a serious breach of criminal procedure? And if so, who inside the IPID authorized or facilitated this unlawful access to confidential records?
It is a serious contravention of Section 33.
Yes.
Can I just confirm it quickly? It's just. Section 33, subsection 2, read with Regulation 10(1) of the regulations for the operation of the IPID Act. So it was a serious contravention, and it involved all the people of IPID, Temane Binyang, Nhlanhla Mahlangu, Mansara Pesu, and the other, even Cedric was involved in that before he became a 204 witness. Yes, okay. We know that he ultimately became a 204 witness.
You stated that confidential NPA internal memorandum ended up in the position of O'Sullivan. What does this incident indicate about the level of infiltration or compromise within the NPA itself?
It was the only incident that I became aware of due to O'Sullivan sending me an email where he had attached this memo and sending me his affidavit to the Zondo Commission where he described that he got this memo, internal memo from a whistleblower. So it was the only incident that I became aware of.
Threats, and you provided a multiple example of threatening emails sent to you by O'Sullivan, which I am having here as well. During the prosecution, did you report these threats to NPA leadership? And what steps, if any, were taken to protect prosecutors from such interference?
Yes, I did report them. At some stage, I wanted clarity, especially after he went around radio stations defaming me.
Yeah.
I wanted clarity, and I requested the DPP to find out from head office whether legal assistance extended to suing a person for defaming you in the course of carrying out your duties. And I was informed that no, it is not possible because that is a personal problem, not
Now-
an NPA.
Now, Paul O'Sullivan sent you an email on the 6th of December 2017. He called you names and others. You, Michael, we are part of a criminal conspiracy. You were either the most stupid, gullible prosecutor in South Africa or the most crooked prosecutor in South Africa. Which is it? Either way, you are no longer fit for the purpose and you have to go. Did that happen?
Yes.
Eventually. He got rid of you. Or
No.
the NPA got rid of you.
No, remember at the DPP, I had the protection of the DPP advocate Mzinyati who knew about the case, and my supervisor also knew and understood the charges, the crimes that had been committed. So he wouldn't have succeeded.
Now, because these emails were sent to Sibongile Mzinyati, the one we are talking about now.
Yes.
Sean S.K. Abrams, Glenis Breitenberg, Andrew KMA, I don't know who's that, is it Chauke? The one who's facing, who's on the inquiry?
Yes.
Don't you think we should call him in this committee? In your view, what's your take?
I have no...
No, I'm just asking you.
I have no view.
I think we have to call him as well. I mean, the language used here by O'Sullivan, disrespect of the highest level, white supremacy at its best, living under the apartheid. You know, what I'm reading here is scary, Che. Scary. But because there's a lot of attachment and we don't have enough time, I'm just going to read few here. The way the man was in charge, he says here, your resignation will be acceptable, followed by your removal as an advocate, and then a criminal trial. Nothing less will do. I repeat, I was 10,000 kilometers away when the raids by IPID were launched. I only knew about it when the media called me. What they got through the raids is, I hear, truly damning and brings you into a criminal syndicate along with Patlani. The phone records will prove all of that. If you are still working for the NPA, when I get back to South Africa in February, I shall launch an application to have you suspended along with the fake advocate Mlojwa. Charge me with intimidation if you dare. I will face you in court and finish what you started. I've not forgotten that you have fraudulently signed a J50 for me and Sarah Jane Trenet. You thought you will stop us. Did you? Wrong, Michael. Just look here. Take a good look. You will see the criminal against you and the other rubbish. He calls everyone rubbish. He calls everyone rubbish. He said that here in this core committee, that we are talking rubbish. in the NPA with more coming soon. If you cannot prosecute you, we'll expose you. And guess what? The donations are rolling in the forensic for justice. We have millions now, enough to sustain a really good fight. And I can tell you now, all those so-called, what they call them? Civil society organizations, they are quiet. Because of color and nothing else. South Africa, we are afraid of speaking out the truth. They are not saying anything. They are not joining. They are not saying anything. No statement, zero. But the more I deal with a low life, dishonest people like you, the more I like my dogs. That's Paul O'Sullivan saying that to you. What's your take on that?
It's obviously extortion because he's threatening a prosecutor and insulting a prosecutor because he wanted to have the advantage of his prosecution or not proceeding. So that's extortion. It's contravention of Section 32(1)(b) in terms of threatening, insulting, and hindering a prosecutor for doing his job. That is why I say I didn't at that stage want to open criminal cases because it would have jeopardized the Camille Drift case because of a conflict. So that is what they were pushing. He did not care whatever he said, as long as I could get away from the case of Camille Drift.
Now, in the same emails which he sent to you, he says here, I've left South Africa on 11/27 and have been working tirelessly since the exposing of the road in South Africa from London. See an attached speech of Lord Hayne. I think those who knows Lord Hayne, they will understand who I'm talking about. London can move against SOEs in South Africa, yet the police and NPA has been paralyzed due to criminal capture. There's a lot more coming out from London and Washington soon that will expose the rot in South Africa. I cannot stop now with your dirty tricks. Now I understand why you wanted me to hand over my passport in February, just like the apartheid police used to do. What a disgrace. As I said in the last paragraph, I said to Zuma, crook mistress, and her bastard son in the SAA November 2014, came on, stop me if you can. I wish I was in the NPA then. How I wish he was saying this to me. I'm not sure what you have done. I'll take him to court. Even those courts, we've got some reservations. What's your take, advocate?
No, it is true. So those were insulting words, and they have to end up in court. But like I said, I had situations where I was supposed to face conflict. Then thereafter, I had the situation where I was placed under protection due to the serious threats that were imminent, where one of my investigators was assassinated. The threat was that I was also supposed to be assassinated, but the NPA acted with speed, and after receiving that information from the SSA, and I was placed under, but yeah, I'm going to open cases.
Now, he sent you another email on the 7th of December, 2017. I guess if I swiped 5 billion, I will also need a dirty general, a couple of dirty brigadiers and dirty rotten prosecutors to help to cover my tax and go after those that were exposing me. You and me will go down in the history, Michael. Me for bringing down 2 chiefs of police in 10 years. You being the first NPA criminal on my radar to go to prison.
Yes.
Have you responded to him when he sent you this email?
I never responded. I was just printing the evidence and keeping it aside. So for in case, for when I open the cases, I would have that evidence because it is self-explanatory. And yes, that was it.
Before you close, let me say this again, this email. As I'm saying, is insulting everyone. Everyone is stupid according to him and rubbish. He says here, it leads to an inevitable conclusion that a corrupt president and those that have aided and abetted him are planning to call a state of emergency to save themselves from prison. I want to warn you that this type of the last-ditch illegal attempt to silence people will not be tolerated. Now, I shall use my considerable skills and contacts to lawfully undermine the illegal states of emergency. And the states of emergency it's only declared by the president. And yeah. But he undermines everybody. Even the head of state even told us he trained our current president, Cyril Ramaphosa, to be a reserved populist. That's what he told us. You are even said that in terms of the constitution, which was bizarre to say the least. But this is how the arrogancy of these emails which were sent to you, which does not surprise me at all.
In the face of all the evidence that was there against him.
Now, you've been harassed by Paul O'Sullivan for a number of years, am I right?
Yes.
And not only you, am I right?
Yes, not only me. Also Advocate Nzinyati, the DPP, the NDPP, Sean Abrams. Yeah, he was harassing every person.
And then NPA Breitenbach, was he harassed as well? Was she being harassed as well? Or you don't know her then?
No, I just know that in some of the emails, 1 or 2 of the emails, when he made those insults, he copied them.
Yeah, because the copies here are very clear. Those evidence are clear here. Now, coming to the issue as well, which I was busy with you on that, because there's a lot of things, unfortunately, you don't have time like the other commission. This, in your statement, you indicated that you believe that the conduct of O'Sullivan and Trent and certain IPID members constituted an enterprise under the Prevention of Organized Crime Act. What evidence led you to believe that their actions form part of the coordinated racketeering and enterprise?
Okay, I summarize the evidence here in accordance with the dates. And I say here, in January 2016, accused number 1 demanded that the complainant, Khomoto Patlani, deal with a certain Muno, a general in the SAPS, despite the said accused number 1 having opened a docket with IPID against the said Muno. When the complainant did not accede to his demands, he started threatening him and extorting him, threatening to investigate him, dig up his past, open a docket against him and have him sent to prison. And he further promised to leave the complainant alone if he dealt with the... I see you don't have time, but I summarized everything here.
Yeah. No, I understand that. And thank you, Advocate. You know, before my time comes to an end, there's an interdict referred to in your statement obtained by Neil Diamond, who applied for an interdict after being harassed with intimidation and attempted extortion by Paul O'Sullivan. Copy is attached here, is M1. This was one of the reasons which you considered in coming to the conclusion that Mr. O'Sullivan will endanger the safety of other people or will commit a Schedule 1 offense if released on bail? You remember on that case?
Yes.
When you signed the warrant of arrest, I was not aware of the court order. I must be noted. I think that's you, am I right?
Yes, that was me.
As we speak now, all this harassment and intimidation, in your view, from your former colleagues, has it stopped now as we speak?
Intimidation?
Yes, from Paul O'Sullivan. Has it stopped harassing
I
people?
think as soon as he hears that the matter against him is going to possibly be re-enrolled, he's going to start harassing the prosecutors involved.
Now, earlier we spoke about the issue of the court order, which gives him a 48 hours notice before, if anyone wants to arrest him.
Yes.
Can you perhaps, in brief, that as we speak now, if he comes in here, the police have a case against him, they want to arrest him, is it impossible? They have to notice him.
Yes, they have to notice him in order to comply with the court order, unless maybe there is an urgent reason maybe to arrest him, and then we have resort to Section 35, subsection 5, in terms of the unfairness or otherwise, where we can go to court and say that this person was arrested and we had an extraordinary situation where despite the court order, we had reasons to arrest him immediately to prevent harm.
Now, in your view, do you have anyone? Do you know anyone in this country who has that privilege?
No. No.
So it means that Paul O'Sullivan, like General Mkhwanazi said on the 6th, to say our criminal justice system has been infiltrated, Paul O'Sullivan is one of those who, in fact, we are in this situation in this country where we are because of him.
Partly, so I know I have evidence that shows that he had infiltrated IPID.
Thank you so much. Thank you, Chair.
Honorable Nombala.
Thank you, Chair. Good afternoon, Advocate Mashuka.
Good afternoon, Honorable.
Yeah, you are a seasoned career prosecutor. You have served the NPA for a period of 24 years and 9 months.
Yes.
And then you decide to leave the institution. Well, you are saying in your affidavit you don't want to disclose your current employment. I respect that. But I'm just interested in knowing, why have you decided to leave the NPA after serving for so many years? Was it out of frustration, or it was out of new opportunities that you identified to be better than the occupation you held at the time?
Yes, it's the latter.
So it was not out of frustration?
No, even though O'Sullivan tried, he did not break me.
You are saying you left the NPA when?
Effective 1 September 2024.
2024, yes. Okay. Now, you are saying, I think on paragraph 131, when you explain the reasons why the matter was struck off, you are saying in the next court appearance, you did not have warning statements of individuals against whom charges were supposed to be preferred. So who do we blame here? Do we blame you or the investigating officer?
Okay, I have the warning statement from some of the accused. The only warning statement that I did not have was that of Mr. McBride, because when the IO called him, he said, "Talk to my lawyers." Then IO asked him, "Who are your lawyers?" Then he dropped the phone. And then he never picked it up until he took us to the Zondo Commission. IO tried to trace him, look for him. He never got hold of him.
So was Mr. McBride not charged already? Because I was under the impression that the people who were charged was McBride and Sarah Jane. Were they not charged already?
No, it was O'Sullivan, Trent,
O'Sullivan,
Manda,
okay.
and Temani
Okay.
Bina.
Okay.
Yes.
So you needed to add more witnesses. And
More suspects.
More suspects. So I'm sorry. So those suspects were McBride and?
I cannot disclose the names of the suspects until they appear in court.
How many were they? The outstanding witnesses.
Yeah,
I mean,
they were-
accused, suspects.
They were at that stage 4, but we identified that there could be more, but then we decided that the others do not form part of the enterprise. They only did maybe one, were involved in one incident which could not be reconciled with being an enterprise as this other core group.
So that was in 2017?
Yes.
So from 2017 to date, it's difficult to add more witnesses?
No.
Have they been added?
No, because remember, there was this to and fro regarding the racketeering.
The racketeering,
On
yes.
the-
You said
I-
there are
I-
two
I-
aspects. You are saying in your affidavit, there are two aspects which led to a matter being struck off.
Yes.
The first aspect is that more witnesses had to be added. The
Yes.
second one is that you identified a charge of racketeering.
Yes.
I'm saying now on the first aspect, is it still difficult until today to add more witnesses?
No. If the matter is re-enrolled, you can add those suspects.
Yeah, because what I'm trying to establish here is why is it so difficult to re-enroll the matter now?
No, it's not difficult to re-enroll the matter. A decision just has to be taken, and then the matter is re-enrolled.
So why has that decision not been taken? The decision is supposed to be taken by the DPP, correct?
In terms of even racketeering or even a normal indictment has to be signed by the deputy director. So
yeah, but I'm trying to understand, Mr. Mashuka, where is it stuck now?
At this stage, I heard that there's a letter that the NDPP sent to Parliament to say that they have allocated a they are allocating a prosecutor to decide on the matter.
On the matter?
Yeah.
So a decision has not been taken?
Yes.
Okay. So when Mr. Paul O'Sullivan was arrested, how long did it take him to appear for the first time in court?
In court. When he was arrested, I had to go and appear in the High Court on an agent basis because he made an agent application to the High Court of Pretoria.
On the same day? On
the same day, yeah, at night, around 9 o'clock, I was there. And the basis was I have this 48-hour notice order.
So the matter was heard on the same day?
Yes, was heard on the same day, and then it was agreed that either he must be released and then given a notice or taken to court.
At what time was it heard? You are saying you were there at 9 o'clock?
Yeah, at around 9 o'clock in there.
And then a decision was taken?
Yes.
On the same night?
Yes.
Was it in the High Court or Magistrate Court?
Yeah, it was in the High Court.
Who was the judge who was presiding over the matter?
It was Judge Lekhodi.
Or Judge Lekhodi?
Yeah.
Okay.
He was a judge by then.
Okay. Let me trying to write it down.
But remember, he only had to interpret what was before him, which was a notice, an order that was not even made by him.
Okay. Now, the DPP, you are saying on paragraph 121, the DPP ultimately declined to prosecute.
On those two charges of
yes, I'm just because I'm trying to save my time.
Yes,
I'm not going to read the whole paragraph.
No, I understand.
Is this jotting your memory?
Yes.
What I'm talking about?
Yes.
Yeah. So how do you view this? Was this genuine or?
It was never genuine because a person is arrested. A cell phone is seized in terms of Section 23(1)(a). He's taken to the cells. How can there be kidnapping and theft of cell phone? But I have a comparable case where they resurrected some previous cases against some of the investigating teams. Then they referred that case to the High Court, I think in High Court in Johannesburg. My investigators got acquitted in terms of Section 174 relating to the theft of and kidnapping at the airport. There was a robbery at the airport. Then some of my investigators arrested those people who committed the robbery and seized the money. Then they were accused of kidnapping, and the High Court gave a 174.
So is that suggestive of a proposition that some in the NPA are in cahoots with Paul O'Sullivan, or were in cahoots? If that is your interpretation of the situation.
No, it is McBride who went to resurrect those cases according to the investigating officers.
No, you are saying here, Mr. Advocate Mashuha, we are saying there is a memorandum that was written by advocates, and wherein they were analyzing the prospects of success.
Yes.
And the inference that I'm drawing here is that the memorandum suggested that you can continue with the prosecution.
Yes.
And the DPP took a different position.
Yes.
It declined against the memorandum that was written by the advocates.
Yes.
Is that correct?
Yes.
Yeah. No, so I'm saying, is that now suggestive of a proposition that the NPA was also in cahoots?
Well,
or there are some individuals who were working in the NPA, not now in IPID, but in the NPA, there are some individuals who were working with Paul O'Sullivan.
Okay, firstly, in terms of the decision, it is not wrong for different prosecutors to take different or assess evidence differently and take different decisions. It is normal, it happens. But my concern was that that memorandum was leaked, according to O'Sullivan, by someone inside the NPA. So it means that there was that infiltration by someone in the NPA who leaked that memorandum.
Yeah, no, I see the leakage, but I'm talking here about the decision of the DPP to decline prosecution. You have said to me, you don't believe that this decision was correct. And also, there is a memorandum that was written by advocates, which was saying prosecution can continue. But the DPP took a different approach on the matter, which you do not agree with as a seasoned career prosecutor, which also the advocates who wrote a memorandum did not agree with. So it took a unique decision. Now, the question is, you just need to be honest in terms of your own perspective, because we are making different propositions here based on experiences.
Yeah.
Do you think this had ulterior motives? And do you think this is also suggestive of a proposition that Paul O'Sullivan did not only infiltrate IPID, he also had some role players within an institution called the NPA?
Okay, I will leave it to you to make that inference. But what I'm saying is that it is not necessarily that where different advocates differ with the matter. You can see that matter of Katomena. There was one group which said there's racketeering, the other said there's no racketeering. So it's normal for lawyers to have different ideas. That is why even in court, you find a lower court says this, the higher court, then the matter is appealed to the higher court, which differs with the lower court. Then up to the constitutional court, they differ like that. So I cannot ascribe it, save for where they are alleging in the memorandum that my case is a petty case. You have heard now for yourself the evidence that was in that case. So they did not have an opportunity to read what is in my docket, but they just came to the decision that no, that is a petty case. There, I can ascribe some maybe wrongfulness to them.
Okay, this committee, or there's evidence before this committee, which alleges that Mr. Paul, do you know Xhosa or Zulu? You don't know. Mr. Paul O'Sullivan, I just want to say this in Zulu or in Xhosa. Ukuthi ubelala ngengubenye no Jane. No Sarah Jane.
No, that.
Now we are saying you made some downloads from Sarah Jane's phone and so on. Even if you don't go deeper into the merits, but did you come across something which corroborates with that allegation? Ukuthi bebengomelana uSarah Jane beno Paul O'Sullivan.
Unfortunately, I cannot. That is, I would be destroying the state's case if I disclose.
No. It's no longer only the state case, because that we're doing an investigation here also, and I always take offense when people think we're just doing idols or it's a podcast. When they treat this thing as a normal oversight exercise. Here, we do have powers of making an investigation as Parliament.
Indeed.
Two, there is evidence that has been put before this committee, which relates to that aspect. So we're investigating. So we are not jeopardizing anything, but you are assisting us as this committee, because there is a letter, as it has been said by Honorable Nhlanhla, which we got, which says we can't ask about intimacy and so on. Now, as a person who dealt with this thing at your official level, as a prosecutor, even if you don't go deeper, even if you don't give us much details, but would you agree with somebody who says, "Wakungunyelwana"?
I can't.
You can say yes or no, but would you agree with that person? I will move on. I won't probe you further.
No, I have to take into consideration the integrity of the case, because these things are not only ending here. They are going to go to the criminal trial, and then that is why I have to treat the information with the integrity which it desires.
Okay, now let me respect that. On paragraph 103, we were saying, O'Sullivan paid McBride's fees and got rewarded by McBride with involvement in IPID, so he can execute his plan against Pahlana. Let me start this question like this. When did Paul O'Sullivan start to have an interest in the affairs of IPID? Did he start?
They started in 2016. If I remember well, General Pahlane testified about an instance where McBride visited Sable Hills whilst he was under suspension, and tried to talk to him. So they always wanted to bring General Pahlane to their side. Now that they see that he was not playing ball, that is when now all these things
No,
happen.
I'm asking this because I want to understand the mission in its context here. I want to understand what was the ultimate goal.
The ultimate goal.
What was the end goal? Did Paul O'Sullivan engage or impose himself into the affairs of IPID because he specifically wanted to deal with an individual called General Pahlane, or he had a general interest which some did not include General Pahlane?
No, they wanted to take over the criminal justice system, so have their own people installed in those positions according to the evidence of Mr. Cedric Nkabinde, and that evidence is borne out by what is contained in communications there, where they wanted, they were discussing the removal of General Pahlane, that he must be dismissed. Certain political parties must put pressure that he be dismissed. Certain organizations,
So that interest started way before the establishment of the Pahlane task team.
Yes.
The reason why I'm asking is because the insinuation I'm drawing from this paragraph, when you say O'Sullivan paid McBride's fees and got rewarded by McBride with involvement in IPID, so he can execute his plan against Pahlane.
Yes.
It gives an impression that before the payment of these fees, Paul O'Sullivan was outside the affairs of IPID.
Yes.
He paid this amount because he wanted to pay his way in.
That is true, because he assisted. He also admitted year before the committee that he paid 200,000 rand for the legal fees. So we are saying that is gratification, because the definition of gratification includes the forbearance of.
Yeah, you see where I have a problem, Advocate Mashucha. You are saying, you have just said to me, his interest started way before the establishment of the Pahlane task team.
Yes.
Now, on the other hand, you are saying the reason why he paid this money is because he was outside IPID, so he was paying his way in.
No, he expected to be reinstated. That is why he paid those legal fees. Now, as soon as McBride was reinstated, immediately he approached McBride and then involved himself in the investigations, unlawfully in the investigations against General Patlan. So that is what we call paying it forward. He paid it forward.
Yeah, there is an excuse which does not accord with logic. Yeah, I think Honorable Sangoni has also asked you about this excuse, and I was not satisfied with your response. I think on paragraph 73, in your saying, you decided not to prefer charges against Mahlangu and Binang because in your view, that would impede the Pahlane investigations that they were involved with. The Pahlane investigations were dealt with by IPID, correct?
Yes.
Because Mahlangu and Binang are employees of IPID, are investigators of IPID.
Yes.
And then the charges that you were supposed to prefer against them, you were supposed to prefer those charges as a prosecutor.
Yes.
From the NPA.
Yes.
So now, where do we find the nexus between the two? Does it mean that when somebody is busy with a certain investigation or with certain work, even when there is overwhelming evidence before you as a prosecutor, you can't charge that person because he is busy doing some work elsewhere?
No, you can charge him, but there was no rush because the person who was actually being used to do the intimidation of the witnesses and so on were those two. So if they are charged and out of the picture, those ones we could deal with them at a later.
No,
later
but still,
stage.
advocate, because it's not about whether there is rush or there is no rush. When there is evidence, prima facie evidence, the only responsibility you have is to execute your mandate, is to charge people.
Yes, that is why you can charge people by.
Because you had evidence at hand. I was going to understand maybe if you were saying to us, evidence was insufficient at the time.
No, there was sufficient evidence.
But now we are saying there was sufficient evidence, but you could not charge them because they were still busy with another investigation.
No.
Somewhere.
We did not, we could not charge them. We could have, but we did not charge them, but we first wanted to deal with the actual persons who were committing the intimidations, and that is Sarah Trent and Paul O'Sullivan. Those ones had, we know that they had the mandate to do the investigations. These ones, other two, did not have the mandate. That is why they were used to intimidate people. So we wanted to deal with these two urgently before we get to the actual IPID members.
Yeah, I know that, advocate, you are very careful of not jeopardizing cases which are before or investigations which are currently underway. I just want to ask you about what you have written on paragraph. Okay. You are saying here on paragraph 67, O'Sullivan threatened Justa with 2 years imprisonment. So is Justa willing to depose to an affidavit?
Yes, Justa has deposed to, I think, 3 affidavits. If I remember well, yeah, there should be 3.
To this effect?
Yes.
Okay. And then, at what stage did you take this matter? Because when you, at the beginning of your statement, you are saying that it was dealt with by another prosecutor who later resigned.
Yes.
But you go on to say, when you took over the matter, you had to establish whether it was possible to continue with prosecution and so on. So following that, is it correct to assume that you took the matter at an early stage when there was no prima facie evidence?
No, there was already prima facie. I was referring to a prosecutorial decision. Remember, if I receive a docket, I have to make a prosecutorial decision whether there is sufficient evidence to proceed or not. So there were already those statements of Jooste. Then I instructed that the investigating officers go and obtain further evidence. And I even went to consult with the witnesses myself. And then from there, they came out a whole lot of these statements that were sent to Jooste. He then also talked about them. So I had to request the instructed the investigating officers to obtain further evidence. That is why thereafter I charged the accused.
So let's say you had not resigned as the prosecutor from the NPA and you would still be dealing with this matter even by now.
Yes.
Maybe to how far would you have gone at this stage? Would be still, if the matter was still in your hands, would be still complaining about it being stagnant? Because the complaint or the concern that we have here is that, one, it's unjustifiable that a decision to strike it off on the basis that more witnesses have to be added was taken in 2017, correct?
Yes.
And when you calculate time from 2017 to date, that's a very huge period. So would it be in the same position now if it was still under your hands?
I can say that I'm very happy that the matter is being considered, and it is the NPA is.
But when has it been reconsidered, Mr. Advocate Masha?
There is a letter from the NDPP which indicates.
Thank you so much, the Democratic Alliance.
Thank you, Chair. Thank you, Advocate. Advocate, why did you resign as a prosecutor?
I resigned. Well, most of the things are personal, but I resigned to look for a better job. And
so I can't hear you very well. You're a bit far from the mic. Sorry.
No, I resigned in order to get better conditions. Let me put it like that.
What were problematic about your conditions?
Personal things that were affecting me, including health consideration.
Okay, but anything other? I mean, I respect your personal reasons, but in terms of the workplace and the conditions at the workplace, were there specific things that were hindering you or bothering you or frustrating you?
Not at all. I was working so perfectly in harmony, in peace with my colleagues, especially those at the organized crime. We were overwhelmed by work, but yeah, things went well. But now, if you are involved in court work for such a long time, sometimes it gets to you. So yeah,
I can understand. So one or two things that, for the record and for clarity, would you say, or maybe let me state for the record, I think the emails, the abusive emails that you received are inexcusable, right? And one should never be spoken to like that. And it's just, so let me get that straight from the start. But one question I have, and it's something similar that we sometimes experience as MPs, is that it's not abnormal to receive messages or things, especially on social media and now and then an email, which indicate some sort of dislike to you. Would you say it's abnormal for prosecutors to not be liked by the people that they want to prosecute?
Not at all. It's not abnormal, but again, that does not mean that if someone goes overboard, it is not illegal for them to do that. Yeah.
And I can understand.
That is why I stayed on for several years. I experienced these threats, but then there was this duty upon me to, what do they say, to be impartial, not to act through fear or otherwise, yes.
And did the MPA ever do any kind of, or allow for any kind of threat and risk assessment to be done for you?
Yes, at the time when there was a direct threat from Mpumalanga that the SSA had picked up, the NPA rushed to do the threat assessment and provide me with bodyguards. I think I spent 3 years being with the bodyguards.
More or less, what time period was that, advocate? Just for the record.
Up until 2024, when I resigned 3 years backwards.
Okay. Okay.
Yes.
Did any of that protection continue? But let me rather, I don't want to put you at risk in any way. Did you have any conflict or disciplinary matters inside the MPA while you were there?
No.
None.
No.
And you, I mean, I welcome it. I think you said earlier you were working in harmony with your colleagues. I think that's important. Something that bothers me slightly about the testimony that you've shared is more with regards to the so-called infiltration, whether it's Mr. O'Sullivan or anyone else. I'll tell you why. It just simply cannot be that easy. And not aimed at you necessarily, but I want to understand how can it be then that one individual is able to overthrow or influence a case to this point, or allegedly do it to this point. I mean, if you're sure of your case, which I believe you are, it just doesn't make sense to me that we're now so many years down the line and we haven't seen any form of prosecution, never mind conviction, of most or any of the matters that you've mentioned. Maybe speak to me on that. What are your thoughts? You know, the allegation has been made today that it's both IPID and the MPA. Are we then saying that the MPA is an infiltrated institution? Speak to us on that.
Well, in regard to the NPA, I do not have evidence that NPA is infiltrated, but for the email that O'Sullivan sent to me where he attached the internal memorandum of the NPA and the affidavit that he submitted at Zondo, which he was supposed to direct it at the Zondo Commission, but he made sure that the copy of that is directed to me so that I can see all the insults that he was hailing. But in that, he admitted that he got the internal memorandum from a whistleblower in the DPP office. And on the other issue of IPID, that one I have referred to the contraventions of Section 33(5), Section 25, where several instances of leaking or disclosing of information to private persons took place. So that one, there's evidence, direct evidence of the commission of those offenses, and it proves that the IPID was indeed infiltrated.
Are there any of those specific individuals, whether MPA or IPID, that you're aware are still there? And if so, who are they?
At NPA, O'Sullivan did not disclose who he got the prosecution memorandum from. At IPID, is those people that were charged and other suspects that I cannot mention their names before or until they appear in court.
Would you be able to, for the record, even if it's in writing after this, provide the committee with an exact timeline in all of this to see the decisions you personally took in relation to this investigation? You know, what kind of communique was done to your seniors, to anyone else for that matter, what was reported or not reported? And you can obviously include any form of, whether it was harassment or intimidation, any kind of alleged misconduct. Would you be willing to share that with the committee?
Yes, I would share with the committee because remember, I'm outside now, so I relied on information that I got from the NPA, and I'm very grateful for the NPA that they cooperated and gave me some of the information, although I discovered that in some of the files there is missing information, but as far as I can get that, the relevant information, I will try to avail it to you.
Thank you, Advocate. In terms of documentation or documenting of your concerns, when you first became aware of any of this alleged misconduct, and the reason why I keep mentioning the MPA and IPID is because, broadly speaking, allegations were made in both directions today. Did you, and this is again for the record, did you formally record those concerns in writing and report them to your superiors and any other competent authority?
Maybe I should just explain that in the DPP office, when we took our decisions, we did that in conjunction with a deputy director. So my deputies were informed of all those problems. All those problems that I was facing. In fact, I wanted to show you Section 24, subsection 8B of the NPA Act says that any power or function which is exercised by a deputy director of public prosecutions is construed to be performed by the DPP himself. So I informed them.
Are there specific investigators or prosecutors or even witnesses that would be able to corroborate your version of events as you've described them to the committee today? And if so, who are they?
Which version of event are you
No, I
referring
think to corroborate the whole matter, especially regarding O'Sullivan, that you've described today during the sitting.
Oh, no, there is evidence of that. We have witness statements. We have the downloads of the phone. We have witness statement from TransUnion where we received the information and they provided us with the original statements which showed that there were the credit reports of people were accessed. So we have overwhelming evidence in that regard.
I've got 2 or 3 more questions for you. The first one is, what's your relationship with Mr. Khomotso Pakhlane?
I have no relationship. She is I won't say a witness, not even a complainant, because the complaint was opened by General Ntebo Mabula.
Okay. And then, just for clarity, one of the annexures today, it was an email that was sent by Mr. O'Sullivan regarding 3 counts of alleged fraud. The first one was the creation of a letter, 7th of November letter in 2017. It says that, I'm going to quote it directly, Mashugha was unlawfully and intentionally made a letter and did so with the intention of misleading the reader into believing the letter was sent by your good self. This was referring to Advocate Zinyati. The second one was also a second count of alleged fraud, where he says at 9 a.m. on the 8th of November at the Pretoria Magistrates Court, when Mashugha handed the 4-page letter to my attorney and told him the DPP has approved racketeering charges against your clients, he went on to say that he had applied for the requisite certificate in terms of Section 2, etc., whilst at all material times Mashugha knew that the DPP Gauteng North had not approved any such charges. And then the third one was the third alleged offence of fraud, when Mashugha told the Pretoria court that DPP had approved the charges and he was just awaiting the requisite approval from the NDPP. What is your comment for the record on those 3?
The first one of fraud, the DPP or the advocates in the DPP communicate with outside parties or the lower courts in the name of the DPP. So we prosecute in the name of the DPP. You will see our indictments are written in the name of the DPP. So even if they are, the DPP himself is not involved in the in signing the indictments, the fact that they are signed by the DDPP is in terms of Section 24(8)(b) construed to be the DPP, as I have alluded. So that letter that O'Sullivan is referring to there, I'm aware of it. He did send me an email to that effect. It was signed on behalf of Advocate Mzinyati, I think, by Dikeledi Sikumba. So it went out in the name of the DPP. And then on the issue of me misrepresenting that a racketeering certificate has been granted, I think you just need to look at the record. The record is clear that I was applying for a postponement in order to engage in a process of applying to the NDPP to grant a certificate. I never said that the racketeering certificate was granted.
Thank you, Advocate. Then my final question, in terms of the removal of the criminal case from the court roll, pending...
time has unfortunately come to an end. Can
Thank you,
we
Chair.
get the next speaker?
Thank you, Chair. Thank you, Advocate.
Thank you very much, Chairperson. Good Advocate, how are you?
Thank you. Fine. Thank you.
Chair, before getting into it, I think I want to ask you a question, because the reason we're sitting here is to better enable and strengthen our institutions. So from resigning from the NPA, is there any 3 things that you can give me in short to improve the situation at the NPA? Is there anything that needs strengthening at the NPA where they're currently lacking extremely, that is contributing to any of the mess that we see ourselves in?
What I know is the problem that I was facing there was the overwhelming work, especially in the organized crime unit. So the organized crime unit consists only of senior state advocates, no juniors there, because of the kind of cases that we are facing there. So you find a person having 4 cases, but we can fill this whole
So capacitation
table.
is one of the major
capacitation, and then people are overworked. But the credit that I can give to my colleagues is that they were crying like an ambulance crying, but going forward, doing the job. No, there was no much complaint in terms of them doing their job.
All right, Advocate, we'll pause it because of the time. I've got extremely limited. I just want to find out, and I know you cannot speak about your current employment and you do not wish to do so, so we'll try not to traverse that, so apologies if I do. But you spoke when you resigned, there were security reasons that existed while you were employed. And you then went on and mentioned that, you know, there was an assassination attempt and it was meant for you. Is this the concrete reasons that you say that there were the threats? It's because of those assassinations at the time?
Yes, I did a matter where certain syndicates were involved. And then during the bail application, that information came out, but we were just given some limited security. And then the threats were carried out against my investigating officer, one Colonel Bruver. So after they killed him, that is where the NPA now became serious and placed me under that protection, because the credible information from SSA was that me and the IO were supposed to be killed, because they thought if we are killed, the matter will not go forward. But I proceeded with the trial. When I left the NPA, the matter was parted, but we had called some of the witnesses.
Did any of those, and you don't need to name them, but did any of the people that tried to assassinate you, were they in the departments, any of our government departments, which was a total different syndicate on its own?
I do not know the people that tried to assassinate me personally, but the information was that the suspects in that case that I was dealing with were involved in the organization of those.
Thank you, Advocate. Did you have any cases that were opened against you? And if so, how many?
I do not have any cases opened against me, but I know that in one of those emails, O'Sullivan says that I'm conflicted now, I must leave the prosecution against him because I am conflicted. He has opened a racketeering case against me, but I never...
But you've never had any other cases against you?
I was never
Thank you.
informed.
I want to circle back to something you spoke about earlier, about that 48-hour arrangement with Paul O'Sullivan.
Yes.
I think that was a bit of a shocking moment. I just want to find out, is this a common practice? Does it occur often? Is there anybody else with these arrangements that you know of?
From my personal knowledge, I have never come across this kind.
Yeah, I think
of
it's ludicrous.
arrangement.
Did you ever question this?
Yes, I questioned it with the SAPS on the same date that I was I appeared in the High Court in respect of the arrest of Mr. O'Sullivan. Then after the application, I think I questioned the counsel who was representing the SAPS to say that, but this thing is ridiculous. Why don't you take steps to rescind it? And then in light of what Mr. O'Sullivan is doing. And then I don't know whether they started the process, because he said he's going to advise General Patlani that they institute rescission proceedings. So I don't know.
Thank you. I want to speak about paragraph 106.2. We know Ms. Streng's phone messages were downloaded but my question doesn't pertain to the messages or the content. But I want to understand why Paul O'Sullivan is telling you this in that email in 106.2. Why does he believe you took the phone illegally on the 4th of November 2017? Because you made it perfectly clear that it was a legal seizure. You explained that today quite at length.
Yes, I do not know why he said that, but Paul O'Sullivan kept on making all ridiculous allegations against me. So, but I understand he's just an individual who is trying to get out of a sticky situation.
You assert the infiltration by Mr. O'Sullivan, and you stated the memorandum ended up in his hands. And I don't want to underplay your claims about Mr. O'Sullivan getting the paperwork and memorandums and so forth in his hands. But what I do want to ask, is a single leak sufficient to prove systemic infiltration as a whole? Because we keep referring to one individual, and I think the question isn't about Paul O'Sullivan as such, but it's about IPID as an institution. And, you know, everything we hear is either Paul O'Sullivan or Sarah Jane Trent. And I want to know, is the institution compromised or isn't it?
In terms of the NPA, I cannot say there was a systemic institutional reputational damage in terms of the infiltration, because it was just a single incident that I became aware of due to O'Sullivan sending me that email and that affidavit. But with IPID, there was an ongoing a breach and violation of the IPID Act and corrupt activities. So it was so intense. And remember, the scary thing about it is that the information was being disclosed to a person who is not vetted, despite the IPID Act saying that the members of IPID themselves had to be vetted.
All right. I only have about a minute left, so I just have two questions. So I'm going to ask quickly and then you can answer them. If the infiltration was known, what urgent internal process took place or disciplinary action if there was this infiltration? You must have communicated with us with IPID. They must be aware of it. And the second question is, why did IPID allow O'Sullivan and Trent to lead investigations when it was launched against Nhlanhla in the first place? What influence did he have over them? Because reading all the allegations and listening to all the witnesses, that there was infiltration of this in IPID by these two people, no one answers as to why they were allowed to do it. Why did IPID, according to you, allow complainants then to interfere?
Yes. One should remember that if a complaint could be launched to IPID, it would land in the hands of Mr. McBride. On the other hand, we had O'Sullivan, who was shooting down any argument about IPID infiltration. On the other hand, we had the media, which was used to give a good story about IPID, especially against Nhlanhla in the investigations. They were leaks. They were leaking. IPID was leaking information and false information in some respects. For example, that 80,000 rand sound system, we know that it was false. They admit themselves in the downloads that they know that it was false. They are going to get into trouble. Then Sarah says, no, don't worry. We are gonna hit him for a 6, whatever that means. So they are gonna go after him again and again and again. So there was this wall of protection against anyone who tried to get some explanation as to what is going on. There are many other journalists who sent questions through asking, why is a private individual involved in the investigation of IPID? They were asking those questions, and those questions were never answered, but no one else was interested in knowing until the case was opened.
Thank you, Advocate, and thank you for answering in such a level-headed way, in a way that we could understand. I really do appreciate it. Thank you.
Thank you very much.
Honorable Kola Barnett. Honorable Matthys.
Thank you, Chair, and good afternoon again, Advocate. Just some disclaimer notes. So we must not be gaslit about Paul O'Sullivan and Sarah Jane Trent here. They are the people that are before us. They're the ones that evidence has been submitted. Obviously, it needs to be tested. So under no conditions must their role that they played here be gaslit under the guise of systemic. And we're not denying that there is a systemic problem, but how they entered into the system is going to be able to guide us on the systemic corruption and how our systems can be captured by that. But we must be very clear. So we will continue talking about Paul O'Sullivan and Sarah Trent because it's explosive and we must get to the bottom of it. I just want you to clarify just initially, who was the Deputy Director of Public Prosecutions and the NDPP that would have had to deal with the racketeering certificate?
It's Advocate Hein van der Merwe, and the NDPP would be Advocate Sean Abrams.
Okay, and then so you speak about that in paragraph 131 and 135. You didn't outline the timelines more or less in your affidavit. So can you provide the dates more or less when those discussions were had regarding the issuing of this racketeering certificate, just more or less?
Okay, maybe I do not have more information because
just the time period, you don't remember?
The time period would be 2018. The first indictment was formatted and referred on the 31st of January 2018. And then I saw from the efforts that I could make, I saw that in April 2018, one of the prosecution memorandums also went out. So okay. I think
so around then. Okay,
I think that would be the second prosecution memorandum.
Okay. Could you have continued with the matter without including the racketeering charges? And then during the court proceedings, after the back work was done for the racketeering certificate and charges that be added, was that an option?
Yes.
And why wasn't it done?
That was an option, but it would have made more sense to present to court a complete picture that these people are an enterprise, in fact. So we had overwhelming evidence of those people, but if we were to charge them, the advantage of charging with racketeering is that there's no misjoinder. So number 1 and 3 can be involved in count 1, and then number 1 and 5 and 7 involved in count 2, and then as long as there are at least 2 offenses that each individual has committed in terms of Schedule 1 offenses, then there's no misjoinder. But if you are not to follow the racketeering way, then you would end up having 3 or 4 different trials.
That was a
depending on which suspects or accused are implicated.
Did you and your team anticipate that the court would strike the matter off the roll because you were waiting for the racketeering matter or the racketeering certificate?
No, we did not anticipate because the case was only on the roll from February until November. So it was not even a year old. And then we had
A year is a very long time, but
but we had compelling reasons why, because we had just been able to download the cell phone. So
were you surprised?
I was shocked. I was shocked of those allegations because it was people who were regarded as in public as corruption bastards. They are going.
And who was so it was before the High Court, obviously, the case. So who was the judge that struck it off the roll?
Or it was a magistrate, not a
was
judge.
Magistrate level, yeah.
I can't remember, but on the record of the magistrate
So
court.
I will ask our evidence leaders to look into that. So do you think that you and your team at the NPA made the decision that you took to wait to add the racketeering charges? Well, I guess you're saying that you didn't anticipate that the magistrate was going to strike it off the roll.
Yes.
Was it in the best interest of justice? Because here we are right now. And if we didn't even have this committee, I'm sure that case would have just been collecting dust somewhere.
Yes, what is best is what the acting DPP now has decided, that the matter is now going to be given to an advocate who will relook at the charges now.
Okay, all right.
Yes.
So we will follow up on that on our side. So let's talk about this case that Sarah Jane Trent opened for kidnapping. So you've been in the space of prosecuting and in the NPA holding very senior positions. So her case, I just need clarity. You said a non-prosecutorial, what is it? Non-prosecutorial certificate was issued when she opened a case that she was kidnapped.
Yes, a nolle prosecute certificate,
yes.
a decline to prosecute.
Yes, decline to prosecute.
Yes.
Okay, so is this something common that you see? Do you see it, and this is obviously your opinion in the legal space, that it was intentionally done, if indeed it didn't happen, so it can be used as a way of making sure that her phone messages do not enter evidence?
Yes, it was designed to do that, but I've seen in my experience, accused persons and suspects will do anything. They can even say that they were assaulted, and then the open cases only to find later that they were never assaulted. So they sometimes they are assaulted. So these things
But
happen.
you know
So
where they learn from? They learn from the top-ranking officials in our criminal justice system, because that's all we've seen here, is all these senior leaders that are leading in our criminal justice system, from SAPS to NPA, all they do is open cases and write statutory declarations against each other. But I'm going to push you, yes, because you see that chair of ours is a time thing. So the question on if the committee writes to the NPA, now we want to have access to all those messages of Sarah Jane Trent, because she's gone through hell or high water, sending even us emails with lawyers' letters, etc., saying that those messages must not be before this committee. What reasons can the NPA or SAPS, because SAPS obviously they collected it, so they did the investigation, you have the docket there at the NPA. What reasons, legal or procedural reasons, could they give us not to have access to all those messages? even if we decide as a committee or we make a decision as a committee, that they will be confidential and we will not release them?
Yes, obviously, when we're looking at the interests of the upcoming criminal trial, the NPA will look at the issue of confidentiality, whether if those are disclosed, there will be the confidentiality, which would lead to the integrity of the information can be ascertained. But other than information that would be in the charge sheet, because the charge sheet is a public document. So facts that are alleged in the charge sheet or the indictment, it's something that can be shared. But I think in terms of the information itself, the NPA might want to have the information tested first in a trial, within a trial at the criminal, in a criminal court before they would accede.
So you anticipating that the first thing will be that they will question the evidence. Okay, let's go quickly to the issue that you say in paragraph, I think it's paragraph 51, that Northwest, the Major General who was the Deputy Provincial Commissioner, Major General Mabula.
Mabula, yes.
Why was he investigating the matter and not someone in Gauteng? Did you ever ask that question?
No, the information that I was given was that because it is the national commissioner who is involved and who is based here in Gauteng in terms of residence, if they get investigators from out of Gauteng, it would give some form of objectivity to the investigation.
Because we had Lieutenant General Khumalo here, and he said under oath that Gauteng SAPS is corrupt. I think he even went as far to say there is no, we'd be lucky if there's 1% of our SAPS members there that are not corrupt. Do you think that might have also been one of the reasons why the National Commissioner, because you're saying it was the National Commissioner that gave instructions, because he also came here and said that he referred the matter to Northwest to do the investigation. Is that something that happens regularly in your experience at the NPA, especially on such matters?
I am not aware, because matters that are referred to us as the NPA, well, at the DPP, we have not experienced such a form of corruption or interference. Yeah.
So the question is that has it happened, or does it happen often, that you can get a case where another province is investigating a matter that should have been investigated, for example, here in Gauteng?
I think I have never met something
but it was a
like that arrangement. No, I have never met that. But we don't have a right to question us as NPA. Documents are referred to us.
Yeah,
then we
I was just asking, in your experience, do you know it, not whether you had power to decide who and whatever it is. It was just to get your experience in doing that. Do you know who was the Deputy Provincial Commissioner in Gauteng during this period when Paul O'Sullivan and Sarah Trent seemed to be running amok in our criminal justice system?
No.
You don't know, and I think our evidence leaders must be able to get that information. And I asked that at the back of the fact that Lieutenant General Khumalo said that Gauteng was corrupt. So we must work out who are the leaders. And also Lieutenant General Mosikile that was here yesterday. She and that Paul O'Sullivan, she gave under testimony that he would come and drop off dossiers in her office, etc. So he was doing a lot of forensic investigations according to her, and bringing that information to Gauteng without vetting him, not even knowing if he's even
Angazita.
forensic
Your time-
justice.
your
Thank you.
time-
I want my 15 minutes now. Yeah, sorry. Okay. Thank you, everyone.
Thank you.
Thank you, Honorable Chairperson. Good afternoon, Advocate.
Good afternoon,
Mashura.
Honorable.
Camille Drift case. Who is the complainant in this case?
The complainant is General Mabula, because he's the one who opened a case after the threat assessment. Then he registered the case and investigated it. So General Khomotso Patlane became a witness as an A2. So General Mabula is A1, General Patlane A2.
This is the same case that was handed to you eventually.
Yes.
No. The Patlane case, I take it that Paul O'Sullivan is actually a complainant. Is he
Yes.
alone or a group of them?
Yes, he's the complainant.
Okay. Is it standard operating procedure that complainants can actually become lead investigators in their own cases?
It is not, and especially taking into consideration the sections that I have read out of the IPID Act that specifically say that at paragraph 30 or 31, I say there that Section 2D of IPID Act provides for the object of this act, which is being to provide for independent and impartial investigation of identified criminal offenses allegedly committed by members of the SAPS. And at paragraph 33(2) provides that any member of the directorate who willfully discloses information in circumstances in which he or she knows or could reasonably be expected to know that such a disclosure will or may prejudicially affect the exercise or the performance by the directorate of the powers and functions is guilty of an offense.
Would you say then, therefore, in the light of the legislation that you have actually just alluded to now, that the actions of Mr. O'Sullivan in leading the investigation in his own case in full knowledge of the IPID was deliberate?
It was deliberate, it was conscious, but he had to do his part in terms of showing General Patlane that I can do what I promised you to do, number one, and then I can get you dismissed or suspended.
In paragraph 131, the Patlane, the anti-Patlane group, you are actually saying that, in your opinion, there was evidence of a sustained, continuous, unlawful campaign to target General Patlane and other victims.
Yes.
Why is this?
There was a continuous
disclosure. Whatever was investigated with a person like Trent and O'Sullivan, who were supposed to be part of the investigation. When applications for 205, Section 205 were made, they were made by them. When the IPID, the IPID only took those 205s so that the magistrate can sign them and then send them to the service provider. The bank statements, the cell phone records, they were received by the same individuals who then just emailed them to O'Sullivan and Trent. So this was continuous up until they were arrested.
Would you actually also conclude that Mr. Paul O'Sullivan and Mr. McBride and others were part of this group?
Yes.
The Anti-Pahlane task team.
Yes, in fact, I describe them as the persons who managed the affairs of the enterprise, because you have to differentiate in terms of Section 21E of the Prevention of Organized Crime Act. You have to differentiate as to who is participating in the racketeering activities and who is managing the enterprise. So McBride, Trent, and O'Sullivan were identified as the persons who were managing the affairs of the enterprise.
Well, in fact, your statement is corroborated by the statement made here by Mr. Nkabinde. Because
Yes.
Mr. Nkabinde also made such an assertion that Mr. McBride and Mr. Paul O'Sullivan were part of the Pahlane task team.
Yes.
Together with him, Nkabinde himself.
Yes, together with Nkabinde.
There is somewhere where you made mention of former Minister Mr. Nhlanhla's statement. Having you obtained a statement from former Minister Nhlanhla.
Yes,
Would you have-
after we discovered that his credit record was also obtained unlawfully by Sarah Jane Trent on the instruction of McBride, who gave Sarah Jane Trent the ID number of Minister Nhlanhla. Then I instructed the police to approach Minister Nhlanhla and obtain his statement, and that was done.
Yeah, in paragraph 92, where your matter which you had worked so hard to actually collect and collate evidence for, was struck off the roll. What would be the legal basis for doing that?
It will be for the unreasonable delay. So I tried to argue against it that there was no unreasonable delay. We have concrete reasons why there was a delay, but it was not unreasonable. But the magistrate did not agree with me, and I had to live with the fact that the magistrate did not agree with me, and then try to address the reasons for the delay and try to get the indictment completed and the prosecution memorandum so that we can apply from the NDPP for the racketeering certificate, but there were some challenges in regard to that.
In your opinion, advocate, why would Paul O'Sullivan and Mr. McBride work so hard to ensure that General Patlane actually ends up in jail. Why was that? Why is that?
I watched, I think at some stage, there was evidence before this honorable court. I just don't remember who gave that evidence that there was an encounter between McBride and General Patlane at his estate whilst McBride was still under suspension, where he wanted him to be on their side. And then General Patlane, I think, did not accede to that. And then there was another instance where General Patlane had experienced an attempted robbery. Now, McBride told Sarah Jane Trent to post a YouTube video which in which it was suggested that General Patlane was hiding behind a sofa. So Sarah posted with the YouTube on her name, only to discover later that it was on her name. Then she rushed and deleted that YouTube video and posted it under a pseudonym. So what I think was happening is that they wanted him to be part of their group that would consist of all the criminal justice system individuals who are grouped together and who are carrying out their own objectives. But Patlane refused, and then he was supposed to be dismissed or whatever. And it also appears from their own communications that they wanted to ensure that Patlane is removed.
Yeah, in paragraph 110, you actually say emphatically that the objective facts set out in your affidavit, and in particular the evidence, if I were to quote what you are saying, emanating from O'Sullivan and Trent, clearly demonstrate that IPID, to the contrary, was captured by O'Sullivan and Trent. Do you still stand by this?
I still stand by this.
Okay, thank you. Paragraph 118. Do you believe that your actions, that of signing of a warrant of arrest for Paul O'Sullivan, was in contempt of High Court order?
Not at all. First of all, the order that was made in favor of Mr. Paul O'Sullivan did not amend the law passed by the Parliament, the Criminal Procedure Act. So the Criminal Procedure Act empowered the prosecutor and the magistrate to be involved in the signing of a warrant of arrest. So, the court order did not interdict or prohibit the NPA prosecutor from signing the search warrant. What it did was, after the police gets the warrant of arrest, they must now give Mr. O'Sullivan 48 hours notice, but it did not prohibit the signing of a warrant of arrest.
So why would the Democratic Alliance, through its spokesperson, Advocate Honorable Glenis Bredenbach, chastise you of actually blatantly in contempt of court?
I don't know whether it was pure politics or an error in understanding that this order did not prohibit me from signing the search warrant. Maybe it was just an error on her part.
My last question has to do with the braai, which was actually organized. And Mr. Gavinde, when seated where you are seated, actually also said that that was not a braai. It was in fact a meeting called ostensibly to concoct, things against General Pathan. And when Mr. O'Sullivan was here, he said, "Oh, that's rubbish. It was actually the book launch." So in your own understanding, what was it? Was it a book launch, a meeting, or a braai?
Objectively speaking.
Thank you so much. You will respond to that question during the chairperson's time. The time of the member has ended. It's now the 30 minutes for Honorable Sol start now.
Thank you, Chair. Advocate Masha, good afternoon.
Good afternoon, Honorable Sol.
This part is going to be very important because listening to you, it seems like you are going to give me a whole picture of Mr. O'Sullivan. Our engagement is going to be around me trying to understand the holes and how deep the holes of corruption goes. So I'm going to ask you some clarity questions based on your statement. And then we've also just received a few, I think about an hour or so ago, affidavit from Mr. Nhlanhla. So I'm also going to ask some clarity questions around that. Okay?
Okay.
So let's confirm, you testified that you had to get permission to provide this affidavit. And this is the affidavit that you also provided in the Zondo Commission. I just want to make sure, is the one that we have before us the exact same affidavit that you submitted to Zondo?
No, it is similar in certain respects because I was addressing different issues. So it's not entirely similar. In the Zondo Commission, I was responding to the allegations of Mr. McBride that says that, amongst others, I was one of the core groups of NPA advocates who are captured and who target people with fake cases. So I had to prove in my affidavit there otherwise. So here I've just been invited by this honorable committee to assist the committee with information regarding the investigations or allegations relating to what I have already described in my affidavit.
Yes, including why you decided that you should lay charges. What were the reasons? That's part of why you are here, right? To tell us what made you decide. And one of the elements is the security breach at General Pathan's house. Correct.
Okay, yes, why I preferred charges against the accused. Not why I laid charges. Remember, I did not
preferred,
lay
that's what-
charges.
You must
preferred
forgive me
charges.
because you are the advocate. I'm a
Yes.
layman.
Yes, I
So
just
when
wanted to-
when I say lay the charges,
yes,
I mean use the word preferred the charges, and I know that you were not leading, you were guiding.
yes.
I'm still learning the difference, but
No,
be patient with me.
I just wanted it to come correct in the record.
All right. So preferred charges. So you agree that one of the reasons why you are here also is to testify on why you preferred charges. And one of the reasons why you preferred is the security breach at General Patlane's home, correct?
No.
No?
No.
Okay.
Remember, the security breach happened first,
Mm.
and there was an analysis. Thereafter, an investigations, a docket was opened where investigations were made. After those investigations, the docket was now sent to the DPP office for a decision. Then the deputy director then allocated the docket to a senior state advocate to consider. And then that senior state advocate, after some time, resigned. Then that's where now I came into the picture. The matter was reallocated to me. Then I studied it. I saw that there were some few investigations to make, and then thereafter I could say that they can make.
But
they can be charged.
Okay, you must help me now because the core of the whole thing is on that day where the allegation is also that Paul O'Sullivan and others portrayed themselves to be IPID officials. And this is when the security breach happened, not?
Yes, this is when the security breach happened. So but now the docket, for the docket to be in the DPP office referred to there was an investigation of that security breach where statements were obtained which substantiated that security breach in terms of statements, in terms of witnesses saying that we were told that whoever is an IPID member, they acted as IPID members, all that information in the docket then was brought to the DPP where we took a decision.
So then it was part of your consideration.
What was part of my consideration?
The security breach. It's all together, it's all one event.
Yes, but if it was only a security breach.
No, I didn't say only, I meant one of the elements that impacted your consideration.
Yes, one of the consideration, yes.
Yes, and that's why I was shocked when you said no.
Yes, but remember, security breach on its own is not
No,
a charge. I could not have taken the decision based on the security breach alone, but the offenses which happened.
That's not what I meant.
Okay, if you don't mean.
I didn't mean it's you separated and made and did a charge on.
Okay.
I mean the contributing factors that you considered that caused you to prefer the two charge.
I understand.
All of these things added up together.
Yes.
So the security breach was one of them.
Yes.
The reason why I'm asking is because I'm getting to, when I compared your Zondo Commission affidavit and this one, Section 74 in your Zondo Commission affidavit speaks to the report that was done for the security breach. In 74, you say that the report by crime intelligence does not speak anything about the security breach. Then in paragraph 84, 82, you then say you never had sight of the report in your Zondo affidavit. That's the portion you left out on the one for us on page 32.
Yes, I left out information that is not relevant for
Now,
purposes
I feel this is relevant, so I'm trying to push you towards that to say, I consider this relevant, especially the fact that in the Zondo affidavit, you say, section 74, there's no mention of the security, of whether or not there's a security breach or there was a security breach. Then in 82 of the same document, you say you didn't have sight of the report.
of the report of security breach.
That was done by CI.
Yes.
So
If
now
you-
my question is, if you haven't had sight of the report, how do you know what was mentioned or not?
Well, I would have to get that Zondo affidavit because I did not study it in detail. In fact, I just used it to amend it so that it can fit the purpose for this.
That's my point. So if you amended it, then it means when you came to section 74 and 82, you chose to leave them out.
Of this affidavit or of the Zondo affidavit?
The one you gave to us doesn't have 74.
Yes.
It doesn't have 74.4.
It cannot have all the
I
all the
understand.
paragraphs because I was addressing different
I'm showing you
objects. Yes.
One, I'm showing you that it's related.
Yes.
Two, I'm showing you that you chose not to put it in this report.
Yes. If you can show me the paragraphs that you are speaking about in the Zondo.
You should know because you left it out. You chose, I'm not going to put this part in.
Well,
So you should know.
So how would I know what I left out? You have to show me that Zondo commission paragraph that you said I've left out so that I can look at it.
This is how you would know. You took your Zondo affidavit, you say you only used it to amend.
Yes.
And then you chose what to give to us.
Yes.
So when you leave out 74 and 82, you chose, I'm not going to put this one that's here in here. You chose that. So I don't need to show you that. However, you can go back to your Zondo.
That's an amendment. That is why I'm saying that you want to ask me about what is in my Zondo affidavit. You can put it in front of me so that I can.
No, sir, I don't need to put it in front of you. I'm showing you that you have left it out. But
Yes.
you can.
I agree. I left some.
So you should know what it
out.
says.
Yes.
So you should know what it says.
How can I know if you don't put it in front of me so that I can compare that in
You
this
already-
affidavit, I left this, it is
Okay,
here
Tara.
in this affidavit.
Okay, advocate, we'll move on, but you already compared. That's the point. By choosing not to include it, you drew a comparison. But there was a reason why I asked that. Mr. Hlangwani, in his affidavit that was sent to us on the group, he alleges on the appeal, he alleges that he did not receive notice from you of the appeal. Is that true?
Partly true. He might not have, he did not receive a notice from me, but he could not have received the notice from me when I had resigned by then.
Yes, but you can't have an appeal without giving notice. That's in terms of Rule 42(1)A.
What I'm saying is, when I have resigned, it means that there is a colleague, a former colleague, who is taking over the matter, who is the one who would serve notices
Yeah, but
on
you, you the one who is challenging his acquittal.
the DPP, remember I have already explained many times that we do what
Just
we are
because
doing.
of time, advocate,
We are doing what we are doing in the name of the DPP. So it does not mean that Mashuha took the decision. If Mashuha is not there, another advocate is nominated to
Yes, but
proceed with the process.
Mashuha instituted it. You see, Mashuha instituted it in the name of the institution, but you instituted it.
Yes.
Yes.
The DPP office instituted. Yes.
Did you go to the appeal?
How can I go to the appeal when
I'm
not-
finding out, did you go to the appeal?
No, I had already left. So my colleague, my former colleague there, is the one who would have attended.
So
the
then
appeal.
would you know whether or not the decision was upheld?
There is a case law. It was reported in, I think, in Safli.
Yeah, I saw it.
What happened? Yeah.
So it was upheld.
Yes, the appeal was upheld.
Yes, he's still acquitted. Do you know why?
Because apparently a rescission was lodged.
Yes. And the basis of upholding it was Rule 42(1)(a) of the High Court rules, the uniform rules, that he did not receive notice.
Yes.
And that's what I'm trying to say to you.
Yes, I heard of that.
All right, so you agree?
Yes.
Hlangwani then also alleges that General Patlane signed off on investigation orders where he was a complainant on the January 16, 2017. Is this true?
January 16, 2017. I don't know even what you are talking about. I don't have knowledge of that.
In the case that you were investigating, that you were dealing with here, he alleges that General Patlane would sign off investigation orders on the 16th of January 2017.
I'm not aware of that, and I'm not even aware what the investigation orders are.
When you order for something to be investigated, if you give authority for it to be done, but you are saying you have no knowledge of it.
No. My responsibility was to guide investigations, which I did.
You see, the allegation that you made that Paul O'Sullivan was basically investigating his own case. Hlangwani is making the same assertion to say that General Patlane was signing off on things that he's a complainant in. That's the point. And you are the one who guided the investigation.
Yes.
Now that's the point. Are you saying you have no knowledge of it?
I have no knowledge of that, yes.
All right. Are you saying for a fact that Paul O'Sullivan has captured IPID?
Yes.
For a fact?
Yes.
How does he do it? Give us a quick idea. How does he do it?
Okay. He paid for the legal fees of McBride.
Yeah.
And then when McBride got reappointed at IPID, O'Sullivan was involved in leading IPID investigators, doing the Section 205s, receiving the information that in contravention of the IPID, the sections, relevant sections that I've already read out of the IPID Act.
Am I understanding you correctly when you say the modus operandi is he writes an email to General Patlane, he threatens him because of what he wants General Patlane to do for General Moon or Monsoon, what's the name?
Moon, yes.
And if he doesn't do it, then he's going to go after General Paslane.
Yes.
Then, if General Paslane doesn't respond, then he uses his contact in IPID to then fulfill this threat that he makes.
Yes.
So he then goes to the house to prove that I'll do what I said I will do in the email.
Yes.
And in this way, he's hoping that it forces General Paslane to deal with General Mosul.
Yes, because every step of the investigation that were carried out, most of the steps he would leak information to Patlane and send him an email and threaten him further and show him that we've got this and this evidence. We've got statement from who and who.
And we know this for a fact that that is the modus operandi, because when he left the sitting the other day, he screamed to my colleague, sort out your loan. And the next day, the whole papers was full. So the question is, how did he know?
Yes, yes.
Where does he get access?
Yes, that's the concern, because we have a person who does not is not even vetted, accessing confidential information. We don't know what other secrets of the state he has accessed up to now. We don't know.
What I want to understand so that we can deal with it tomorrow is that, are you saying that this excess of information that he has, which he's not supposed to have, confidential information, is the thing he uses as leverage to control whoever he wants to control, especially those in the senior or top brass? So he gets secrets about you, he will then threaten you with it, and if you listen to him, he then tells you as a senior police official who to deal with for as long as he has these secret information on you. Is that what you're saying? His leverage is access to private information, uses that as leverage, and then controls generals and officials, senior police officials, to then do what he says when it comes to who he's targeting.
I think that is his modus operandi, taking into consideration how or the conduct, his conduct that appear from the downloads. First of all, there was an instance where the driver of General Patlane, Alvin Dupré, was not cooperating with them in terms of them wanting him to include certain allegations against General Patlane. Now, when he had refused, his ID number was leaked to Sergeant Trent, and it was said, get something strange in his credit report. So they were obviously using the information that they have obtained as leverage against some people.
Does he have private dirt on all senior police officials?
I'm not.
Because if that's how he controls them,
yes,
then that's the access to capture. If the answer is yes, does that mean almost all of our senior top SAPS officials, generals, has dirt that only Paul O'Sullivan knows?
Yes, that is a likelihood, but what I can attest to is that that is his modus operandi. He gets dead against you, then may use it as leverage against you. That is what was shown.
What I'm trying to get at, if we look at it from the other way, if we have generals and senior COP officials who's not corrupt, Paul O'Sullivan has no leverage.
Yes.
Paul O'Sullivan has leverage because senior cops, SAPS officials, corrupt.
Yes, what I can say is, if you are corrupt, he won't have leverage. If you are not corrupt, he won't have leverage against you. But if there's something that he can use against you, he will definitely use it against you. So he doesn't care about the rules. He just goes out and obtain information unlawfully as he wishes, because you can see how easily he accessed credit information records of people and didn't see that as wrong. He said, no, I'm allowed to do that. No lawful reason that he gave.
And I'm sure that's what gives him God's status in his mind, because he's all knowing on everybody's private issues.
Yes, and I mean, he's everything that you can think of. On one of his statements that he shared, I don't know whether it is with Patlani or me, he annexed that statement as an A1, where he alleges to be an engineer. Then I later learned when I was following, after hours, when I was following this committee, that he did not have any qualifications relating to most of the things that he. Then I was asking myself, how is he a prof? He even said he's a professional engineer. So,
Advocate, would you agree with me? The only way for us to remove that God status, fake God status from Paul O'Sullivan, is when our generals and our senior officials stops being corrupt.
I think you are accurate on that one.
I thank you, Chair. Oh, and I thank you, Advocate.
Thank you so much, Honorable Souls.
Are you not thanking the chairperson for being benevolent?
I thank you, Chairperson.
Thank you so much. Honorable Vessels, your time starts now.
Thank you, Honorable Chairperson. Good evening, Advocate Chucha.
Good evening, Honorable Vessels.
Let me start off where Honorable Souls also touched on it. There's the allegation that you took instruction from police, senior police officers, whilst you were a prosecutor, and that you acted on instructions of those senior police managers or senior police management to drive certain agendas for them. What's your comment on those allegations?
If it is in relation to this Camille Drift matter, I have already set out the way the matter was allocated to me. I did not have anything to do with this matter. My supervisor by then, Mr. Nemarani, whilst I was at the organized crime unit, allocated it to a different person. In fact, I was in a different unit, the General Prosecutions Unit by then. He allocated it to Advocate Geyser. And then Advocate Geyser, in due course, resigned. And then, because of the pressure at organized crime unit, the advocates there were overburdened with work. So, Advocate Nemarani approached the DPP, Advocate Mzinyati. And that's how the matter was allocated to me.
Thank you, Advocate. Unfortunately, I don't have a lot of time. But you never acted on any instruction from police. You never.
It is ridiculous to say that because an advocate acts together with the deputy director. So if there is any wrong thing, the deputy director would immediately see that there's something wrong here.
Did you, in your tenure, prosecute a lot of cases against police officials?
Yes.
And against IPID investigators, officials?
It was the first time that I prosecuted a case against IPID official. That was the first time.
Was it the last time?
That was the last time, yes.
Did you not prosecute or start prosecution against Raymond Mabaza?
Raymond Mabaza, I think that name rings a bell.
You can't recall.
Raymond.
I think it was
Raymond
just
Mabaza.
before your resignation. And after your resignation, the case was withdrawn by the then appointed prosecutor because of a lack of evidence. You don't recall that case?
Raymond, I recall the person Raymond Mabaza, but I don't know whether was he an IPID officer?
He was an IPID
officer.
officer.
Yes.
Okay.
But I know there's an accused by the name of Raymond Mabaza that I prosecuted.
Okay. And there was nothing strange with that case at all? No undue influence or?
No, I'm just trying to think the facts in that. Oh no. Was he the one with other co-accused where
something with a Ponzi scheme
where Zimbabweans were involved and he extorted
allegedly.
Yeah, he allegedly extorted those Zimbabweans, and then there was he arrested those Zimbabweans and kept them in the cell.
35,000 rand.
Yes, I remember it.
Arrested by the Hawks, but then there was no evidence then later, apparently.
I do not know the outcome of the case.
Right. I'm covered on the fraud allegations. I think you explained that quite well. And I'm also covered on General Mkhwanazi's involvement in the investigation. You say that you do not know if he was involved in the investigation.
No, I do not know.
Okay. One last question. You now spoke on Paul O'Sullivan, and I think the Honourable Souls asked you in detail with regards to his modus operandi and so forth. But is there any possibility that his means that his means are wrong, but that his ends, his motive might be proper? But might it be that there is truth in some of the allegations that he makes?
Okay. I do not want to unnecessarily encroach on on the cases against General Patlani, especially when I don't know the contents of that case. But what I can say is that Paul is prone to making wild allegations without proof. If you look at the house, he said the house is 4 million, then 6 million, then 8 million, then 10 million. We all saw it in the news. And then if you only to find that he did not do his homework, they had to fraudulently get a search warrant to go to General Patlani's house as if they are going to search for the sound system. But in their communications, they said they looked at the whole house. After that search, they communicate later and said, did you see the aircons, the finishing, and the what? So they were looking for that. So, and also the issue about the sound system. He says the suppliers bought an 80,000 sound system for General Patlani, which was not true. So when
So might it be that corruption is like sardines? When it's sardine season, if you throw out a net, you will catch a sardine. Wild allegations, but somewhere there will be some truth.
Yeah, probably it could have been like that.
Thank you very much.
But the constitutional rights of people matter too.
Absolutely, and the natural justice as well. Yeah.
Yeah.
Thank you so much, Chairperson.
You're welcome.
Honorable James.
Thank you, Chair. Thank you so much, Advocate. You are actually helping us prepare for those two musketeers that's appearing before us tomorrow. So we appreciate your testimony here before us. Ek gaan sommer met die deur in die huis inval. I'm going to ask you, is Paul O'Sullivan a double agent? Like as in good cop, bad cop, does he play both sides? You've investigated him. What's your take on that?
I've just investigated him in this matter of Camille Drift. So you remember when I investigated him, it was for a complaint that was made by General Patlani. So I am not able to give a general picture as to whether he would be a double agent, only on the basis of one investigation that I carried out.
Would you say, so you won't be able to tell me if he's part of a drug syndicate? If he has affiliations into drug syndicates, drug cartels?
No, I cannot be able to say that because the only issue that I raised was that 3rd December 2016 meeting where I think one of the honorable members said it's related somehow to Jacob Naro, who is who might be related to drugs with crash share or what, but I don't have that
You don't have evidence.
information. Yeah.
Okay, that's fine. Does Paul O'Sullivan, based on what we've heard, benefit from state seized goods and property? Because that's the pattern I'm beginning to pick up here, because he bought the Kwechna home, right, which was seized by the state. And also there was a threat to Patlani's accommodation, saying to him it will be auctioned and he will buy it.
Yes, yes. And then there's what I remember is there's an email. I think it was read out where he said he got donations of 20 million or some sort of pledges to an amount of 20 million.
Donations for what? 20 million for what? Because when he appeared before us, he said he never ever received any money for all the good work that he's been doing over the 36 years.
On the Patlani emails, he sent Patlani an email referring to a donation or pledge of 20 million that he had got.
For what was that donation, do you know?
He did not explain for what.
Do you think that this could be part of the modus operandi? In terms of buying and benefiting from properties that the state has seized, with its property, with its goods?
I'm not sure of that, Honorable.
Are you familiar with the Code of Conduct for Security Service Providers 2003? You familiar with that?
Yes.
Okay, section 15 in particular, which talks to state interference. Okay?
Yes.
Why was this not added to your charge sheet?
We did investigate that. In fact, Sira also wanted to investigate and charge Mr. Paul O'Sullivan because at some stage he had registered with SIRA as a security provider, as far as I can remember. So SIRA says that if provides that even if you are not a member of SIRA, but if you provide a security service, then they can have jurisdiction over you and charge you. So the investigation was referred to SIRA, and I know at some stage I was contacted by an official from SIRA regarding that investigation. So I don't know what happened.
That was actually going to be my next question, if SIRA actually opened up a case against him. Because when Mr. Paul O'Sullivan appeared before this committee, he came here with evidence and he gave testimony alleging that he has investigated, and even today, senior SAPS officials, which he had absolutely no right to do. He should have been arrested, according to the section 15, that says, may not perform any act which interferes or hinders, obstructs a security service or an organ of state in performing any function. He is guilty, he has been interfering. May not advise, he has been advising. May not undertake or assist in the entrapment of any person. That's what he's been doing. May not concede facts regarding commission of an offense from a security service or any organ of state. That's what he's been doing. May not employ a corrupt, illegal, or unlawful method or technique, or use unlawful threats, intimidation, misrepresentation. That is everything. Here we have regulation telling us what Mr. Paul O'Sullivan cannot do. Mr. Paul O'Sullivan has even come before this committee and told us that he used his own tools of trade to assist IPID, which Mr. McBride said it was needed because IPID didn't have those tools of trade. And here we have regulations saying that he's not allowed to do it, that we can actually charge him.
Yes, we can.
That he was never meant to investigate any senior SAPS official. We can charge him.
Yes, we took.
Including Jackie Celebi, including Patlani, including every time he opened up his mouth, he wasn't even supposed to have an opportunity, a platform before this committee to present all of those cases. Am I correct in saying that?
Yes.
So am I correct in saying that Mr. McBride has, at this point in time, Robert McBride has absolutely no business even working for another state organ, because he facilitated this and he enabled this?
What I can say, or the extent that I can go, is that this evidence proves that they acted wrongfully. But as to whether you can be involved in an organ of state, someone else has to make that call. I cannot.
Don't be scared to say someone has to. He cannot perform.
Indeed, the conduct is egregious.
So basically what you are saying to us today is what we have been saying all along, is the fact that bottom line is, here you have regulation that proves that these two musketeers had absolutely no business. They even had no business getting a reward, which some of the members were justifying.
Honorable James, may we please, you and I, refrain from using the word musketeers.
Okay, I withdraw, Chair.
Thank you so much.
Thank you. So basically, what can I call them?
The witnesses that will be before us tomorrow.
Yeah, sorry, I'm just trying to get my trail of thought back now, Chair. Mr. Paul O'Sullivan and Sarah J. Trent had absolutely no business in doing any investigations.
Yes.
And they should be charged.
They should be charged.
And basically that this charge should have been added to their charge sheet.
SIRA also has got, because it refers to misconduct, has got jurisdiction to charge them with misconduct in relation to that. But I charged them with a contravention of section 33 5 and 33.2, those IPID contraventions in over and above the corruption sections that I charged them with.
My last question, I should have asked for 15 minutes. My last question, Advocate, was Ms. Trent's phone taken abroad to be downloaded? There's a story of her phone was taken to Israel to be downloaded.
I have given you 15 minutes.
Oh, thank you, Chair. You're so kind.
Yes, after it was seized.
Yeah.
Then there's a company which I was informed that there's a company called Celebrite, which has a contract with SAPS. So the SAPS use it to situations where they have to download the phones. So
where's this company based? Sorry to interject. Is it based in Israel?
Yes, it is based in Israel.
So the phone actually went to Israel?
Yes, for unlocking. Then it came back and then they downloaded it here in South Africa.
So we don't have service providers in South Africa to unlock an iPhone?
Apparently, yeah, they were not, they did not have it at that stage.
Okay, thank you so much. Thank you, Chair.
Bangazita, may you please finish that part which you wanted to conclude with the witness.
Thank you, Chair. I'm trying to mobilize my thought and also to remember what was involved in that question. Chair.
Let me take Honorable Nhlanhla as you
I will raise my hand when I'm ready, Chair.
No, Chair, just a quick thingy. I think the correct statement in relation to the unlocking of the iPhone in Israel, for the record, should be there was no way of unlocking the iPhone in South Africa at that particular time, because the status may have changed by now. So I think just I wanted to register that for the record. Thank you.
Thank you so much. Honorable Mngango. Honorable Mngango, your microphone is off. Can you switch it on?
I'm trying to remember, Honorable Chairperson. But all the same, I actually would like to know, excuse me, from the advocate whether he's aware that Mr. Paul O'Sullivan actually is a citizen of 3 countries, Ireland, England, and South Africa, and that he is in possession of 3 passports. And why we are alarmed with this court order, which actually says that he must be given 48 hours before he is arrested. And we are concerned because if this man is a citizen of 3 countries and cannot be arrested on the spot when he commits a crime, and that was a convenient order to give him an opportunity to actually skip the country to avoid arrest. So that is why I would really love to see you know, justice being done insofar as actually investigating this kind of order. What exactly was it trying to achieve? I
Indeed.
wonder if you can comment on that.
Yes, I would agree with you that it makes our our processes difficult because at that time the police had arrested him, and using section 23(1)(a), they had seized his phone and downloaded it, and then he was released. So they had to abandon all that evidence, and that would have linked him to serious allegations. So the only way to go about this is to make an application for a rescission of that court order. So I don't know why it was not proceeded with, because it was a settlement order, but I don't think it would be in the interest of justice that it be left unchallenged and without being rescinded.
Thank you, Honorable Chairperson. My last take would be to make a plea that I'm very much aware of the time constraint under which this committee is operating, but I feel that would be actually failing our duty if we did not actually call in IPID to come and actually clarify some of the things that actually have been said here. Not only from the advocate only, but a lot of other people have said things about IPID.
Yeah.
Thank you.
The committee will make that decision whether we want to compile written questions. We will have to look at the time that we still have and make a decision. I see, Honorable Skosana, you are being triggered. Before you do what you want to do, let me address you. All these honorable members have accepted 15 minutes. And you were the first one to flatly reject. You used the word, I reject 15 minutes. And the chair, being the benevolent chair that everyone knows, said those who request their 15 minutes will be given their 15 minutes. And you were an exception. You were given 30 minutes.
It was not an exception, it was a normal thing.
No, it was.
But
It was
remember,
because it's a decision that was taken in this meeting. It was circulated, that decision.
no, but you asked everyone.
Yes, and the majority of the members said 15 minutes.
And 10 minutes.
And Honorable James even
10.
lowered her standard and requested 10 minutes.
And honorable vessels as well.
And the chairperson said, I understand the issues that honorable members may have. And for the sake of agreement and peace in the House, I will circulate you and check. I will rotate and check how many minutes each one of you requests. And everybody was allocated the way they requested. And so now I see you still want to ask questions.
A question, Chair. I just wanted to make a follow-up because I was listening.
Yeah, that is
so it's not a question.
Don't switch on the microphone because you have not been granted that permission. If you must ask or not. I'm looking at the faces of the members to read if they approve of your request or not. The chairperson, the chairperson speaks the sentiments of the members. Yes. So there is no other person who have spoken for 30 minutes. In fact, it's you who spoke for 30 minutes plus 1 minute. He spoke 30 minutes less. So I'm not going to grant you that permission to speak. What you can do, because we are about to release the witness, the same thing that you did when Mr. Paul O'Sullivan left last week. You can accompany Advocate Masha, and then you have those answers that you want. Can I check with the legal team if you have any matters that you want to clarify with Advocate Masha?
Honorable Chair, just a few questions. Yeah.
Yeah.
Advocate Mashuga, you indicate in your statement that you're here to testify in relation to that part of the terms of reference which refers to infiltration in the police or in the criminal justice system, broadly speaking.
Yes.
That statement was made by General Mkhwanazi on the 6th of July 2025. You left the NPA in 2024.
Yes.
Are you able or in a position to comment on General Mkhwanazi's assertions or allegations of infiltration into the criminal justice system that he made in 2025? Or rather, let me try and restrict it. Or is it limited to that period when you were in the NPA?
Yes.
And is it further limited to your own experience in the Kameeldrift case?
Yes, it is limited in that regard, but in general, what General Mkhwanazi would have stated is borne out by different incidents, whether at IPID or wherever I saw that the committee received certain testimony from different incidences that would have borne out the observations of General Mkhwanazi.
Now, we also know that Mr. McBride was the executive director of IPID, appointed in 2015. Then you may know he was then suspended, and then he went to court, and then he was reinstated in 2017 and 2019. The Kameeldrift complaint was in fact lodged with an acting executive director while he was on suspension. I don't know if you know that it's not particularly material to the question. It was then, after he was reinstated, that complaint was then resuscitated, revived. And that seems to be the period of what you describe as the O'Sullivan infiltration into IPID. Is that correct?
That is correct.
So it seemed to be limited to a period from 2017, and then we also know that his contract was not renewed by then Minister Kele. In fact, based on a memorandum that he relied on, submitted to him by Mr. Cedric Kabinde.
Yes.
Where he made the kind of allegations that you also mentioned to us today.
Yes.
Now, I think this is a question that you may have answered, but one that was raised by Honorable Matthys. In 2017, February, when the matter was removed from the roll, you were otherwise prepared to proceed with the trial, save that you now wanted to introduce the racketeering charge,
yes,
which requires a certificate
yes,
from the NDPP, and which I think you said you were going to refer to the High Court.
Yes, indeed.
So if you, I suppose a speculation, so it's a speculative question, then you can answer. But if you were ready to proceed to trial otherwise with the other charges,
Yes, that is correct.
the seizure of the arrest and the seizure of the cell phone of Trent's, that's the Santon case.
That is the something case.
And there, I think you said that there was Sean Abrams, then NDPP, declined to prosecute in that case.
The DPP, acting DPP advocate Baloy declined to prosecute. Then IPID made representations to Sean Abrams, the NDPP, who confirmed the decline to prosecute.
You say that in your affidavit, I think fairly, you say that the issue around the download of the data on Trent's phone, that is likely and will, as a prosecutor, it will likely become the subject of a trial within a trial, should the matter proceed to court.
Yes, I believe so.
And we know that the matter is now from Advocate Mutibi's response to us as the NDPP. That matter is still under consideration and is still likely to come to trial.
Indeed so.
Yeah. You know what the reason was for General Paslani's dismissal? He was dismissed in 2020.
No, I do not.
You don't know whether it was connected with the Kameeldrift case?
No, I do not know.
My thanks also to you, Advocate Mashuga, for your attendance and your cooperation. Thank you.
Thank you very much, SC.
Advocate Mashuga and your team from the NPA, Advocate Maga and Advocate Ramatsekisa. Ramatsekisa, does it mean you are the one who brings them before court? We want to thank you so much. These honorable members can agree that today's proceedings have helped us to better understand the intricacies that we have been dealing with in IPID. And for sure, that is why you had one of the members even said it would have been better if you appeared before us, before IPID came here. Because when IPID appeared before, not necessarily IPID, I mean, Mr. McBride appeared before us, we were still very hazy in terms of understanding the evidence that Mr. Nkabinde had given us. And there were so many puzzles that had to be completed. So you helped us today with your evidence to cross the T's and dot the I's. So if there are any other questions that members would have formulated out of your evidence, we will find a way to raise them with IPID for written responses, or if time allows, members can always decide what they want to do. But we want to thank you so much for your cooperation. And the legal team for the consultations that were made. But very importantly, when you go back home, Advocate Maga, you must thank the NDPP on our behalf for granting the witness permission to come and make a presentation before the committee. Where I'm sitting when I listen to his evidence, some of the things that have been said here might impact on the reputation of the institution. But the NDPP did not look at that. He allowed the witness to come here and say, go and say whatever you know about the matters that they are asking you. We read commitment on the part of the NDPP to help us to get out of the woods and build the criminal justice system of choice in this country. We want to thank you so much, and please pass our regards to the NDPP. Honorable members, we have come to the end of our proceedings with Advocate Masha, and as usual, when we release him to leave, we are going to request Honorable Skosana to accompany him. We are going to take a break and then come back at 19:30. Thank you so much, honorable members. And thank you so much, Advocate Masha, you are released.
Thank you.
Thank you.
Advocate Mkhwanazi, are we ready?
Yes, Chair, I'm ready.
Yeah. The witness that is before us, is he the witness that we have expected here? And what are the full names of the witness?
The name of the witness is Mr. Fadil Adams. He is a member of Parliament, and Chair confirmed that I have had consultations with the witness, and he's produced a statement, and he is ready to give his evidence.
Good evening, Mr. Fadil Adams, and how are you?
Good evening, Chair. I'm doing well, thank you.
Welcome to our proceedings, Honorable Member.
Thank you, Chair.
Our proceedings start by way of administration of oath on the witness. Let me take this opportunity and thank you for availing time to do consultations with our legal team, but also making yourself available to appear before this committee. This ad hoc committee has been appointed by the National Assembly to investigate the allegations that have been made by the KwaZulu-Natal Provincial Commissioner, General Mkhwanazi. And the committee has invited you here to help it in its oversight and investigative work. Amongst others, it's investigating, number one, the alleged unlawful disbandment of the political killing task team, otherwise known as the PKTT or NPKTT. Number two, alleged moratorium on the filling of vacancies within the SAPS. Number three, alleged corrupt relationship between senior leadership of the SAPS and members of the public. And lastly, political interference in the work of the SAPS. In extending the invitation to you, the chairperson of this ad hoc committee has indicated that you may provide information to the committee, if you so wish, under oath in terms of the powers, privileges, immunities of Parliament and Provincial Legislatures Act of 2004. Honorable Adams, please be informed that by law you are required to answer fully and satisfactorily all questions lawfully put to you, or to produce any document that you are required to do so in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or even damages. Honorable Adams, you are, however, protected in that the evidence given under oath or affirmation before the House or a committee of Parliament may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 1, Section 17, subsection 2 of the powers, privileges, and immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or a Committee of Parliament with information or makes a statement before it which is false or misleading commits an offense and is liable to a fine or to imprisonment for a period not exceeding 2 years. You are required to take an oath or affirm that the evidence you are about to give is truthful. Which one do you elect, oath or affirmation?
The oath, Honorable Chairperson.
Thank you so much. You have elected oath. May you please follow me as I dictate. May you please say aye and state your names in full.
I, Fadil Adams,
Swear that the evidence I shall give
swear that the evidence that I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
nothing but the truth.
And so help me God.
So help me God.
Thank you so much. You are sworn in. We are going to hand over to Advocate Mkhwanazi and yourself to present evidence. How much time do you need, Advocate Mkhwanazi, in the presentation of evidence?
Chair, I'll try to not go beyond 2 hours.
Okay.
Like
So
yesterday.
thereafter, Honorable Adams, we are going to allocate time to members of the committee to ask you questions. And please remember that you will not leave the house until the chairperson informs you that we have come to the end of the proceedings. Honorable
Thank you, Chair. Chair, I just want us to be practical. We must agree now before we start, because we can't, in the middle of the road, we say we are no longer continuing. If you look at the time, it's 8 minutes to 8. 2 hours will be around 10. And if you allocate us our normal 30 minutes, unless you change like you did today and say 15 minutes, but as well, let's count that. That it is possible for us to be out here around 1 or 2. If we agree, so be it. Thank you.
That is our agreement. It was us who took a decision that after Advocate Mashura, we are taking Honorable Adams. So we have already sworn the witness in is all systems go. Whatever time we finish this morning,
yes,
I will thank you for the work that we would have done.
As long as people are not going to leave, because they normally leave, Chair, and we always hear people leaves, you'll say, no, I've got a commitment. We'll end up being 4 or 5 years.
So long as there is a chairperson here and a witness, the proceedings go ahead. Honorable Matthys.
Chair, I don't recall us agreeing that we were going to do questions as members of Parliament tonight. From my understanding was that we were going to let the evidence leaders do their part, and then we would arrange another day for Honorable Adams to come back to do the questions. And it's also not going to do justice to us to be able to do questions. We even raised the issue that the evidence is quite comprehensive as well. So we must do justice.
Yeah, we will cross the river when we come to it. Let's allow the evidence leaders to and Honorable Adams to present evidence.
Should I proceed, Chair? Or?
Yes, you have been given a green light by the chairperson.
Okay, thank you, Chair. Just as a matter of housekeeping, I just want to clarify the bundles that members have that were distributed to members. So members would have Honorable Adams' statement, and that would be accompanied by a bundle of annexures. It's just one bundle of annexures, although the bundle seems to refer to part 2. So there's one bundle of annexures, and the annexures are made reference to in his statement. And then there's an exhibit bundle, which Mr. Adams has requested to also have before the committee, although he hasn't addressed, made any averments in relation to the exhibit bundle, but he wanted to keep it at hand in case questions are asked about the information contained in that bundle. Chair, then there's also an extract of General Mkhwanazi's statement, which he made to the committee, or rather before the Nhlanhla commission, which we've attached to his statement before this committee. This is just for ease of reference for members, because I do intend to refer Mr. Adams to portions of this particular extract. So just so that members can have it handy. So that's it.
The moment, Skosana.
I'm not sure whether I heard very well the issue of that there's a Nhlanhla.
Chair, it's an extract of a statement which was attached to General Mkhwanazi's statement before this committee. Chair would remember that the General Mkhwanazi's statement to the Nhlanhla Commission was attached as an annexure to his statement to this committee. And we've just taken a portion of that because it deals with some of the allegations that the General Mkhwanazi has made against Honorable Fadil Adams.
Yeah, my issue, Chair, was that it should be our statement, not Nhlanhla, ad hoc committee here. Nhlanhla is something else. You know, if it must be changed, it has to be changed to an ad hoc committee here.
No, it's not. It's not an affidavit of the witness. Yes, it's not an affidavit. The witness has an affidavit.
The problem is that once you say Nhlanhla, it means we are somewhere else.
No. There you are wrong. You yourselves as the members of this committee have sent me as the chairperson to go and meet with the chairperson of the Nhlanhla Commission on exchange of documents. And we even came back to the committee and reported that we will exchange documents. And every time a document from the Nhlanhla Commission comes here, it doesn't come as a primary document. It comes as an annexure. So that is.
Thank you, Chair. You answered me.
That is exactly
I'm
what
fine. I'm fine, Chair.
What the legal team is saying.
Chair, I'm okay. For you to
Yes.
explain further, I'm accommodated now. Because what I don't want is that initially we had a debate about that issue. Thank you, Chair.
I'm prolonging the night. Advocate Mkhwanazi, are we ready to go?
Yes, Chair, thank you.
Yeah, in you we trust.
Thank you, Chair. Honorable Adams has indicated in my earlier reference to the documents, you were called here because of allegations that General Mkhwanazi has made in relation to your conduct. He alleged that you had unauthorized access to intelligence information and that you used it recklessly and that for your own benefit, and that is essentially why you were called by the committee to address those allegations. But in your statement, you've also indicated in paragraph 4 of your statement, you've indicated that you also wish to assist the committee in relation to its terms of reference, and the issues raised in its terms of reference is political interference within SAPS, evaluating the extent of misconduct and unethical behavior by members of SAPS and other relevant individuals or institutions.
That is 100% right, ma'am.
Okay. So as a start, I just would like to take you through the content of your statement, and we'll start with your qualifications, which you deal with in paragraph 5 to 6.
Yeah, there's a reason I did not attach a CV, because I've got nothing to brag about. I'm a high school dropout and I've worked in construction my whole life. There's nothing glamorous there and there's nothing to dispute as far as I'm concerned.
Okay, but you do indicate that you are a member of parliament and you've served on the portfolio committee of police. Do you want to just talk a bit about that?
Yes. It was 5 years ago to the day that we ended a hunger strike outside of Parliament. I went without food for 8 days to draw to the attention of the president the plight of the children of the Cape Flats who were dying at the rate of 10 a day. He paid no attention to it. He promised us a meeting and he never followed through. To the day. So when I was elected to become a member of this house, I only had one place to go. I wanted to go to the police portfolio. I wanted to go there because I wanted to make a change. I want our children on the Cape Flats to live longer. I want proper policing. You know, it's not a coincidence that out of all the police stations in this country that are under-resourced, 80% of them are found in the colored areas. And it is a shame that you can walk into any police station in the Western Cape and you'd have to look to see the coloreds working there. We're only good to be locked up. This was the only portfolio I wanted to come to. And I was thankful when I got the chance. And when I did, I swore that I'd make a difference. And apparently, there's a certain general who has a problem with that.
Chair.
Oh, and I was also a councillor in the city of Cape Town for 2 years.
Chair. I'm worried, Chair, that when we finish here, Mr. Adams' neck would have broken. Please, can he be advised for the mic to follow him? He must not follow the mic. I'm worried because he is like this when he answers. So he must just drag the mic towards him.
Chairperson, with respect, and thank you for your concern, Honorable
No,
Mora. I have a shoulder problem, Chair, and this is where I'm comfortable.
You explained to me, but your problem is that you pulled the chair back.
It hurts. I tried that position.
Your chair has withdrawn from the mic. If you can move your chair a bit closer to the
I tried that, Chair. It hurts when I. So this is where I'm comfortable. I hope it doesn't offend anyone. And to be honest, I was going to go to the doctor this morning, but I was accused of ducking the committee yesterday. So I thought I would not embarrass myself in front of my family.
No, nobody has ever said you are ducking the committee.
I don't know which meeting
What
I was
I
watching.
had coming from the meeting is that.
But I'm good, Chair. I hope the posture is not seen as being disrespectful, but this is where I'm comfortable. Thank you.
No, it's fine. Let's proceed. Honorable Sols.
I just want to make sure that your Honorable Nhlanhla say looks like he's on drugs.
I can confirm that he didn't, Honorable Souls. I would have been over the table by then. Thank you.
Thank you very much. I thought, watch it.
Honorable Sangon.
No, Chair, when you greet witnesses, you normally greet the entourage that accompanies him. Honorable Adams has got his family here and people that he brought to support them. You're looking at the wrong side, Chair. So please, can we also acknowledge them? Thank you.
He himself has not said anything. If he can tell us that Honorable Adams.
Yes, Chairperson.
Do you have people who have accompanied you here?
Yes, Chairperson. My family is in the corner. They're not that hard to spot. They're all brown.
Where are they sitting?
Right in the corner over there, Chairperson.
You were supposed to have brought them to sit here behind you.
I don't think they want to be on TV, Chairperson. Even the one that looks like a Freedom Front Plus voter is one of mine.
Okay. Can I greet you, all of you, from where I'm sitting as the chairperson? Greetings on behalf of the committee to all of you and welcome. Thank you so much. May we proceed?
Thank you, Chair. Honorable Adams, you deal with the allegations that were made against you in relation to intelligence information, and you provide an explanation or your version of events in paragraphs, starting from paragraph 7, I believe, to paragraph 13 of your statement. And your version of events is that an envelope was slipped under your door, and you say that it was in the last week of October, but you can't exactly remember when that happened. Do you just want to elaborate on that?
Yes, thank you, Advocate. I remember the hiding Nkabinde took at Mr. Nkabinde took at this portfolio for not providing dates. And I do understand, the need for precision. At the time when this happened, I never thought there'd be an ad hoc or a madlanga. I thought it was a simple case of possible corruption, so I didn't write down the dates, and I've actually lost the device that I had in my possession at the time, which should have made things much more easier, but I don't have it. So the best I can do is sometimes go approximately. Where I've been able to fill in dates is where I could follow an email trail. But I came to my office like I normally do. When I used to come to Parliament every day, it was about 6:15. I know it was in the last week of October. That I know for a fact. Whether it was the 23rd, the 24th, the 25th, I can't say. I don't want to be accused of perjuring myself later. But I found in my office floor an envelope. I assumed it was slipped under the door. I opened the envelope, and inside it, there appeared to be evidence of criminality. And it was evidence that was implicating some very senior people within the SAPS. There was one name that I knew and others that I didn't. Because the cases are now before the courts, I can't speak too much on the merits of the case because I don't want to give anyone a loophole of walking out on a technicality. But I was unsure as to what to do with the documentation. Remember that there was no JSEI at the time. And I don't have direct access to the Minister of Intelligence or Safe Security. So what I decided to do was to lay criminal charges. But before I did that, I went and saw a very good friend of mine. He's now deceased, the late Major General Andre Lincoln of the AGU. It was on his suggestion that I went to the police station. So what I did is I went to Grand Central Police Station the next day. And I think it was the next day, or it might have been the day after that. And I laid criminal charges against Generals Khumalo, Lushaba, and Madondo.
Can I just ask before you move on that? You've given us an indication that that at the time there was no JSCI, there was no committee basically that you could have gone to and informed them about the information. So it seems that you were clearly aware that the information was classified. But you also say in your statement that you were not sure whether these documents are fraudulent. So the question that immediately comes to mind is, why did you not, one, make an effort to first verify whether these documents were in fact valid? And secondly, regardless of whether these documents are authentic, why did you not first investigate who did that, who placed the documents there? Because these are classified documents.
Can I answer? Thank you, Advocate. Only one of the documents was marked classified. Only one. I think there were 4. I'm not an investigator. Just like General Khumalo is not an investigator, just like General Mkhwanazi is not an investigator. That's why we have investigators. If I was to investigate this thing, I'd probably bark up the wrong tree. I gave it to the experts, the South African Police Services. What I did is I opened the docket. The officer that took the docket from me asked me for the evidence because I gave a lengthy statement. I said, no, I will give it to the investigating officer when he calls. Because I didn't want to hand classified information to just anybody. I left that police station and I received a phone call from General Lincoln, he was very well connected within the SAPS. And I was shocked when he told me that my documents, my dockets had been collected by the provincial office. I didn't even know what that meant. I said, General, is this procedural? He said, no. I said, then what does it mean? He said, they're trying to cover it up. I asked him, why, General, are you saying this? He said, the procedure, son, is what he used to call me sarcastically, is as such. You lay the charge. The docket then gets given to the head of detectives. He will read the docket and he will assign it to a detective. He says, provincial does not get involved. Something's wrong.
Mr. Adams, just before you go, and I'm sorry to interrupt, but you have to give more, I'm just going to ask for more clarity in relation to the information, because as you know, and I've raised this with you during the consultation, there's a lot of details missing in the information that you've given. And again, I'd just like to go back to the you not taking the necessary steps to verify the information.
Oh.
You say you're not an investigator, but you are a member of the Police Portfolio Committee. We've heard from General Mkhwanazi, for instance, that when matters are discussed at the Portfolio Committee and something comes up that is considered classified, the meeting would be advised not to bring it to that particular committee, but to then refer it to the relevant committee, which is the JSCI. So you're quite familiar that information must be treated a certain way. You mentioned miss in your statement. I don't think your answer that you're not an investigator is sufficient, because you know better as a portfolio committee member.
I actually do agree with you, Advocate. So on the issue of the validation of the documentation, I had no means to do that, and I didn't want to bring it to the police committee, because you can ask Honorable Skosana, you can ask Honorable James and Matthys, the fights we have within that committee with regards to classification. You can also ask Honorable Shongwe, I saw that look, because it is my understanding that classification of crime is a crime. And I'm backed up in that with the Vuma versus IPID case and the MIS document, because we've brought criminality to the police portfolio where the generals hide behind classification. Now, our founding document, the Constitution, it makes no provision for the classification of crime. And therefore, I was only going to do this one way, whatever the result.
Could you then tell the members what you considered the crime to have been? Because what we have in front of us is a statement by you saying you were not sure whether the documents were fraudulent. So you were also questioning the authenticity thereof, but you seem to have been convinced that this is a crime.
100%.
And on what basis did you then decide to go?
Look, I looked at the sorry, Advocate, thank you. I looked at the documents and I said to myself, here's a possibility that you could be set up, because someone's expecting you to run to the media and you're going to end up with egg in your face. On the flip side of that coin was, this could be real. Now, the best people, in my view, to make that call would be the South African Police Services. And that's why I took it there.
Can you just maybe elaborate on what information you then subsequently gave to SAPS when you went and opened the docket? Because you said you did not give any evidence. So what did you give to SAPS to satisfy them that what you've given them would be enough to pursue an investigation?
I gave them a sketch of what the documents claimed, but I did not hand them any hard copies of the evidence.
You're not saying much.
No.
What do you mean by a sketch?
I essentially told them that this general is accused of defeating the ends of justice on this date, and this general is accused of fraud, and may have not accused, defeated the end, may have defeated the ends of justice on this date. This general might have committed fraud on this date, etc., and that's it.
You may continue. You were then called by
General
Colonel Lincoln and informed on what did he tell you? Because as you've just informed the House, the information that you've given in your dockets is a sketch. So why would he call you out of concern that the information will be taken further? Because it's just basically nothing.
General Lincoln said to me that if this is what they've done, they are going to cover this thing up. I asked him, General, what do we do? He said, you walk away. I said, why? He said, because people are going to die before this thing goes to court. I said, General, are you serious? He said, 100%. I said, I'm not going to walk away, and I'm certainly not scared of death. What do I do? He said, son, you open this docket, you open these cases in another province, let's see what happens. I flew to Johannesburg, and I opened the same cases at Orlando, at the Orlando, and Nhlanhla at the police stations. But when I was there, I waited. I made it clear I was not going to leave until I received my case numbers, because I wanted this thing registered. Once that was done, the very next day, I emailed the minister, the suspended minister, Mkhwanazi. And I said to the minister that my dockets have been irregularly collected here in Cape Town because I'm complaining to the minister. I didn't know what course of action the minister would take. Excuse me. But I did demand from the minister that someone outside of the SAPS investigate this case. General Lincoln gave me a telephone number for the IDAC, which I contacted. I cannot remember who I spoke to, but I was contacted by Brigadier Permo. And not the very next day, or maybe the day after that, by the IGI of Intelligence, Mr. Imtiaz Faisal. He asked me about the cases I laid and asked if I'd come to his office because his office may have an interest in some of the allegations. I flew to Johannesburg. I met with the IG for maybe 10 minutes. He handed me over to Advocate Govender, and I gave Advocate Govender the information.
Before you go on, because I don't want us to get too deep into it, because we're going to try to assist the committee with dates so that when they have assessed the evidence, that they can have some sort of chronology, and also so that you can address Mkhwanazi's version around these allegations. I know you said you don't remember any of these dates, but I'm going to provide you with the dates that he's given to us, and then you could just maybe confirm whether these are correct or whether what he said was wrong.
I think, Advocate, that you should provide the dates,
Mm-hmm.
but please understand, I'm not going to argue with these dates because I'll be arguing out of stupidity then. I'll go with the dates he's given.
No, but what we're trying to do with going through those dates and why your comment is so important in respect of those dates was that what General Mkhwanazi was said to us was that there appears to have been a haste in which you dealt with the matter. You leave out some crucial information here in your statement. For instance, you went to the minister not once, but twice, and that is not apparent from your statement. And the time frames within which you went to the minister and the time frames within which the minister then subsequently approached in the inspectorate to deal with your complaint, there are 1-2 days in between. And so that, to what General Mkhwanazi has told the committee, appears to suggest that there was something behind the urgency within which you dealt with the matter. And so that is why it is so important that we take the time and get an explanation from you why you did things in such a hurry.
Okay.
Okay. So in paragraph 9 of your statement, you say that the charges were laid on the 29th of October.
On the?
Was it on the 29th of October? Can you maybe look at your statement? This is in paragraph 9.
I remember that date. It is the 29th of October, I think.
General Mkhwanazi says the 30th, but you in your statement say the 29th. That's why I'm asking.
The 29th of October in Cape Town, the 30th in Johannesburg.
Okay, so you say it's the 29th. Is General Mkhwanazi then incorrect by saying
I
it's
do
the 30th?
believe he's incorrect.
He has attached I believe, the front page of the cases, but we can verify that. You strongly feel that it was on the 29th of October, even though you...
Advocate, if I'm wrong, I'll own it, but I do believe it was the 29th. I think so.
Okay. So 29th of October, you opened up cases in Cape Town. There's very little information in the docket. It's a sketch that you've provided. And subsequently, which you say the next day, the 31st of October, you went to Joburg because you had received a call from General Lincoln.
Yes, ma'am.
So on the 31st of October, you then rushed to Joburg to open up another docket.
Was it the 30th or the 31st? But
the 31st.
The 30th. Okay, let's go with the 31st.
The 31st of October. And so now on the 1st, after you've opened up this docket in Johannesburg, on the 1st, you then write to the minister. Can you explain why you would open up, you've given an explanation about Cape Town and you said you received a call from Lincoln. And Joburg, why after you've opened up a charge in Joburg, you then on the 1st complain to the minister and you complain about members of SAPS specifically and you say that they've intercepted your dockets?
So let's just follow the trail. I wasn't drunk or out of my mind when I laid the charges here at Grand Central, right here, which is when the dockets disappeared. I have to go to Johannesburg at taxpayers' expense to lay the same charges, I think I'm within my right to complain to the minister. The fact that the minister acts speedily, the minister can answer if that is his standard turnaround time. I, for one, as a citizen of a country where service delivery is suffering, I'm very happy that we have a minister that reacts speedily. I wish all of us had.
But we want to understand why, after you've laid charges in Johannesburg on the 31st, you then complain about members of SAPS to the minister. What happened in Johannesburg that made you believe that your information was being intercepted? And remember, you've told us that these are just sketches. This is not even documents containing evidence. So what happened that made you believe that your information, your sketch is being intercepted?
So, Advocate, when they intercept my dockets, which they did, the plan was that these allegations must never be investigated. Why would I not complain about that? Please understand where I'm from.
Why? What happened in Joburg? That's the question. Not
No,
we hear you.
Nothing happened in Joburg except that I had the suspicion that they could do the same thing again. Because after what happened in Cape Town, it was clear to me that here is a plot going on that means these dockets will not be investigated. It's for this reason that I drew the attention of the minister to it.
So you then write this email to the minister on the 1st of November, and we have a copy of that email in the bundle. And this email that you wrote to the minister is also there's very little information in there. You basically just tell the minister on the 1st of November that you suspect that your information might be intercepted, and you give him the case numbers and you ask him to intervene.
I'm just looking for it.
Okay, let me just try to give you the page number. I think it's page 6.
First or second bundle, Advocate?
It's on page 283. At the bottom of the page. Of this bundle, of the Mkhwanazi.
Oh, yeah.
Mkhwanazi bundle, yes.
Okay.
283, yes.
Just a second, I'm struggling with one hand here. Okay, on page 283.
Okay.
At the bottom.
So you wrote to the minister and you said that I've opened cases in the Western Cape on a number of senior SAPS personnel, and you gave the case numbers. You do not say who these senior officials are. And you said, I was told the dockets were intercepted. In my quest for justice, I traveled to Johannesburg and opened the following dockets. And you proceeded with the case numbers. And then you say, however, I've been notified, which is contrary to what you said. You said it was on your own suspicion. You said, I've been notified that the Gauteng Police Department has followed the same modus operandi and is interfering in the investigative process. So were you not being truthful to the minister?
No. Sorry, Advocate. I was told that they're probably going to follow the same thing.
Who told you that?
The late General Andre Lincoln. When I look at this email, could have worded this thing better. I could have. But that's just me using the wrong word. I should have said suspect that they may use the same modus operandi.
And then you proceeded to humbly ask for the minister to intervene to ensure the integrity of the investigative process. There's nothing else. There's no report on what the nature of the charges are, or unless if there was there more information attached to this email?
You must remember, if there's one thing that I cannot be caned about here, is the fact that I didn't tell anybody what's in the docket. Not even the minister.
Okay. But then when we see that the minister, in less than an hour, on the same date, on that same page 283, the chief of staff writes to the national commissioner in less than an hour and informs the minister, the national commissioner's office, that the minister has received this complaint and that they want a report within 3 days.
If I was the minister, I'd want the report the next day. And I'll tell you why,
without any information?
if I may. I've been to court so many times with people whose dockets have gone missing. It is a very serious problem. It is a very serious problem. The fact that the minister's office replies within 1 hour tells me that they may also see this as a serious problem. I understand that certain generals may not see this as a serious problem, but I do appreciate the fact that they responded promptly. I didn't expect him to respond that promptly, but I'm certainly not going to say no thank you to it. If you read my email, I'm not asking for a special favor. I'm telling the minister that this is what happened and I need you to intervene.
So General Mkhwanazi did in fact tell this committee what the nature of the charges were that you have laid against these senior officials. And, you know, if the minister at least had the benefit of that kind of information, I think it would more or less sort of have been made, it would have made more sense as to why you would, in a haste, refer the matter to the National Commissioner. But he didn't even have that, what we have now in front of us.
So I'm complaining as a member of parliament about a very serious issue that happens at our police stations all the time. And there are people complaining that we have an effective ministry. Is that what I'm understanding? I'm asking because I'm not understanding. You know, the normal complaint is that SAPS doesn't respond. They take too long to respond. They don't answer their phones, yada, yada. I can show you emails that I've sent that don't get responses. I'm happy. I'm extremely happy. Let me put it on the record that the minister's office responded promptly. But if you want to know why they responded within an hour, you're asking the wrong person, advocate. That question should be posed to the minister.
This shouldn't be, the questions posed shouldn't be viewed in a negative light. It's just for clarity's sake.
No.
And if the minister's office was that responsive, then it is in fact a great thing. I think it tells citizens that they now can, if there's a complaint that they have, this is the kind of immediate response. And like you've said, a lot of people have problems with dockets, and it appears that if they write to the minister, they'll get a response in less than 30 minutes.
In a perfect world, let's hope it happens.
We then know that after the minister then sent this email to the inspectorate to provide a report by the force. To the National Commissioner, who then subsequently requested the inspectorate to intervene. The inspectorate then 3 days later furnishes the minister a report, and part of the complaints that they've raised or issues that they've raised is that the information is simply not enough to pursue, to conduct a proper investigation. But what they then also said is that they recommended that the minister afford them more time, a period of 10 days, to get in touch with you and to conduct further investigations. And then they will come back to the report, to the minister, to be able to indicate what's happening on these matters. Were you aware of that?
Yes. I heard about that. I wasn't told by the minister. I wasn't emailed, but I'd heard about that.
So if you've heard about that, why then did you, on the 10th of November, before expiry of that 10-day period, write to the minister again and then requested the minister to refer your complaint to an independent investigative body?
I don't trust the South African police services. I have no faith in the South African police services.
The Minister of Police is Police Services.
Yeah.
And he dealt with the complaint you've given him and he's referred it to the National Commissioner.
The Minister of Police is the executive arm of the South African police services. The operational and functional part of it is what we don't trust.
You don't trust the way the minister dealt with your complaint?
No, I trust the minister to deal with my complaint. I also trust these generals to pull the wool over the minister's eyes. Understand, I've raised various things within portfolio. These people have lied to Parliament over and over again. I did not trust them to investigate themselves. If you would allow me to expand. One of the charges I laid was against General Dumisani Khumalo, who was arrested and is now before the court. He's the DivCom of crime intelligence. It's probably the most sensitive position in the country, well, within SAPS in the country. His appointment was supposed to be ratified by Parliament. Parliament was never notified of his appointment. Do you understand where I'm going? When I lay charges against the same man who was acting in his position with a cooked security clearance, listen to as I say it, it was cooked. It was fraudulent. When I lay charges against this man, the dockets miraculously get collected by the provincial office. I did not trust these people to investigate. This is why I asked the minister for someone outside of SAPS to investigate. You're asking the wolf to investigate the wolf. It doesn't make any sense.
What's even more confusing, Mr. Adams, is you did go to the police and you opened up a charge here in Cape Town. This wolf. You did go to Gauteng to open up a charge. You did write to the minister to intervene because you believed that there were no progress on your charges. You then do not trust how the minister dealt with the complaint because he's written to the National Commissioner on your behalf. You're aware of it. You've just said it yourself. So it's very confusing how you would have wanted the investigation to take place if you never allowed them the chance, if you never given them the opportunity. Why did you go there in the first place then?
Advocate, I don't know of another place to lay a charge but the police. So I had to go to the wolf. Then the dockets, let's say they disappeared for a while. They did. Then I complained to the only person I could complain to, the minister. There was no one else to complain with. So I deal with what I have in front of me. But when given the option of not dealing with these boys in blue, I grabbed it. When I was told that the IDAC could investigate this, I grabbed the opportunity. So yes, I dealt with the wolf. Because if you could tell me that I could go and lay charges against General Khumalo at the Civic Center and use a counselor to lay the charges, I would have spoken to a counselor. If somebody had told me that I could lay charges against General Lushaba at Groote Schuur Hospital by speaking to a doctor, I would have done that. But in order to lay charges and get a case number, I had to go to the police station. I hope that makes sense to you.
Not quite, but I'm sure I'll understand as you explain later on. What did you expect the minister to do when you went to him with your complaints? Did you expect him to do what?
I was hoping that the minister would ask what happened to these case dockets. I'm not privy, I wasn't privy to the interaction between the minister and the NASCOM. I wanted some type of action and I wanted some type of disciplinary action leveled against the person who I still don't know who it was that came to collect the dockets. Now that didn't happen.
Mr. Adams, you serve on the police portfolio committee. You know, when something gets referred to the minister, it's high level. The minister would then call on other resources like you did here with the National Commissioner. National Commissioner in turn turns to the inspectorate, who would then ask senior officials to deal with something that comes from the minister. In a South Africa where there are so many things happening that require SAPS attention, it's taking away resources, especially if you know from day one that you were never seriously pursuing these charges with the police because you never trusted them.
That is 100% correct. And that is why the person who collected the dockets should be prosecuted. All I'm saying to you is I laid the charges. It was the civic thing to do in my mind. When the dockets were collected by the provincial office illegally, what was I supposed to do, advocate? What Mkhwanazi wants me to do? Shut up and go away. Maybe that is the lesson that we should send to everybody who's serious about fighting crime in this country. Don't bother. Like, I'm sitting here and I know exactly what certain people are thinking without accusing anyone. I did the right thing. I don't care what anybody else thinks. I did the right thing. I've asked within the police portfolio why General Khumalo was allowed to buy cell phone grabbers, obsolete cell phone grabbers that have never worked. I wasn't given an answer. Do you understand how the police portfolio functions?
Not
These people operate with impunity. They do as they want, when they want. It's why they went out buying hotels with our tax money. And I know I'm jumping. I'm trying to put it into perspective for you.
Okay, so maybe let's go back to the timeline. You then, like I've indicated, wrote to the minister again on the 10th, and you asked him to refer the matter to an independent investigative body after he's received the report from the inspectorate that recommended that he should wait 10 days. Why did you not approach that independent body yourself? Why go back to the minister and ask him to write that letter to IDEC?
I never asked the minister to write a letter to IDEC.
You asked him to refer the matter
Yes.
to an independent investigative body.
Not to the IDAC, to an independent. I meant even outside of government. I didn't mean Section 9. When it happened that way, that's the way it happened. I asked that SAPS not investigate SAPS. That's all I asked.
Are you familiar
Also,
with IDEC?
I am now. Also, I also figured that the referral to investigate the SAPS would carry a lot more weight if it came from Minister Senzo Mkhwanazi than it would from Fadil Adams.
But you say in your statement you also contacted IDEC.
Yes, I did.
At which point did you contact IDEC?
I wouldn't be able to give you the exact date, but it was round about 2-3 days after I messaged the minister.
So we know the minister wrote a letter to IDEC on the 11th of November. Were you aware of that letter on the 11th of November?
No, I was not, ma'am.
So you say that could have been it would have been around what, the 13th of November when you wrote to IDEC?
13th, 14th, 15th, roundabout there.
Did you write to them? Did you go see them? What happened?
No, I called because I didn't know what the procedure was. Because I didn't know what to do. I said to my, I miss that man. I said to General Lincoln, General, I don't think this thing is being treated properly by the minister. And he said to me, I'll get you a number, call the IDAC. I said, who's the IDAC? He said, they're better than the Hawks.
No, but what do you mean it wasn't being handled by the minister? Because you were aware that the minister referred the matter to the inspectorate. You now then, you must have been aware of the report that came back from the inspectorate because you said, no, I want an independent body now. So what do you mean the minister was not handling your issue?
You know, advocate, if you know me for any length of time, you know everything I do is in a hurry. I want it done today. And in an issue as critical as this, I wanted it done yesterday. So yes, I appreciated the fact that the minister responded to me quickly, but I wasn't getting the phone call or the email or the interview that I wanted because this thing was not going to go away. Now, understand, I work on the Cape Flats where things go away. I am not a cold. I'm not the flu. I don't go away. It's a permanent thing here. I was going to have this thing investigated. I was going to have these people charged if there was a case. If there was no case, fine. But if there was a case, it was going to be investigated properly.
But again, Mr. Adams, I think it raises the other concern that I had, that you have no intention of seriously taking assistance from the minister or the police, but yet you as a member of the portfolio committee, this is what you said, but you as a member of the police portfolio committee, go and ask the minister where he could have been busy with something else. The national commissioner is involved, he could have been busy with something else. You know under what pressure the police is already operating. But you say you have no, isn't that a little bit, isn't that wrong? Do you not see anything wrong with how you've dealt with it?
Ma'am, I never said I was perfect. What I said is I was desperate. The minister, in my view, wasn't dealing with this thing fast enough. And therefore, I was willing to try other avenues, as I am even right now. Now, I tell you again, when those dockets went missing, it was clear to me that General Khumalo was not going to be investigated by the SAPS. That's when I reached out to the minister. I'll explain it again. I expected the minister to come down from his throne, shake the national commissioner, and get an investigation going from somewhere else. At the 11th, I don't know that he's reached out to the IDAC. It's why I called. If I had known, if the minister had copied me in the email, I'd have sat back and waited. He didn't. If there was collusion between myself and the minister, like someone here alluded to, I would have known that he had emailed the IDAC on the 11th, and I would not have reached out to the IDAC.
Why did you omit these engagements that I've just mentioned from your statement?
Which engagements are those, ma'am?
The number of times you've approached the minister. In your statement, you briefly deal with the fact that you went to the minister and you complained with SAPS, to SAPS. You've heard General Mkhwanazi's evidence in relation to the chronology and how he was trying to indicate to the committee that there might be something, there's something very suspicious about the urgency in which you've dealt with this. Why in your statement did you ignore all these steps or not address all these steps that you've taken and provide an explanation to this committee that could satisfy them that, you know, this.
I actually didn't think that my second email was all that vital until the cross-questioning began, because I read Mkhwanazi's statement. I'm not denying that I emailed the minister a second time. But when you say all these steps, it's one email. That's the total sum of it. Now, I wish I had attached the email, which I actually don't have anymore because I deleted a lot of emails because of space, but there's nothing devious about it. It was just a simple issue of, I'm going to keep my statement as short as I can for the benefit of the committee, because I've been sitting outside here since 1 o'clock, and I've listened to a man go through files and files and files and files, and I don't know what he said. I wasn't going to be one of those witnesses.
Mr. Adams, I'm afraid it is all these steps. It is all these steps. It's not just one email. There were reports by the inspectorate, which you've now told us you were aware of, and you could have addressed that. You could have indicated or explained that the reason why I decided not to, in spite of what the inspectorate has advised the minister, I decided not to wait because I simply did not trust the police. All of this is not apparent from your statement. It's not just one email.
Advocate, paragraph 13 of my statement deals with the investigative body, with the directorate. I recall the same week, I was called by a lieutenant colonel whose name I don't remember, but I actually saw it in General Mkhwanazi's statement. He wanted to meet with me, claiming to be investigating the cases I'd laid. I was deeply suspicious of his motives, so I politely found an excuse not to meet every time he called, because he called me 3 or 4 times. My suspicion was vindicated after some investigation. Remember, I'd laid a criminal case, not a service delivery one. Now, let me explain something to you, and this is how devious these generals are. I've laid a case against 3 generals. The SAPS protocol dictates that you get investigated by your equal. Look at what the NASCOM does. They're sending a lieutenant colonel to investigate a general. Now again, General Andre Lincoln points this out to me. He says to me, a colonel does not investigate a general. I said, Gen, what do you mean? He said, even if there's a case against them, they'll win it on appeal because they were investigated by a subordinate. He says these people are smart. That's the reason I never met with the directorate. Every time he called me, I found an excuse. I said, no, I'm not here. I said, no, I'm busy. No, I'm down with the flu. I don't know what excuses I gave him, but I found a reason not to meet him. Now you're saying to me that I left out the steps taken. Paragraph 13 is covered.
No, can I just explain why I said that? Paragraph 13 doesn't have a date and it's towards the end. The content of paragraph 13 seems to suggest that it was after your meetings with IDEC and even after you met with the IG, which we will come to now. It's towards the end and there's no date. It suggests that it was the time you spoke to Colonel Lincoln, but I don't know, is he a general?
He was a major general.
Major general. Now, you've indicated to us you spoke to him about your charges that you've laid in Cape Town and he gave you a warning in respect of that. but I've taken you through various things, steps, subsequent events that happened after Cape Town. This paragraph 13 suggests that this happened after it, and you'll see if you look at where it's placed. This does not suggest that this happened before the minister's intervention or after the minister's intervention.
This happened after them. I recall the same week. The same week.
Which same week? There's
Honorable,
week of what?
Honorable Source.
Yeah, Chair, I would just want to see fairness with the witness. The procedure has always been, there was never an expectation for you to have listed details in your affidavit. The oral testimony compensates for those details. So I'm just asking for fairness that Honorable Adams be treated like all the other witnesses. If there's no detail in his statement, the evidence leader should allow oral testimony to compensate for that. Thank you, Chair.
Okay. That is accepted.
Thank you, Chair. So,
Excuse me, Advocate.
could you?
I thought we agreed that I laid the charges on the 31st in Johannesburg. I thought we agreed that I emailed the minister the very next day. I thought we agreed that shortly after that, Imtiaz Faisal, the IGI of Intelligence, called me. So later on that same week. So what is the problem with the chronologically, chronologically? Oh God, I'm tired. Anyway, you understand what I'm saying. What is the problem with that?
We haven't spoken about the IG yet.
No, I'm saying, okay, but it says in my statement that on a date I struggle to recall, I was contacted by Director General of Intelligence, Imtiaz Faisal. So it happened in that same week, but it was in the same week that I emailed the minister. So now what I'm saying to you is I'm struggling with dates. Remember, when this Lieutenant Colonel called me, I wasn't writing down the date because I don't foresee myself sitting in front of Parliament because of this one day. So if we want to be pedantic, then excuse me, I can't be. I'm giving you the evidence to the best of my recollection. This was not a WhatsApp chat. It was a phone call. Now I'm explaining to you the reason I don't trust SAPS. The National Commissioner or the Provincial Commissioner in the Western Cape send a Lieutenant Colonel to investigate a general. It's totally against the SAPS policy. Now, the minute I discover this, I refuse to meet with this man. So I'm trying to get this house to understand that we are working with a bunch of scoundrels wearing 3 and 4 stars. But while I'm trying to explain this to the house, I'm getting hammered on dates. I'm asking the advocate to work with me, please. I'm also in a considerable amount of pain, so I'm not going to do a O'Sullivan, Honorable Nomvalo. I'm struggling with my shoulder, but we'll see this thing through tonight.
Honorable Sango.
Thank you, Chair. As much as I agree with what Honorable Souls was saying, that we should allow the witness to compensate with oral evidence, I think that is exactly what Advocate Mkhwanazi is trying to do. She's trying to get Honorable Adams to supplement what is missing in the affidavit with oral evidence. And I think it's quite unfortunate that Honorable Adams would want to characterize that as being hammered by dates, about dates. Yes, we want to know the chronology, and that is exactly what Advocate Mkhwanazi was asking. The chronology, which came before which. It doesn't mean this date and this date, but how did it unfold? So I'm really requesting that the witness tries to cooperate with the advocate as well. Thank you, Chair.
Chair, just for clarity, remember.
Wait for the chair to recognize. Okay. Do you want to be recognized?
Yes, Chair.
You are recognized.
Thank you, Chairperson. Just for clarity on Honorable Sangone's statement, when I raised my hand, the chair didn't see me, but it was not on the point of the clarity on dates, because of course that's very important. The chronological order of the dates is very important. When I raised my hand was when the advocate was asking Honorable Adams, why did he not say how many times he met the minister? You see, that must be in the statement. I met him 3 times and I met him like, that's not the requirement. So I'm saying in his oral statement, he can compensate and provide those details. That's the point, Chair, but not on the dates.
Chairperson, if I may. It is only in the very beginning where I struggle with the dates, Chairperson, because this is 2 years ago. I mean, it's 18 months ago. But the statement gets better in relation to dates because then I could turn to my cell phone, I could turn to my emails. Unfortunately, I had deleted some emails and I had lost the device that I was using at this time. But the statement does get better. So I do apologize to the committee for my, I'm going to say, tardiness with regards to dates here. But I can help out approximately, but I am under oath and I can't be lying about dates just to fill space. So that's exactly where I'm at.
Honorable Nhlanhla.
No, thanks, Chair. And I've also noticed in the statement of the witness that there is that missing part of the dates. And they are important, Chair, because the dates of when did the envelope with such information was found, when was the first case opened, and all those things. So I will implore that we say Honorable Adams must go back and recheck the exact dates and submit in writing on a later date. Thank you, Chair.
Okay.
May I proceed? Thank you, Chair. Honorable Adams, you went on to speak about the IG, and so maybe let's just deal with that a little bit more. You don't, once again, there's no date that indicates when you were contacted by the IG. Can you more or less tell the House around what time? Was this in the midst of all these charges that you lay in, the complaints that you made to the minister, and now IDEC? Where does the IG feature in all of this? Is it before, after IDEC? Where?
It was just after IDAC. Just after. I almost think it was round about the second, somewhere between the sixth, let's call it the 2nd, 3rd, 4th of October. But I can't say specifically it was that date, but I do know it was after I contacted the IDAC.
It can't be October because we know now in November.
Sorry. It's gonna be really hard for me to stick to that date because again, you're asking me to go back into memory events that happened 18 months ago. Man.
Can I ask you then, what you say in your statement that you were contacted by the Inspector General and he asked you about the cases that you've laid? We still don't know what the nature of these cases are, but you explain that he said that his department might have an interest in these cases. With the little information that you've given to the police, we don't know what you've given to IDEC. Or how does the IG learn about your cases? And secondly, what information did he have in relation to your cases that would tell you that I have an interest in this, or my department has an interest in this?
I actually wouldn't be able to tell you. He is the IG of intelligence. It's his job to know things. So I don't know how he knows about it. I don't know who told him. It could have been one of the policemen. It could have been someone who knew about the dockets that disappeared. I wouldn't be able to tell you that. But what I can confirm is that the IGI of intelligence called me and asked me if I would come to his office because his department might have an interest in this. I would not say no to that.
And his offices are in Joburg, sorry. This might be an obvious one, but I don't know. Is it in Joburg? So you traveled. Again, why are you not able to check your travel information to provide us with more certainty around these things?
Because I go to Joburg sometimes 3, 4, 5 times in a month. So even if I was to go back, I wouldn't be able to tell you which dates I went. There'd be 4 or 5 flights. It'd become a lottery. I wouldn't know when to tell you.
Honorable Sokanyile.
Sorry, Chairperson, I just want to check something. You went to Johannesburg or Pretoria?
Sorry, the IGI's office in Pretoria, not Johannesburg. Sorry, ma'am. For us Cape Townians, Joburg, Pretoria, same thing. So we actually believe Sunset is in Joburg as well.
So you met with the IG, and did he explain to you what his interest in the matter is?
The IGI didn't do any explaining. He asked me if I had any information. I said, yes, I have paperwork. He asked if we would hand it over. I said, yes. He told me that there were many things wrong in this country, and we as Parliament and the police and the JSCI needed to work with him because there were many things he wanted to clean. He introduced me to Advocate Govender. I hope I've got the name right because it's in my statement, and he left me with her. I gave her a statement, I handed the information over to her, and I came back to Cape Town.
So you handed him the classified information that you didn't want her the classified information that you did not want to give to the police.
I did not want to give to the police at the station.
Okay. Did you trust the IGI's intervention?
I was out of options at that stage, ma'am.
What did you expect from them? Were you asking them to also investigate your matter? Is that what they do?
The IGI is responsible for top-level investigations. I was comfortable handing them the information. And I was hoping that they would, in actual fact, do a thorough investigation and some type of outcome would come from it.
So you were essentially laying some sort of charge with the IGI in relation to...
Yes, ma'am. I am the complainant there.
Okay. Then I want to go back to your paragraph 13 that you referred to. You see, again, the IGI, we don't know when you met the IGI. It's sometime in November after all these charges have been laid and after IDEC. So I think I just want to you concede here that this is after all of the steps that you've taken. So when I say that you do not deal with why you were taking all of these steps, it's not explained in your, or that you've omitted the steps, it's not explained in your statement.
I'll concede to that for expediency. I will concede to that. But I would also like to say, it is so unnecessary to have these 1,000 witnesses here. We should have the IGI here. He's the one with the report. But the man's on suspension, just like the IGI before him, for investigating corruption. I think a message is being sent to the next IGI, investigate corruption and we'll suspend you. You don't need Fadil Adams here. And you didn't need Patricia Masha here. The IGI should have come here.
Okay, let's maybe go back to your evidence.
He's accountable to Parliament as well.
Honorable.
Thanks, Chair. I think let's split with the witness to avoid making statements that may bring us to something that is not at the core business of why we're here. Because it is not true, Chair, that the IGI was suspended for investigating corruption. I think a public statement was made by the presidency, and none of which suggests that the reasoning behind the suspension is on the basis of investigating corruption. So it is very important, Chair, that we don't congest and populate the record with incorrect remarks. Thank you, Chair.
Okay, can we focus on the terms of reference of why we are here?
Thank you, Chairperson.
Yeah.
Okay, so paragraph 13, Ms. Honorable Adams, of your statement, you say that you were called in that same week that you met with the IGI, and you were called by some person that General Mkhwanazi referenced in his testimony to this committee. And you said that this person wanted to meet with you, and he was claiming to be investigating the cases that you have laid. And you were deeply suspicious of his motives, and so you politely found an excuse not to meet him. Then you say, my suspicion was vindicated after some investigation. Remember, I had laid a criminal case, not a service delivery case. Are you suggesting that this person was somehow requested by the people whom you've laid charges against to get in contact with you?
100. I'm almost 100% sure. There's no other explanation in my mind, because if you were going to investigate a general, it should be a general investigating a general. That's the policy. I didn't write the policy. I might not even agree with the policy, but that is the policy. So the moment they let a lieutenant colonel loose to investigate generals, something was the matter, and I wasn't going to entertain that.
Just to be clear, you laid charges against General Khumalo, who is the Divisional Commissioner of Crime Intelligence. You laid charges against General Madondo and Major General Lushaba, who's the CFO of Crime Intelligence. And you're saying that those persons were responsible for the call you received, and you were suspicious about the call. What did you think was going to happen?
That there was going to be an investigation, an internal investigation, and if they were found not guilty, I'd look stupid, and if they were found guilty, they would appeal it because they had just been investigated by a subordinate. This was the way out. This is how I reasoned it. There was no other explanation for a lieutenant colonel investigating a general. Oh, and the lieutenant colonel's name is Phillips.
The one that General Mkhwanazi mentioned.
Yes, ma'am.
So General Phillips was sent by... Lieutenant Phillips was sent...
No, Lieutenant Colonel, sorry. I didn't get to finish. Lieutenant Colonel Phillips.
Lieutenant Colonel Phillips was sent by General Mkhwanazi and Khumalo to come after you.
I'm not saying General Mkhwanazi or Khumalo, I'm saying by someone in the cabal. Now, when I say the cabal, I'm speaking about one of many corrupt generals. If you're asking me to name a specific one, it's impossible. Let me put you in the picture, Advocate. Sorry, man. I'm just going to go off script a little bit. Do you know we have 200 police generals in this country? 200. We should have one national commissioner who is a full general, maybe 8 lieutenant generals, 16 major generals, 32 colonels, 64 brigadiers. That's structure. The SAPS as it is a jobs for pals. Everyone's a general. We're paying about R500 million a year to ineffectual generals. Many of them incompetent, many of them there without the proper vetting. No security clearance. And this is why policemen stay in their ranks as sergeants and warrant officers for 30 years, because there's no money to advance these people. So if you're asking me which member of the cabal sent Lieutenant Colonel Phillips, I can't tell you which one, but it's one of them.
Honorable Sangon.
Chairperson, you know, the problem that we're having really here with this witness is that this witness wants to address this house as if they are in the police portfolio committee. And as Honorable Nhlanhla was saying, we can't allow him to make false statements. There is one general in the South African Police Service, and he is General Fani Masemul. You then have lieutenant generals. You then have major generals. You can't be making a statement here, Honorable Adams, that there are 200 generals. You know it's not true. It's a colloquial way of referring to the different levels of the senior management service of the South African Police Force. So please, can we please ask the witness, Chair, to just deliver his testimony and please, please, please try. I know it's hard, but refrain from wanting to make political remarks. Thank you, Chair.
Honorable Chairperson, through you, there was nothing political about my statement.
I have not allowed you to.
Oh, sorry, Chairperson.
Yes. Do you want to speak?
Thank you, Chairperson. There was nothing political about my statement. What I stated was fact. We have 200 generals of various ranks, major generals, lieutenant generals, and one general. I said we should have one full general. Who is Fani Masimola? Who is the National Commissioner? I don't understand where the politics of it is. The fact of the matter is the SAPS is top heavy and the troops are suffering. Now, if there's anything political about that, then I'll withdraw it. But in my mind, there's nothing. And
Yeah,
this is the interaction
that is what the honorable member is saying, that because we are in parliamentary proceedings, let's be formal. That is what the honorable member is saying.
Oh, thank you, Chair. Point taken.
Thank you so much. You can proceed.
Just before we move on to the next.
And just to say to yourselves that the many interruptions that we have, I have already added an hour to the proceedings. If you have a night of 12 hours, you must know we are now going to experience the 13th hour.
Just before we move on to the next topic, Honorable Adams, we know that IDEC subsequently investigated your complaint, and that General Kumalo and General Shabandem were then subsequently arrested. But what came to light during the evidence that was given by Advocate Johnson was we could see that there was another docket opened, and it appears that the arrest of General Kumalo and General Shabandem were based on the strength of that docket that was opened in Brooklyn Police Station. Do you have an explanation as to why there was this separate docket opened? Because we know on record that you've opened 3 here, and then you went to Johannesburg, you opened others, and that's, I think, at Orlando Station. Where does Brooklyn Station feature in the midst of this?
I'm actually just thinking about it now. If you'll just grant me a few minutes, if we can keep going, it will come to me and I will respond. I'm just trying to just put it in the order of things. I don't want to hold up the proceedings by going ooh and ah. I know, I'm trying to think. Remember, it's 18 months ago. Just give me a minute, it'll come to me, but I'm asking for the sake of time if we can just move on, because the chair is going to add another hour to our night.
So you will come and give us an explanation?
No, I will give you an explanation.
And you do have an explanation, just so that it be
No, there's a very reasonable explanation. It just needs to come back to me.
Okay. And then the referral, the members have asked about the referral. You know, when you lodge a complaint with IDEC, there's a Section 27 referral that needs to happen. And we haven't seen that referral. Have you, when you asked IDEC to investigate the matter, how did you do it? What happened? What did you give them?
I gave them my referral letter.
A letter?
A letter. It was an affidavit, sorry, not a letter, an affidavit. It was commissioned. Somebody asked me to see it and I said, but I didn't make a duplicate. I just handed it over. It is with the IDAC. And if the IDAC was asked to produce it, they should be able to. So I'm not understanding why that was an issue, but yeah, I gave them an affidavit.
Okay. I think then we can move on to the next topic. And there it deals with what you call lies and manipulation that flowed unhindered at the Police Oversight Committee. Do you want to, before we go into your respective paragraphs, do you want to just explain why what you intend to deal with in there?
So, you know, when the police portfolio sat down to discuss the budget, I think it was Honorable Schikkeling, Honorable Kola Barnard, and I think it was Honorable Susana and myself who came out strongly and said, we are very disappointed at the intelligence budget. We wanted intelligence to receive more money. I think those were the members. I may be wrong. I even think Honorable James was also in agreement with us saying that intelligence should receive more money. So after what I found out about what was happening at intelligence, I wish I could withdraw my statement from the minutes. Because when it comes to the police portfolio, it is impossible to hold these generals to account. And I'll for the benefit of the committee, I will read out a few of those occasions. On the 5th of March, 2025, I inquired of National Commissioner Fani Masimola to explain the reasons General Khumalo was allowed to purchase a redundant cell phone grabber. Now, no response was given. The NASCOM was allowed to duck and dive the portfolio. However, Brigadier Tiani Shlongweni has articulated the reasons our tax monies were wasted. Yet it doesn't excuse what happened at the portfolio. Because when we come to portfolio, it's for accountability. So when I come there as a member of the police portfolio and say to the minister, hold on a second, you spent 40 million rand on a grabber that was never used. Never, because it was redundant. We are looking for answers. We're expecting answers. We don't get those. On the 12th of March, I inquired of the National Commissioner about the top-level security clearance of certain SAPS officials. Included in this was the issue of General Dumisani Khumalo's first clearance, which was alleged was fraudulent. In the Portfolio Committee meeting, the National Commissioner claimed that General Khumalo's clearance was above board. Again, Brigadier Tiani Shlongweni came to this portfolio and said that it was impossible that it could be legit because it was done in a matter of days. It normally takes about a year. So the National Commissioner lied to Parliament, but he faced no sanction. Please see attachment FAA1. It's the minutes of that portfolio. When I asked the Commissioner about the clearance of the National Commissioner and Lieutenant Khumalo during the portfolio meeting.
Can I just ask you there? So you haven't attached anything in relation to the allegations that you make in respect of the grabber that you consider redundant. You just say the Commissioner hasn't given you a response. And then are you asking this committee to rely on the evidence given by Mr. Shlongwane as your substantiation of these allegations that you make? Is that in support? Should we look at Mr. Shlongwane's evidence for support of these allegations that you make?
Given the fact that Mr. Shlongwane was the CFO of Crime Intelligence, I would say that his testimony must be regarded as reliable.
Can I ask you to articulate what did he say that we should look at when we consider whether or not that evidence or what he said
that the grabber was purchased to finance the NASREC conference.
Mm-hmm.
Now, that would make perfect sense because you pay top dollar for a grabber that is worthless if it is indeed the intention to finance a political conference. That is what the CFO, the former CFO of Crime Intelligence said. Now, I asked this question in portfolio. I was not given an answer. It makes me question, what is the purpose of the SAPS portfolio? If I may continue.
And before we also want to deal with paragraph 16, but just on that, so that's the only support for that allegation that you make?
Yes, ma'am. It's the only support I think I need.
It's Shlongwane's evidence.
Look, advocate, sorry, not look. Advocate, I'm coming to this portfolio as people are before me with what we have. This portfolio must make recommendations. Amongst others, in this case, maybe the portfolio should, I can't tell the portfolio what to do. Maybe the portfolio should take a closer look at the grabber. Maybe the portfolio should look at the true value of the grabber and what was paid for it. I can't tell this portfolio what to do. I can only tell this portfolio what I see wrong in SAPS. Remember, I wanted to be a member of this of the ad hoc. Remember, there was a concerted effort made to keep me out.
And in relation to the clearance of General Khumalo, what evidence do you have that he wasn't cleared, or that that his clearance wasn't above board?
The National Commissioner's come here and admitted that he had 2 clearances. He never told us why the first one wasn't good enough. He had to apply for a second one. The National Commissioner sat here and he said it. Also, again, Brigadier Nhlanhla, the CFO of Crime Intelligence, says there is no way a top secret clearance can be given in a week. He looked at the date that was applied and the date it was approved. He said it's impossible. This man knows what he's talking about. I'm just a layman. But please understand that upon obtaining the rank of brigadier and up, the oath of office goes something like this: subject to me attaining and maintaining top-level security clearance. These people are appointed without it, and they're allowed to operate without it for years.
Why should we accept Mr. Hlongwane's evidence above that of Lieutenant General Khumalo and above that of the National Commissioner? And is it simply because he was the CFO of Crime Intelligence? Is that the basis on which his evidence is more reliable than that of the National Commissioner and that of General Khumalo?
On the issue of the clearances, I think it is. Remember, the National Commissioner operated without top-level security clearance for 4 years. That is confirmed. Remember that General Khumalo would not have needed to apply for a second clearance if his first clearance was above board. So yes, in this case, I do believe that Hlongwane is the better candidate.
Okay, you may proceed.
On the 19th of February 2025, I asked the National Commissioner to supply to the Portfolio Committee the names of the police generals, including provincial heads lacking suitable security clearance. Despite assurance from the National Commissioner that this list would be supplied, it was never released. Please see attachment FAW2, which contains the minutes of the Portfolio Committee meeting. In the same meeting, February 19th, 2025, I asked the National Commissioner about the lack of media attention relating to case number 111-2024, which deals with an incident where over 100 million rands worth of mandrax was found and no media statement was ever given. The reply from General Labia was that the clandestine lab was under further investigation. The latest status of that same case mentions firearms. It doesn't speak of drugs anymore. Please see attachment FAA2, if I may be allowed to expand on that before we go any further. Mandrax, 90% of it is probably consumed here on these Cape Flats. It was a drug that was manufactured and brought to the Cape Flats by the nationalists. It was how they subdued our people. So when you tell me that 100, because most of the mandrax addicts are to be found on the Cape Flats. When you tell me that 100 million rand drug bust was effected in KZN, and it doesn't get reported to the media, and we're told that it's under further investigation, it's almost 2 years later, still no media statement. And a few weeks ago, one of our sources tells us that that case number no longer speaks about drugs, it now speaks about firearms, which makes me suspect that that 100 million rands worth of mandrax did find its way to the Cape Flats. These type of things we don't get answers on. This is the type of thing I take very personally.
So just to be clear, in respect of the content of paragraph 17, which also speaks to security clearance issue, there's no evidence again. The fact that you've requested a response from the National Commissioner does not confirm that you were right on your allegations. Do you agree with that?
There's no allegation in paragraph 17, Advocate. I'm asking of the National Commissioner to provide the police portfolio a list of the generals who do not have the suitable clearance. That's all I'm asking. Now, when the National Commissioner commits in portfolio to bring us the list and never does, That should be a question of concern. Remember, about an hour ago, you asked me why I omitted a certain email. Now, trust me, that's going to raise suspicion. Simple email. So when I asked our national commissioner, please bring us a list, including the 9 provincial commissioners, about who's not qualified to sit in that office, that list doesn't come. I'm allowed to be suspicious. And let me paint you a little picture. If you do not have a top-level security clearance, you are not allowed to see top-level classified documents. You're not allowed to. How can you be a provincial commissioner if you're not allowed to see top classified documentation? How can you dispense a budget if you're not allowed to see top-level classification? How do you give directive if you're not allowed to see top-level classified documents? How is this possible? Is it a wonder then that all 9 provinces are in trouble with crime? Because we have incompetent and unqualified people running the system. A general comes to this portfolio and says, I'm in possession of top secret documentation. Okay, fine. How does he know? Because we're not allowed to talk about it. Someone told him, but this committee didn't ask him that. But let's move. Sorry, my control issues are stepping in, sorry.
No, Mr. Adams, you are the witness.
No, I'm here to be led. I'm 100% here to be led tonight by a woman of all beautifulness. Welcome to the new South Africa. It's a beautiful thing.
In paragraph 18, Mr. Adams, you raise that, you mentioned that there's an incident where over 100 million rands worth of mandrax was found and no media statement was made. You also say that the reply was, when you asked about it, was that there was an investigation. My question here is, why would it be a problem if the police is reluctant to publish an incident where drugs were found if the reason is that they're busy investigating? Wouldn't it compromise investigations if they make things public?
In my view, and I'm not an investigator, I say it again, if we've just cracked the biggest mandrax hub in the country, I think the SAPS should receive some credit. I think it should make the papers. And when I ask, I think it was 4 months later, I'm told it's under investigation. And that is fine. And then again, we investigate and we are told, reliably told, and I'm asking this committee to look into this, that case number no longer mentions mandrax. The mandrax has been removed of the case. 100 million rands worth of buttons.
What are you trying to suggest?
I think those drugs were stolen.
By who?
By the South African Police Services.
And the National Commission is aware of it and he's condoning it.
Well, he is now. Let's see what he does.
Saying.
Look, if he didn't know, advocate, if he didn't know about it, he knows now. Let's see what he does about it.
Okay.
Let me assist you when SAPS talks about further investigation. Sindiso Magaka was killed 5 years ago. We're still told it's under investigation. So further investigation when it comes from those people means absolutely nothing to me.
Okay. You then proceed in paragraph 19 to raise an issue about a property that was purchased in Musgrave, KZN. And you say that crime intelligence purchased the property and they did it without a mandate. Is this the same property? Just before you answer, is this the same property that we heard from Mary De Haas, from Paul O'Sullivan, from Patricia Mashale, from Brown Mkhwanazi? Is this the same property that you now also raise?
I know of 2 properties, so I don't want to speak out of turn. It may be. There's another place called the Feroz Hotel, which they're probably going to shoot me for now because I don't know if it's classified, but it was unlawfully purchased. So crime intelligence has no mandate to purchase property unless Parliament approves it. When that property was purchased, I was a member of this House. I don't remember receiving that memo. They had no right to purchase that property. That is the sole responsibility of the Department of Public Works. That property was purchased using our tax money. And I'll tell this committee why. And Honorable Shongwe, my brother, Wilmy, I'm willing to bet my seat at this table in this house that that property is right now, as I sit here, housing the PKTT.
Again, Mr. Adams, I mean, we've heard that, and when Mr. Mkhwanazi came and gave his evidence and also spoke about property that was purchased by crime intelligence, he is not sitting on the police portfolio committee, but he was aware that he's not allowed to make classified or speak of classified information and to make it available. We literally had to redact portions of his statement. But here you are, sitting on the police portfolio committee, familiar with the confidentiality and how these documents should be handled.
Let me assist you with this, ma'am. Please allow me. Crime intelligence has purchased this building. We should assume that it's for the business of crime intelligence. The PKTT is not an arm of crime intelligence. It shouldn't even know where the building is. They're being housed in these hotels. And I am willing to bet that they are being invoiced, that we, the taxpayers, are being invoiced to house the PKTT. They needed a washing machine. This is their washing machine.
Do you have any proof of any of the allegations that you just made?
I've mentioned earlier. Chairperson is a hand. Honorable Nola wants to object.
Honorable Nhlanhla.
Thanks, Chair. I hear the witness calling a house a washing machine. I don't understand. Maybe if you can elaborate. Are the people staying here washing clothes? Is there clothes there, or there are washing machines there so that people do laundry? Maybe if you can elaborate. We don't understand. How does a house become a washing machine?
You already have a long day and a long night. The statement must just be withdrawn. It does not belong here.
Chairperson, if I may, Chairperson, I'm going to ask that I be treated like every person before me except Mary Das.
Yeah, let's not make it a
No,
point.
Chairperson, please allow me, please.
Let's not make it a point of debate.
No, Chairperson, this is not a debate. This is me appealing for my right to be treated like everyone else. People came to sit in this chair here and they were throwing mud left, right, and center. I'm suggesting that this ad hoc committee investigate what I'm saying. If you're asking me for evidence, I'm telling you, subpoena the records of that hotel. Subpoena the books. It was bought with our tax money. You are Parliament. You have the right to do it. And if you find out that the PKTT was housed there, arrest these people. And if they weren't, bring charges against me. That's how confident I am. Because I'm telling you now, this is money laundering. Can we continue, please, Advocate?
Okay,
Honorable Skosana.
Thank you, Chair. The witness is raising the issue, but I just wanted to find out quickly. You say the PKTT stay in that hotel, or in that house, or is washing machine?
Yes, Chief, in that washing machine.
I'm sorry?
I can confirm, yes, Chair.
No, what I'm asking is, are you saying, because you want clarity on that, is PKT members staying in that hotel or in that building, or is it the washing machines which are you concerned about?
They are in that hotel and they are running up a laundry bill of 500,000 rand a month while they're living in a hotel. You figure that out because I can't.
Yeah, but what I want to find out, is there anything wrong if they are staying in that hotel?
It's a crime intelligence building, sir. They shouldn't be there. The PKTT is not an arm of crime intelligence. They should not be there.
Yeah, but okay, that's a debate for our conversation.
I'm looking forward to that, Honorable Skosana.
Do you want to debate this, honorable members? I can give you time. I don't have a problem with having a long night. It's not sufficient to have a 12-hour day and a 12-hour night. I wish a day could be 14 to 15 hours. And so be the night. Honorable James, your hand is up.
Thank you, Chair. Honorable Adams, just help me understand here. I just need clarity. PKTT team, is that not made up of SAPS members who forms part of crime intelligence, who has formed a task team, now brought to Gauteng, operating as counterintelligence to assist with investigations into the drug syndicates and the likes of Mr. Kat Nhlanhla? Because remember, we were told that they were doing so well in KZN. They were brought to Gauteng. Some of the members were then opted into the counterintelligence and were sort of bringing down these criminal syndicates. So those members aren't necessarily from Gauteng. Could it not be that obviously they're staying there? The only problem I would then have is if they are actually staying in a building that's owned by the state crime intelligence and still sort of paying for accommodation. If you can just give me clarity on that.
Yes, thank you, Honorable James. So the PKTT was formed at the behest of the President, and their job is to investigate political killings. They are ordinary SAPS members who have been seconded to form the PKTT. As far as I know, they are not from crime intelligence. They may work with counterintelligence or even with crime intelligence, but they are not crime intelligence. Furthermore, they are staying at the hotel. I'm asking of Parliament, request those books. Let us see what is being charged for the PKTT to stay there. Because that hotel was bought without tax money. I tell you tonight, Honorable James, that if a member of the PKTT is to leave to join intelligence, he's no longer a member of the PKTT, and vice versa. The PKTT has one job, to investigate political killings. Now, let me explain to you how the PKTT does not investigate political killings. We have a Human Rights Commission report that claims that, that finds that Lieutenant General Dumisani Khumalo failed at his job, which gave rise to the KZN uprisings. 300 and odd people died. Those were politically motivated deaths. The PKTT does not sit with one of those dockets. Instead, it's chasing a drug dealer in Joburg. They don't have the mandate to do that. This is my problem. This should be our problem. And I'm not fighting anybody. I'm saying to you, no, we'll get to that later. Thank you.
Okay, should I proceed?
Osana, are you fine? Can we proceed?
Chair, I hope I will also get a little bit more time because I'm
Chair,
watching. Oh, okay.
How much more time do you still need, Advocate Mkhwanazi?
No, Chair, I will obviously try to finish as quickly as I could, but maybe an extra 10 to 15 minutes because by the rate we're going.
No. I have given you until 22:30.
Sorry, Chair?
I have given you until 22:30.
Oh, thank you, Chair. Then, Mr. Adams, just to move on, you're making a very, also what I consider a serious statement, given that you are serving on the Police Portfolio Committee. And you say, without giving any detail, in paragraph 20 of your statement, you say, what I can say without any reservation is that the Police Oversight Committee has failed in its mandate and failed the people of South Africa for obvious reasons.
I am a member of the Police Oversight Committee.
Why do you say that?
This is a self-criticism. We could have done better.
In what respect?
For a year, we have allowed General Masimola to sit in that committee, to lie to us, to refuse to answer. We have failed. And there are strong personalities on that committee, like me, like Honorable Skosana, like Honorable Kola Barnard. There's some real bulldogs there, but these people have gotten away with it anyway. I tell you, it's self-reflection. We have failed. Chairperson has a hand.
Honorable Skosana.
Thank you, Chair. I just want us to, I want to go back again, Chair, that it will be a sweeping statement to say General Masemula does not respond to our question. He does respond. I don't think it's correct for us to say that he comes to the committee, he doesn't want to answer. I don't think it's fair, honorable member. It would be really misleading because if you go to the Hansard, you'll find that when we ask questions, when we meet them, he might not give us satisfactory answers as perhaps you want, but it would be misleading to say he doesn't answer question, Chair. Just wanted us to be on the same wavelength. Otherwise, we'll be told that we have lied before the ad hoc committee. I don't think it's correct because it does answer questions. Thank you, Chair.
Taken, Honorable Member. Can we proceed?
Thank you, Chair. Then, Mr. Adams, I'd like to deal with your complaint that you said you made to the Inspector General. So you say in paragraph 21 that you've lodged a complaint on the 16th of May. Sorry, rather, on the 16th of May, you emailed the IG and you, as the complainant in the matter of cases that you've laid, I take it, is this cases that you've laid with the IG? Is it in the norm? Is this normal to go and lay charges with the IG? I think I've asked this before.
I actually don't know what's normal in the line or the way the IG works, ma'am. It was my first interaction with him. I'm referring to myself as the complainant because I had told the IG that these are my complaints and here's the paperwork that I think may back it up. So I'm referring to myself colloquially there.
Okay. So now on page 52, you have attached the email that you've sent to the IG, the 52 of the annexure bundle. Have it.
Thank you.
And you say there, dear IG, could you please tell me what is the status of your investigation into the investigation of the complaint laid against the police generals by Honorable Fadil Adams? Has the investigation been completed? So here we know now that you've asked the IG to conduct an investigation against is this General Kumalo and them?
General Kumalo, Madondo, and Lushaba.
Okay. And then in paragraph 21 of your statement, you say, the IG confirmed that he has completed his report in relation to the cases that I have opened against the Divisional Commission of Crime Intelligence, and it is now with the Minister. Please see email correspondence. There's a report that the IG has prepared, which is, I think it's considered classified. Does this report, the infamous report of the IG, the now suspended IG, does it deal with, is it on the strength of your complaint that he did the report?
If I read the media, thank you, Advocate. If I read the media reports and the information contained therein, then it does appear. But what you see in the media, you know what, the media is the media. I do believe it relates to the complaints that I made.
Okay, Honorable Matthys.
Thank you, Chair. Just some clarity on the annexure bundle, page 52, that the advocate referred to. This is not an email that was sent from Honorable Adams, or is it the wrong? It was sent from Honorable S. Frenchman.
Sorry, he uses that email address. If Honorable Matthys, if you could look at the other emails he sent to the Minister as well, it's the same address and it would be signed Honorable Adams, but this one was written Honorable Frenchman. But more importantly, he also says in his statement that it is his email.
If I may, just some clarity. I seem to have endless problems with this laptop, so it's in at IT for days at any given time. So in certain instances, if I need to send an urgent email, I will use my colleague's a laptop who sits right next in the office right next to me. So in this, and I think one or two other cases, I've said, can I just use your laptop and I'll just forward the email. Sorry, but it is my email, Honorable Matthys. She's very observant.
Honorable Matthys, are you satisfied?
Not really, Honorable Adams, but you even sign it off as Honorable S. Frenchman. And it even says there, it doesn't say, it says here the complaint laid against the police generals by Honorable Fidel Adams. So it doesn't say the complaint that I laid.
Yes, Honorable Matthys. Remember, the IGI doesn't know who Frenchman is. So I put my name in this, you can understand, so he can understand that it is relating to that. And also the signature at the bottom, it's the way her laptop is set up, that any email sent, that comes up at the bottom, and I didn't want to interfere with that, so I just sent it.
Okay, but you could have just deleted and signed it off.
Well,
It's
I'll
not
do that
right.
next time. Sorry about that.
Honorable Nhlanhla.
Thanks, Chair. I think Honorable Maltese covered part of what I wanted to follow up on. That was the recipient of the email then, which is the suspended IGI, aware that this is the complainant following up on his complaint? Because here it's written, as one of my Chase is saying, it's written as though that it's someone else who's following up on your behalf, and the details of the email actually are talking about someone else, not you.
May I, Chairperson? The IGI actually called to confirm and replied afterwards via email. I said to him, my laptop is in at IT. I'm not receiving emails. I'm not sending emails, and that was when he responded.
Are you fine, Honorable Member? Honorable Skwasana, I'll come to you, Honorable Sokhanyi.
Chair, a quick one. I think because I sit in that committee, it will be improper not to put things into a correct perspective. It should not be recorded as true that PKTT is just ordinary SAPS members, because it's a combination of officers specializing in various aspects of investigation. With Lieutenant General Khumalo, as you know, SAPS as a head of crime intelligence, and is a designated project leader of the PKTT. I think let's put that on record. It's not only, there's a lot of people in that PKTT who are specializing in the different aspects. Do you agree, Honorable Member?
No, I do not agree, Honorable Member, and I'll explain to you why. They are all SAPS members, whether they're investigative, whether they're forensics, whether they are all SAPS members, they're all operational team, besides the prosecutors. Furthermore, the head of intelligence can never be the head of a combat unit, because that's where the accountability gets lost. For instance, I can give you, if I'm the head of intelligence, I can give you this intelligence report and tell you, you need to do this.
Yeah.
There has to be objectivity for someone to say, hold on a second, this might not be correct.
No, what I'm saying, what I'm correcting you, in your statement, what you said now,